Trivedi, Judge, High Court of Gujarat. Kakraji, this side please. I would now like to request Shri Venkat Ramani ji to bring our sponsor Shri Ashok Bhai Zinjuwadia to the stage. I think we are just awaiting him in the room. Venkat Ramani ji is just joining us. You can in the meanwhile bring Shri Natwarlal Choksi on the stage. Shri Natwarlal Choksi. Okay, he's also just joining in. And may I also ask our other dignitaries on the dais just to, Shri H.R. Patel to also please join in.
So with these words, let me request the conference chairman, Mr. Samir Jani, to come forward for his welcome address.
Good morning all. Namaskar. I am very fortunate to have you all over here taking so much of pain, more particularly Justice Boyan, who in fact committed me at the Hyderabad seminar that yes, he will make it happen. I am so kind he has been so kind to me that I am obliged. Justice Karia, Justice Souvenir ji, Justice Pranav Trivedi, in fact, Justice, all this justice, when I say, I need to say Lordship, but they have been so kind to me and informal that I simply say justice only. They have been, no formalities are with them. I had been telling in the morning to Justice Karia that if the guest of honor and the chief guest are like you, I don't have any tension about it, entertaining them. And no formalities required. Justice Anil Ardave, Senior Advocate Shri Arvind Datarji, Senior Advocate Shri Kevin Gulati ji, Shri Saurabh Suparkar ji, Nikita, my past presidents, Shri P.C. Joshi, a fatherly figure, with whose blessings I am here today before you, Dr. K. Shivram, Nikita Ben, D.K. Gandhi ji, Dr. Ashok Sharaf in absentia. His mother is ill, so he is not able to join. All my dignified past presidents, Premlata, Madam and all, I am obliged for your august presence. My title sponsors, one of them is medically ill, so would not be able to come, and the other is to join shortly. He is coming from Rajkot. In fact, let me bring it to the notice that no advertisements in Souvenir or banners or standees, nothing like that. It is these two sponsors who has taken the entire responsibility. Organizing something in Junagadh was difficult in the sense that the guests and the dear delegate members had to travel a lot. But then, with the good wishes of, or the blessings of Almighty and my elderlies, I could make it happen. I thank all the delegates from the entire part of India, especially Gujarat. Gujarat, we have covered, sir, the entire part of it. From outside Gujarat, there are 29 states where we represent and 3 union territories. All of them have been kind enough to me by making their presence felt over here. Thank you, all of you. I am grateful to my AIFTPs. My would mean, wherever I say my, it is implied it's my AIFTP. Because I treat it as a family. I am sincerely grateful to the Collegium Advisory Board of AIFTP. So I am the first nation from Gujarat in this AIFTP history. In the 49th year, I represent Gujarat. And this is only because considering my dedication and services for the federation. For reaching to this position, you could find that we have a galaxy of faculties. Oh, sorry, I forgot my deputy president. He got elected yesterday. S. Venkatramani, who is the deputy president now. Both of us concluded that he has 2 years term. I have 2 years term. In fact, technically we have 1 year term. But both of us together will make it a 2-year term. I'm thankful to him also. I was on the faculties. If you could see, I am blessed by God to have such faculties with me, sir. In fact, 2 days earlier, Senior Advocate Arvind Tatarji was telling me that I have some work and can I postpone? Sir, if you are not there, Amitabh के बगैर picture कैसा लगेगा? So he said, I'll fly by chartered flight to Keshur. Incidentally, Keshur's flight was putting him at Keshur by 11, and he was, see, the punctuality, the particularness of a person. He was to reach here by 11:30, so he decided that I will travel from 7 o'clock in the morning till 11 o'clock in the night, but I will come a day earlier. He deferred his meeting. Justice Anil Ardave is the nodal agency to bring Arvind Datar sir over here. I am grateful to him. Sir, coming down, it is Suparkar sir. He has usually relayed the stick to his son Mandish, but then he often says to me, हम गुजराती में कहते हैं कि किसी ऐसे चौगड़िया मुहूर्त में आप मेरे पास आ जाते हो और मुझसे कमिटमेंट लेके चले जाते हो, but then he has been kind. जाते हैं फिर भी वो फंसते हैं. I am thankful to him. I am thankful to Mukesh Bhai Patel, Dr. Girish Ahuja, Kevin Gulati sir, who also traveled way from Delhi to here. Well, all these faculties are here. But you know, Datar sir was asking me, कितने होंगे? 100 लोग हो जाएंगे। अरे मैंने कहा 100 लोगों में मैं आपको बुलाऊंगा ही नहीं. It has to be more than 500. Otherwise, I would never ask Mr. Datar to come over here. So I'm thankful, more particularly, all the delegates. I had, perhaps, I don't know, edit me if I'm wrong, perhaps, Bhuyan Sahib, it is the first NEC, and convention, where before the early bird discount date, we had to close the registration. We closed it by 30th of September. And still, I have to accommodate few of them. In case, if anybody is finding problem in sitting, my regrets. The accommodation part, if anybody has any discomfort, my regrets. The better half of these faculties have also been here, Madam Datar, Madam Meenaben. I call her Meenaben only because I can't say His Lordship's counterpart or something like that, sir. They have been kind enough to me. Well, since I am the 49th president and will be celebrating the 50th Golden Jubilee year the next year, प्री-वेडिंग ईयर मानता हूं मैं इसको. तो शादी से पहले संगीत होती है, मेहंदी होती है, तो आप लोग सब मेहंदी संगीत वगैरह में आए हैं. बारात अगले साल वेंकटरमणी जी लीड करके ले आएंगे. And together, all of us will make it happen. With you together, only we will be able to make it happen. Being a president for the 49th year, I don't promise some magics to you, but I definitely can make a commitment to make 2-3 landmark decisions to be known for years in AIFTP. Likewise, the instance for such a thing only, we are proposing for the first time in the history of AIFTP a youth empowerment committee. We will be grooming the youth for future leadership of AIFTP, and I have Mr. Sanjay Dhariwal over here. Oh, he would be coming. Sanjay Dhariwal, I have. Yeah, okay, he's there. Sir, he is from Bangalore, and he has been taking care of youth empowerment in Jainism. And I'm assigning this assignment to him. He, along with his committee and members, would be developing a new young generation in AIFTP. That is one part. Yesterday, who had all joined for the dinner are aware about that my wife and me are rendering service to the society in the form of running an orphanage, destitute home, PTC college, everything. This year I have decided that बहुत पैसा कमा लिया प्रोफेशन से, अब देना है, तो क्या करेंगे? तो हम जो वहाँ डेडिकेशन से सर्विस करते हैं, me and my wife Ketki, both services, CSR or rather Social Responsibilities Committee, which Mr. Gandhi had started, will be continuing or rather initiating once again for this year, and will show you remarkable activities in that with each state's individual support to me. Without you, I'm nobody. See, and I humbly say that I am a member like you. 1 year earlier, I was sitting with the same areas where you have been sitting. Maybe next year I would be sitting in the first or a second row. But then I am to get down. That is what I always would remember. I don't have personal egos, but I would definitely like that the president's designation or the chair gets due respect, and he dedicates himself for at least for 1 year to this organization and this delegate members. Friends, I am thankful to Uchit Bhai, Mukesh Bhai, and I don't know, Nain Bhai is here? Oh, he is a very senior person, sir. One of the pioneers of sales tax VAT. He has retired from profession, I can say. Regrets Nain Bhai, but he does not appear much before the courts. He has assigned this job to Uchit, his son. But he was also kind enough to accept my invitation and come down over here. My friends, if I have to thank 500 times. I don't want to do that. You are all my family, and if I thank you all in general, I think you are part of me. Thanking myself is like thanking you, but always be with me, stay beside me for 1 year. I assure you, I will do my best for the betterment of this organization, because the respect which this organization has given me is huge, My identity is my federation. Thank you, friends. Thank you so much.
Thank you, Samir Bhai. I'm sure with your projected plans, youth would surely come forward, and there would be an energetic year ahead. I would request Ashok Bhai Jinjuwadia, who is sitting over there. Please, Ashok Bhai, please come on the stage, sir. He is our sponsor from Radhika Jewelers, Rajkot. We welcome you, Ashok Bhai. I would request the dignitaries to please come forward for lighting up of lamp.
I would now like to request certain people to please come on the stage for the floral welcome of our dignitaries. In the interest of time, may I please request, as soon as I call out the name, if you can please come up to the stage and give the bouquet to our dignitaries. First, I would like to invite Shri N.P. Jain to come on the stage and give a bouquet to Honorable Justice Ujjal Bhuyan, Judge, Supreme Court of India. Shri N.P. Jain is the President of All India Federation of Tax Practitioners. And please, if we can have the round of applauses going on as the dignitaries are given the floral welcome. I would now like to ask Shri H.R. Patel to come forward and give a bouquet to Honorable Justice Soumitra Saikia ji, Judge of Guwahati High Court. Shri H.R. Patel. I would now like to ask S. Venkatramani ji to please come forward from the stage and give a bouquet to Honorable Justice Shri B.D. Karia, Judge Gujarat High Court. As Samir Bhai was mentioning, Venkatramani ji is the Deputy President of the AIFTP, so congratulations to you, sir, as well. I would now like to ask S. Nanju Prasad to please come forward and give a floral welcome to Honorable Justice Pranav. Shri Sandeep Bhai Agarwal, if you can please come forward and give a floral welcome to Honorable Justice Pranav Bhai Trivedi, a Judge, Gujarat High Court. Hemang Bhai Shah, if you are there, if you could please come up and give a floral welcome to Shri Narayan Jain, the President of AIFTP. Jayendra Bhai Tanna, if you could please come forward and give a floral welcome to R.D. Kakra ji. Shri Rajni Kalaria, if you can please come on the stage and give a bouquet to Vinayak Patkar ji. I would now like to ask Manoj Dudhatra ji to please come forward and give a bouquet to S. Venkatramani ji. And Manoj, while you are there, in the interest of time, if you could also give a bouquet to Shri Shashank Mithiawala. Nahi hai? Okay. He's not here, sorry. If I can now ask Bhaskar Bhai Patel from Baroda to give a bouquet to Mr. Ashok Bhai Zijuwadia, our sponsor for the event. Shri Ashok Bhai. As Samir Bhai was saying, the success of any event always is based on who supports the event. So a big round of applause for our sponsors. Thank you so much, Ashok Bhai, for being so gracious. Uh, I would also like to now request a few people to give a floral welcome. Shri Ketki Ben Jani, if you could please come forward and give a bouquet to Mrs. Karia. Premlata Bansal ji, if you can please come forward and give a bouquet to Mrs. Trivedi. CA Jamuna Shukla, if you can please come forward and give a bouquet to Mrs. Dave. Okay. Anupama ji, if you can please also give a bouquet to Mrs. Dave. Premlata Bansal ji, if you could please give a bouquet to Mrs. Datar. And Seema Gupta ji, if you can please come forward and give a bouquet to Mrs. Hema Patel.
We have Honorable Dinesh Mohan Sinha sir over here. Okay, we move forward. We have completed our floral welcome. So now I would request Honorable Justice Soumitra Saikia ji for his welcome address. I would request our National President Narayan Jain sir for his welcome address.
Our Honorable Chief Guest, Honorable Mr. Justice Ujjwal Bhuyan Sahab, Honorable Mr. Justice V.D. Karia ji, Judge of Gujarat High Court, Honorable Mr. Justice Soumitra Saikia ji, Judge Guwahati High Court, Honorable Mr. Justice Pranav Trivedi ji, Judge Gujarat High Court, and we are happy that the former Supreme Court judge, and the time when he came to Hyderabad in one of our functions, that time he was also the Supreme Court judge, Honorable Justice Anil Dave. All our past presidents, I can see some of the honorable past presidents. There may be others, but I will just name whomsoever I can see. First, I can see Honorable Sri P.C. Joshi Sahab, the senior most past president. He has just completed 18 years of his age. 18 into 5, 90. We celebrated a few months back in Bombay. Then we have Shivaram Sahab, Dr. Shivaram, senior advocate. We have Premlata Ben, Nikita Ben, And on that side, I can find Sri D.K. Gandhi ji, my immediate past president, Pankaj Gheya ji, and any other past president, those who are available. Oh, M. Srinivasa Rao Sahab. ये तो जब भी his tactics was whenever he used to come in NEC meeting, he used to bring laddus from Tirupati and many times Soul also. So welcome, sir. And all my colleagues in the National Executive Committee, National Office Bearers, and Zone Chairman. We also welcome Sri fatherly figure Sri K.L. Goyal Sahab from Chandigarh, the senior advocate. Now his son is the Zone Chairman. So friends, would not like to take much of your time. The speaker's name already Samir Bhai has told. And earlier from West Zone we used to have the Deputy President or President generally from Bombay. But the Collegium in its wisdom, they decided that this time we will have a President from Gujarat. So who is the person you know? We can again clap for him so that Samir Bhai Jani also takes care of us, and he has brought us to a beautiful place. We can see, some of us can see from our rooms also, the hills, the greenery. Friends, I have a written speech, but I have cut it short because we want to listen to our honorable guests. Only the AIFTP is going to give 19 awards, but only few of them, 5 of them, as has been instructed by me, by the awards committee chairman, I will just name before you. And those who are present, kindly stand up for recognition. One is the AIFTP Best Conference Award. We are not giving the award now, but we are only announcing. Ujjain, Central Zone. Then we have got AIFTP Best Seminar Award. It will go one-day program that will go to Vadodara. Then Best Zone Chairman. Best Zone Chairman, Dr. Ramaraju Srinivasa Rao. He will also get, after lunch, he will also get the award for the West Zone. South Zone has been considered as the best zone for the year 2024. AIFTP Best Article Award for Journal will go to Aditya Gaonkar, and AIFTP Best Article in Souvenir will go to Mrs. Ruchi Rathod. Ruchi is here? Yeah, thank you. And there are many other awards which will be announced after the lunch program. We have one person that is called AIFTP Man of the Year Award, which is sponsored by Sri F.R. Singhvi. It will go to Sri V.P. Gupta of Delhi. His son is here, Anuj. So friends, I will not take more of your time. Time permitting, we will do all these awards. And also there are 24 Presidential Recognition Award. That also we will do at that time, because we are willing to first listen from our honorable guests. And as the outgoing president, I am grateful to all our 11,200 members of India. The family is growing. We could not accommodate more people here. Many more people wanted to come here, but we could not accommodate. But however, we will cover the detailed report with pictures in the AIFTP time so that everybody can see it. So once again, my gratitude and thanks to all of you. Thank you very much.
Thank you so much, Sri Narayan Jain sir, for your welcome address, National President AIFTP. I would now like to request our guest of honor, Honorable Justice Soumitra Saikia ji, guest of, he's the judge from Guwahati High Court. Sir, if you could please come forward and give your address. A big round of applause for Honorable Justice.
Honorable Mr. Justice Ujjal Bhuiya, Judge, Supreme Court of India. Honorable Mr. Justice B.D. Karia, Judge, Gujarat High Court. Honorable Mr. Justice Pranav Trivedi, Judge, Gujarat High Court. Respected spouses of Justice Bhuiya, Justice Karia, Justice Trivedi present. Justice Anil R. Dave, former Judge, Supreme Court of India. Sri N.P. Jain, the President of AIFTP. Sri Samir Jani, who is the National President-elect of the AIFTP. Sri Santosh Gupta, Secretary-elect of AIFTP. All past presidents and other office bearers of AIFTP who are present. The office bearers of Gir Somnath Tax Bar Association, who is one of the hosts, as I can see, of today's conference. Learned advocates, chartered accountants, tax practitioners coming from different parts of the country present today. Ladies and gentlemen, namaskar and a very good morning to all of you. I stand before you today with a great pride and gratitude, as well as a great deal of humility to have been invited here to be a part of this conference as a guest of honor by the All India Federation of Tax Practitioners. This gathering which I can see today is a testament to the critical role that the tax practitioners play in shaping our nation's fiscal landscape and ensuring economic prosperity. The All India Federation of Tax Practitioners, in short, AIFTP, was formed on 11th November 1976 with Sri N.C. Mehta as its first president of the apex body, which comprises of tax practitioners from all over the country, accountants and advocates. And since its inception, the Federation has established itself as a cornerstone of the tax practitioners community. It has become an indispensable platform for all tax professionals across India, representing their interests, promoting their awareness about taxation laws, fostering a culture of professionalism and ethics. Since its inception, the Federation has continued to contribute immensely towards imparting and disseminating knowledge in the realm of taxation, both direct and indirect. I was informed that the Federation has close to 10,500 members, and I stand corrected by Mr. Jain now that it has got 11,200 members. I think that's a phenomenal number of membership for any organization across the country. And these memberships, as I've said, comprises of leading advocates, senior advocates, chartered accountants, tax practitioners coming from across the world. I may be permitted to say that this federation is nothing short of being a melting pot for all the tax brains of the country. The AIFTP publishes a monthly journal covering of latest reported, unreported decisions of the Supreme Court and High Courts, income tax appellate tribunals, other tax tribunals, articles, questions and answers, opinions. I am doubly honored and privileged today to be present here for two reasons. That while I was in the bar, I was also a life member of this coveted federation. By the courtesy of the leaders of tax practitioners and the blessings of the leadership of the AIFTP as at the relevant point in time. Today's conference and convention, I think, is the right occasion and opportunity to introspect, discuss, deliberate on the nuances and intricacies in the realm of taxation. the changes in the laws, the use of technology, the way forward towards having a robust yet a balanced taxation system in our country. The tax system is the backbone of any economy, providing essential revenue for development, infrastructure, and public welfare. As tax practitioners, you are not just interpreters of law, but you are the custodian of the economics of justice, ensuring compliance, fairness, and within the framework of a diverse and complex taxation system. The word tax, I understand, is derived from the word taxare, which means to assess the worth of something. Taxes are imposed by the government for the use and service of the state. They are levied and collected by the state for the purchase or sale of merchandise or services. Taxes provides revenues to the state and is therefore one of the most significant aspects of any system of administration in any form of government. The strength of economy depends on how good a tax system is. A just tax system can propel economic growth of the country and lead its prosperity, which in turn makes its citizens contented and more productive. Effective taxation policy leads to the growth in the GDP of the country. It is considered sound if it performs distributional and stabilization mechanisms for removal of the intricacies in the taxation system in the economy. In India, a formal tax system was in existence since the time of the Maurya dynasty. The higher class of the citizens at that relevant point in time contributed 1/6 of their income as tax. It is said that even before the Mauryas, tax was found to be extensively mentioned in our Manusmriti. Subsequent Mughal invaders brought with them their own taxation system. Jizya, which was introduced during the Mughal era, was a very infamous taxation system, which subsequently was abolished by Emperor Akbar. India today has currently 3-tier taxation system. Besides the central government, the state government who can impose tax. The state government in turn can also delegate taxation to certain local bodies like the municipal corporations, other government corporations. Besides the complexities of taxes, it is one of the reasons why there is a huge demand in India for erudite taxation consultants, auditors, and other professionals. A national convention of this magnitude, having participants from all over the country to exchange their views and ideas, I am certain will be most beneficial to all the participants, both present physically and online. As our nation evolves, it undergoes various changes in India. No doubt, as the nation progresses, the tax structure will also undergo many refinements. For example, as you all know, earlier there was the sales tax, then the VAT, now we have the GST. And every passing day, there are a lot of judgments and rulings coming from Supreme Court, as well as different high courts, as well as appellate tribunals, trying to give better and more comprehensive interpretation of the complex system of taxation. Judiciary has been constantly in the forefront of giving interpretation as and when the occasion arises. With the permission of Justice Bhuya, as well as the learned senior counsels available present today, just to give us short references of some of the famous cases. The K.P. Varghese case in 1981 by the Supreme Court addressed the interpretation of Section 52 of the Income Tax Act, then followed by McDowell's and Company, where a critical distinction was established between tax planning and tax evasion. Then comes the Vodafone International Holdings, where indirect transfers of Indian assets cannot be taxed without explicit legislative provisions, which subsequently led to the amendment of the Income Tax Act. Now, the tax practitioners, being a part of this complex taxation system, has a major role in the nation building. The tax practitioners can render proper counseling and advice with regard to the regulatories, the rules, the sections, in respect of the various stakeholders who are required to wade through the complexities of the taxation system. The taxpayers, on the other end, who bear the brunt of the taxes, are required to be guided properly by the insights and the erudite understanding of the taxation system. As I've said, taxation is perhaps the only certain process of generating revenue for the government. So therefore, the proper suggestions, discussions, interpretations of the relevant sections will lead to forming better policies in the field of both direct and indirect taxation. The taxation landscape is evolving rapidly, driven by globalization, digitalization, economic transformation. So today, I think one of the important aspects is to adopt, accept and implement technology in use of an understanding of taxation. And I think the association of professionals like the Federation plays a major role in disseminating the information and exploring the ways and means to adopt technology. The world is becoming smaller and smaller, so therefore cross-border transactions, international taxations, the complexities involved demand continuous upscaling and upgrading of the taxation practices and the knowledges. These conferences harness a lot of talent and permits exchange of ideas in these complex taxation frames. While the challenges are significant, one must remember that they open doors to unparalleled opportunities. There's a continuous effort on the government of the day on improving the ease of doing business, simplifying tax laws. There's an ongoing emphasis on the digitalization of tax administration is one of the opportunities to innovate and redefine their service delivery models. One of the most common example is the faceless assessments which are being carried on in the income tax department, which was earlier there, which created problem, and we as judges of the High Court were confronted with lots of writ petitions on the ground of bias and unfair practice. So, but today there are other issues which needs to be ironed out, even in faceless assessments. I encourage this esteemed gathering to take a proactive stance today in addressing the contemporary issues and envisioning the future of taxation in India. My suggestion would be to consider on capacity building through continuous learning and exchange programs as is being conducted in these conferences, collaborating with the policymakers to advocate the reforms that reflect the needs of all the stakeholders, leveraging technology to enhance efficiency, accuracy, and compliance. As we look ahead, the AIFTP under the new leadership, I'm sure, will continue to lead the way by fostering innovation, inclusivity, and excellence in tax practice. In closing, I express my deepest admiration and the dedication and expertise of the members of the Federation. Your efforts do not only have a profound impact on the individual beneficiaries, but also on the entire economic fabric of our nation. I urge all members present, both physically and in offline mode, to build a tax ecosystem that is transparent, equitable, aligned with India's aspirations for growth and sustainability. I once again thank you all for this honor. I wish this convention's immense success. May it serve as a beacon of progress and collaboration for all tax practitioners across the nation. Namaskar, Jai Hind, Jai Bharat.
Thank you so much, sir. May I now invite Honorable Justice B.D. Karia, Honorable Judge of the Gujarat High Court, to please come and give his welcome address. Honorable Justice Karia.
Very good morning to all. Honorable Mr. Justice Ujjwal Bhuiyan, Judge, Supreme Court of India. Honorable Mr. Justice Soumitra Saikia, Judge, Guwahati High Court. Honorable Mr. Justice Pranav Trivedi, Judge, Gujarat High Court. Honorable Mr. Justice Anil R. Dave, former Judge, Supreme Court of India. Senior Advocates, Shri Arvind Datar, Shri Saurabh Suparkar, Shri Gulati, Mr. Mukesh Patel, and other learned speakers in the conference. Shri Narayan P. Jain, President of All India Federation of Tax Practitioners 2024. Shri Samir Jani, Deputy President and President of the Federation for the year 2025. Immediate past Presidents, Secretary General, Treasurers and other office bearers of the Federation, office bearers of the Tax Advisors Association Junagadh and Gir Somnath Tax Bar Association Veraval, ladies and gentlemen. I feel privileged to be part of this convention of 27th National Convention of All India Federation of Tax Practitioners 2024 on the theme of Epitome of Excellence, organized by these three federations. I am indeed grateful to the Federation and more particularly Sri Samir Bhai Jani and other office bearers to provide this opportunity to share few thoughts and invite me to this august gathering. Our father of nation, Gandhiji, once said, "Path needs the goal." He never compromised in his path to attain the goal. Getting inspiration from his thoughts and actions, role of Federation for last 48 years to spread the education in the matters relating to the tax laws, other laws and accountancy by conducting seminars and educating the tax practitioners across the country with the latest development in the tax laws and other laws is a great initiative and achievement. The theme of the convention, Epitome of Excellence, is aptly chosen in light of the objective of the Federation. The topics chosen for the different sessions for these 2 days convention on direct taxes and indirect taxes, followed by Brand Trust session to be conducted by legal luminaries, would not only enhance the knowledge of more than 500 participants gathered from the different parts of the country in this historic and spiritual city of Junagadh at foothills of Girnar. But convention would also help in long run while actually dealing with the issues being deliberated in their respective fields. The Federation being the apex body or non-statutory body, the only pan-India organization for the tax advocates, chartered accountants, cost accountants, company secretaries and tax practitioners alike, providing a single platform to all those who are connected with the compliance of complex tax laws, commenced in the year 1976 with the blessings of Honorable Mr. Justice J.C. Shah, Chief Justice of India, and Mr. Palkhiwala, legal luminary in the field, which has contributed for more than 48 years and having more than 11,000 members, show the path to exchange knowledge, share experience and address the evolving challenge in the realm of taxation. I compliment the team under the able leadership of Sri Samir Jani to select the topics of this convention, fulfilling the team Epitome of Excellence. We are fortunate to have among us the legal luminary and senior advocate Sri Arvind Datar, to deliberate upon the current controversial tax issues, which would definitely be enlightening all of us to deal with such issues. In Income Tax Act 1961, attempt has always been made by the legislature to provide separate mechanism for assessment in such cases, and from time to time, the legislature introduced various schemes to settle the disputes and reduce the litigation. Earlier, the block assessment for 10 years was introduced for such cases under Chapter 14B, containing the sections 158B to 158BH, which provides for special procedure for assessment of such cases by the finance, and which was introduced by the Finance Act 1995, which was later on replaced by the provision of Section 153A, 153B, and 153C inserted by Finance Act 2003, with effect from 1/3/2003 under Chapter 14 up to 31/3/21. With effect from 1/4/21 till September 2024, assessment of such cases was to be continued under Section 147 read with Section 148, which are regular provisions of the assessment, only with a rider that conducting inquiry providing opportunity as contemplated under Section 148A was not to be applied, along with other procedural requirements as provided under Section 148 of the Act. Now, by Finance Number 2 Act 2024, with effect from 1st September 24, Chapter 14B, consisting of Section 158B to 158BI, has been substituted, providing for special procedure for assessment for such cases. Thus, the legislature has again gone back to the block assessment era by substitution of the provisions under Chapter 14B of the Act. The session of comparison between new and old block assessment scheme would definitely be in the interest of all to deal with such cases. Recently, the controversy has also arisen regarding issuance of notice under Section 148 for reopening by the jurisdictional assessing officer instead of National Faceless Assessment Center. The Honorable Bombay High Court, in case of Exaware, all you know, that has caused set aside such notices being without jurisdiction. The matter is pending before the Honorable Supreme Court. The issue has arisen pursuant to the scheme formulated by the central government under Section 151 capital A of the Act for faceless assessment of income escaping assessment on 29th March 2022 with effect from 1st April 2022. As the matter is sub judice before the Honorable Court on the issue, such matters are also kept pending by the High Courts. Another issue which has cropped up pursuant to the amendment by the Finance Act Number 2 Act 2024 is change in the provision of the capital gains. Therefore, comparison between the new and the old scheme of capital gains and pros and cons of the new scheme vis-a-vis the old scheme would also help everyone to plan their affairs in the accordance with law. Recently, the Honorable Supreme Court has put in quietus to the issue of the exercise of powers under Article 142 in case of Ashish Agrawal, in the case of Rajiv Bansal. All you know is that the Supreme Court, by interpreting the provisions of section, how the effect of Article 142 has stated that the TOLA, which was in operation from 1st April 2021 to 30th June 2021, was to be applied, and for that purpose, how the period of limitation is to be counted, which will have to be calculated for in the facts of each case as it appears now. Similarly, with the advent of Goods and Service Tax Act subsuming all indirect tax laws, the concept of one nation, one tax for levy of indirect taxes has been implemented. However, even after 6 years, the teething trouble still subsists, like issue of refund of the input tax credit to be availed by the SSC under GST Act, more particularly under Section 16(4), paid with Section 73, and effect of insertion of subsection 5 and 6 with effect from the Finance Number 2 Act, which would definitely give relief to the taxpayers for the past years for who have filed late returns for the financial year 2017-18 to 2021. Now, and with introduction of Section 128 capital A for waiver of interest and penalty, both relating to the demand raised under Section 73 for the period from 1/7/77 to 31/3/2020 is also under contemplation, but the date is not yet announced, as you know. The Honorable Supreme Court also recently has pronounced judgment on Section 17(5)(d) of the GST Act regarding the ITC on building construction meant for lease to be treated as plant. So that has also put an end to a lot of litigation which has been pending under Section 75D, as you know. And with regard to also another landmark decision, in last 2 months, so many decisions have come which have reduced the litigation across the country, which would reduce rather, with regard to such issues which are pending for more than 2 to 4 years. Even for issue on decision on the royalty, right of levy of royalty by the states, has also has direct impact on the GST payable on such royalty on reverse charge mechanism, and deliberation on such recent decision shall definitely will help to deal with such issues. There is also a challenge to virus of Section 16(2)(c) of the GST Act, which is pending before the courts, as input tax credit is denied on the ground that the seller may not have deposited the tax. Then the purchaser would not be allowed to carry forward such tax or to avail the benefit of such input tax credit. Subsection 2 of Section 16 starts with a non-obstante clause that notwithstanding anything contained in this section, no registered person shall be entitled to the credit of any input tax in respect of any supply of goods or services or both to him unless he, as per clause C of the said subsection, subject to the provisions of Section 41, the tax charged in respect of such supply has been actually paid to the government in respect of the said supply. The revenue in such cases makes addition in the hands of the purchaser, even though he has already paid the tax as per the invoice to the supplier. Therefore, a robust system for reconciliation is required to be implemented, which I think it is in process, so as to reduce the litigation on this aspect. It is also agitated before the courts that merely because the seller does not deposit the GST, the purchaser, why the purchaser can be saddled with the liability for the same, as it would amount to double taxation so far as the purchaser is concerned. Here, another important decision which has come recently in case of Canon India, where the DRI has issued the notices which were challenged to be held to be without jurisdiction. The Honorable Supreme Court has allowed the review by holding that such notices issued by the DRI would be considered as notices issued by a proper officer under the Customs Act. And that has also reduced a lot of litigation in the days to come. This is therefore, in my humble opinion, this is a perfect platform where legal minds with experts in the field brood thoughts, foment and new ideas emerges. This is a place where all would strive to achieve epitome of excellence. I once again feel privileged to be part of this convention. My special appreciation to the efforts put by Sri Samir Jani and his team, tirelessly working for last more than 6 months for this national convention at Junagadh with its rich heritage and natural beauty, providing perfect backdrop at the foothills of Girnar mountain. Thanking you all, wishing this function a great success, having a great day. Thank you.
Thank you so much, Honorable Justice Karia. May I now invite Honorable Justice Pranav Trivedi, Judge Gujarat High Court, to please come on the stage and give his words, please.
Honorable Mr. Justice Ujjwal Bhuyan, Judge, Supreme Court of India. Honorable Mr. Justice Bhargav Karia, Judge, Gujarat High Court. Honorable Mr. Justice Soumitra Saikia, Judge, Guwahati High Court. Respected spouses of Justice Bhuyan and Justice Karia. Honorable Mr. Justice Anil Ardave, former Judge, Supreme Court of India. Shri Narayan P. Jain, President of All India Federation of Tax Practitioners, 2024. Shri Samir Jani, Deputy President and President-elect of the Federation for the year 2025. Senior Advocate Shri Arvind Datar, Shri Saurabh Soparkar, Shri Gulati, Mr. Mukesh Patel, distinguished speakers in the conference, learned advocates, chartered accountants, tax practitioners, past presidents of AIFTP, office bearers of the federations, dignitaries on the dais and off the dais. Ladies and gentlemen, namaste, a very good morning to all of you. It is indeed an honor and privilege to be part of this occasion organized by All India Federation of Tax Practitioners here in the city of Junagadh. This event serves as a testament to the dedication of AIFTP in bringing together leaders, thinkers, and change makers in the field of taxation and fiscal governance. Over the years, AIFTP has emerged as a powerful voice and indispensable partner in shaping India's tax landscape. Its efforts to simplify process, enhance compliance, and ensure equitable policies are commendable. By fostering dialogue between taxpayers, administrators, and policymakers, AIFTP has set the stage for sustainable economic growth and trust building within the taxation ecosystem. The theme of this year's 27th National Convention, Epitome of Excellence, is both inspiring and thought-provoking. Excellence as a pursuit transcends professions, sectors, and boundaries. It represents a commitment to not just achieve success, but doing so with integrity, diligence, and a relentless drive for improvement. From a judicial perspective, the pursuit of excellence is deeply embedded in the principles of justice. It demands fairness in application, clarity in interpretation, and consistency in enforcement. These principles are equally vital in the domain of taxation, where the law must serve as a guidepost for governance, business, and individual compliance. I am confident that the deliberations, discussions, and insights shared during this convention will inspire all participants to embody the value of excellence in their respective roles. As a member of the judiciary, I am particularly aware of the pivotal role courts play in interpreting tax laws and ensuring that justice is served fairly and impartially. The judiciary stands as a guardian to right of both taxpayers and revenue, ensuring that the principles of natural justice, law, and equity are upheld. It is heartening to see that forums like AIFTP complement these efforts by promoting awareness, education, and constructive dialogue on tax-related issues. Before concluding, I extend my heartfelt congratulations to AIFTP for organizing the well-structured event. It is not an easy task to bring together such a diverse group of experts, policymakers, and professionals. The success of today's program is a testament of the dedication, vision, and meticulous efforts of the organizing team. I would also like to extend my warmest congratulations to the Deputy President, who has now been entrusted with the role of President for the year 2025. May your tenure be filled with accomplishments that benefit not only this association, but also the broader community it serves. I applaud each member of the team who worked tirelessly behind the scenes to make this program a reality. The efforts have not only set the stage for a meaningful discussion, but also strengthened the foundation for future progress. May the outcome of today's deliberation lead to a lasting contribution to our nation's growth and governance. I wish this event a great success. Thank you. Jai Hind, Jai Guru.
Thank you, sir, for your great word of wisdom. Now, the time has come for what we are waiting for. I would request Shri Samir Bhai Jani, President-elect, to take his oath and come forward as the President of this August Association in presence of the Chief Guest, Shri Ujjwal Bhuyan ji.
I thought my turn has come to speak, but first I have to administer the oath. I,
Samir Sharad Jani,
having been elected as President of All India Federation of Tax Practitioners,
having been elected as President of All India Federation of Tax Practitioners,
do swear in the name of God that I shall perform my duties as the President of the Federation
that I shall perform my duties as a President of Federation
to the best of my knowledge, ability and judgment.
To the best of my ability, knowledge and judgment.
I shall act in accordance with the Constitution, rules, regulations and guidelines of the Federation.
I shall act in accordance with the Constitution, rules, regulations and guidelines of the Federation.
And that I shall perform my duties
as the President
without any fear,
without any fear,
favor or affection,
favor or affection,
and I shall not cause prejudice
and I shall not cause any prejudice
to any of the members of the Federation.
to any of the members of the Federation.
I further undertake
I further undertake
to strive my best
to strive my best
to impress upon the members scrupulously to follow and abide by the standards of professional conduct and etiquette
by the standards of the professional conduct and etiquette
of the Federation,
of the Federation,
and that
and that
I shall endeavor to the best of my ability
I shall endeavor to the best of my ability
and capability
and capability
for the progress and development of the Federation.
for the progress and development of the Federation. Thank you.
Congratulations.
Thank you so much. Thank you.
The next in the line is the release of e-souvenir of the conference. I would request the conference committee to please unveil the e-souvenir on the screen. Please, would request to please hand over the e-souvenir to the dignitaries on the dais. Copy, yeah, please give the copies of the souvenir.
On this occasion, we are also having the release of the publication New Reassessment Regime, Law, Procedure and Practical Guide. The said publication is edited by Dr. K. Shivram, Senior Advocate, Bombay High Court, and Shri Tushar Hemani, Senior Advocate, Gujarat High Court, and it is authored by Mr. Shashi Bekal, Advocate. The publication is dedicated to the fond memory of late Dr. Justice B.P. Saraf, former Chief Justice of the Jammu and Kashmir High Court. The publication is under the able chairperson Srimati Nikita Badheka, past National President of AIFTP. We sincerely acknowledge the support of past President Dr. Ashok Saraf, Senior Advocate, for this publication. In this publication, one will find very encouraging messages from Honorable Justice Rajesh Bindal, Judge Supreme Court, Honorable Justice Ujjal Bhuyan, Judge Supreme Court, and today's chief guest. Honorable Mr. Justice K.R. Sriram, Chief Justice of Madras High Court, and many others. We are sure the publication will be very useful to the members of the Federation. may I request Chief Guest, Honorable Justice Bhuyan, to hand over a copy of this publication to the author, Advocate Shashi Bekal, if you can please come up on the stage, and one copy to Chairperson Mrs. Nikita Badheka, my apologies. I would also like to mention that as part of this AIFTP convention, there is a special MRP of the publication for the delegates at this conference, which is rupees 850. Otherwise, the publication is priced at rupees 1395. So it's a big discount of 40% at the conference. And if after the conference, the members are getting the publication, it will be priced at rupees 1000.
Thank you, everyone. So now it is the final words of wisdom from our chief guest, Shri Bhuyanji. Honorable Judge, Supreme Court.
Jain, National President of All India Federation of Tax Practitioners, Mr. Samir Jani, the past Deputy President, I would put it this way, and whom I have just administered the oath, the incoming President of the Federation, all past Presidents, Justice Karia and Justice Trivedi of Gujarat High Court, their better halves who are present here, Justice Saikia from Guwahati High Court, dignitaries on the dais, Justice Anil Dave, former Judge, Supreme Court of India, Madam Meena Dave. I have very fond memories of the Dave couple. I was a young judge then, but they were very kind to me. I very fondly remember our association of those days. All senior advocates who are present here, I won't take names because lest I miss out on some names, but two names I will definitely take, Mrs. Premlata Bansal and Mrs. Nikita Badheka. The two past presidents and the two women past presidents. In fact, Mr. Jani was saying about having a focus on empowering youth in the Federation. I would like to add that we should have an additional focus to draw more and more women into tax practice. It's a difficult area, and therefore we must encourage more and more women tax practitioners, and we should also have more women in the executive of the Federation. In fact, very recently Supreme Court had intervened to have a couple of office bearers of the Supreme Court Bar Association earmarked for women. How far it's good or bad, I will not say, but then this is done. And the move is on regarding, I won't say much because I'm part of the bench of the Delhi High Court Bar Association and all the bar associations of Delhi. Bombay Bar Association on their own has amended the Bar Association rules, having more women representative in the executive. I think this is an area where I think the elders of the Federation should sit together and work out the roadmap for the future. All the senior advocates who are present here, office bearers of the Federation, the Junagadh Tax Bar Association, the Gir Jamna Somnath Tax Bar, advocates, chartered accountants, tax practitioners, all the delegates who have come here from different parts of the country, our sponsors, ladies and gentlemen. Very good morning to all of you. In fact, I forgot that I had to administer the oath of office to Mr. Jani and came here to speak. It appears that this virus of public speaking has got into the judges. I think we need to curtail this. The lesser we speak in public, the better it is. Lest we say something unwarranted, uncalled for. I'd put it at that. But conferences such as these are all amongst the lawyers. And I was a life member of the Federation, therefore it's like a homecoming for me. So, but then, just a word of caution, I think we judges have started talking too much. I think public speaking should be avoided. Whatever we have to say, we should speak through our judgments. This federation is not new to me. I have been associated with this federation right from the beginning. They were kind enough to felicitate me on my elevation as a judge in Guwahati. I was there in the Bombay conference, I was there in Ranchi. And when I came to the Supreme Court after some kind of a Bharat Darshan, the federation was again kind enough to felicitate me in the Indian Law Institute. I remember that day, 30th of August 2023. So I'm very happy to be present here this morning at Junagadh on the occasion of the 27th National Convention of All India Federation of Tax Practitioners. I thank the organizers for inviting me to this convention and for giving me and my wife. My wife is not here, she has gone to buy some bandhini saris, I think. So she will join us in the evening conference, evening dinner. This is in fact our first visit to this part of our beautiful country. And I find that there are so many places to visit. This short stay of 1 or 2 days may not be sufficient. We will request Mr. Jani to host some other event, some other occasion, so that we all of us can come here and enjoy his wonderful hospitality. Though I was not a tax consultant or a tax lawyer in the conventional sense, nonetheless, my association with the Federation as a standing counsel of the Income Tax Department goes back a long way. I cherish my association with the Federation and all the fond memories I have of the various conventions and seminars which the Federation had organized and which I had attended. The organizers have very aptly captioned the theme of this convention, which is epitome of excellence. I know for sure that tax practitioners always strive for excellence. It is good and it is part of the human psyche that we should strive for excellence. But excellence is distinguishable from perfection. While striving for excellence will help us in achieving better results, perfection is an elusive chase. I always caution people, never chase perfection. Perfection is like a mirage. A perfect judge is yet to be born. A perfect judgment is yet to be delivered. Just look at the case of Keshavananda Bharati. It is undoubtedly India's leading constitutional case. It is this judgment which declared that our constitution has certain core features which form the basic structure. While Parliament can amend the constitution under Article 368 in any manner, it cannot alter the basic structure or the basic feature of our constitution. Mr. Dattar, who is present here, he had written an article which was published in the newspaper The Hindu way back in April 2013 to commemorate 40 years of the sage judgment. Last year we had commemorated 50 years of this judgment. And in that article, I was then a judge in the Guwahati High Court, a new judge. That highlighted the hard work and scholarship that went into the preparation of the lawyers representing the contesting parties, which culminated in that path-breaking judgment. Yet, this judgment is anything but perfect. Fali Nariman, in his memoirs, Before Memory Fades, he writes that there were altogether 9 opinions, which came from the bench comprising 13 judges, the highest till this point of time. I don't know whether we will have a still higher quorum. I don't know, that's in the realm of the future. The opinions, and he writes, the opinions were high on content and scholarship, but short on clarity. The clarity was brought about by a short summary prepared by Justice H.R. Khanna and circulated amongst the judges. Some signed, I am told, a few of them did not even sign. And this came to be the ratio in Keshavananda Bharati. I am only saying this because this goes to show that there is no such thing called perfection in life and in law. Friends, we have in our midst eminent speakers who will deliberate on various topics covering both direct and indirect taxes over the next 2 days. Therefore, I do not want to speak on any specific subject. However, before I address this august gathering on tax-related issues, I would like to share with all of you an important development which had taken place recently. I was pleasantly surprised when the child rights activist and the Nobel laureate, Shri Kailash Satyarthi, visited me sometime in October. And he said that we are organizing a roundtable conference, or rather a discussion in Delhi on role of compassion in achieving justice for all. That was the topic. In fact, he has already started a global movement for compassion covering all walks of life, including the judiciary. This discussion was held on November 18, 2024 in the Constitution Club at New Delhi. 10 sitting Supreme Court judges, including Justice Gawai, Justice Vikram Nath, participated. The discussion was moderated by Justice Hima Kohli, in which Justices Madan Lokur, Kurian Joseph, Indira Banerjee and A.K. Sikri also participated. All the speakers highlighted the need and necessity of having compassion while administering justice. Satyarthi said that his NGO is working to introduce compassion in all decision-making process in a structured way, and to figure out as to whether there can be a measurable yardstick like CQ, compassion quotient, as we have IQ, intelligence quotient. I had said that our justice delivery system or our adjudicatory model, though primarily adversarial, cannot be harsh or revengeful, spiteful. Proportionality is an important ingredient in the adjudicatory process. I said that compassion is a part of the larger circle called justice, which in turn is an adjunct of the law. While law must be applied keeping in mind the overarching principle of justice, justice must be administered in accordance with law. Justice must not only be done in accordance with law, but must accord with the principles of fair play in action. In other words, fairness. Justice without compassion will ring hollow. Compassion encompasses within its fold responsiveness. Litigants in this country want a responsive judiciary, a judiciary which is responsive to the needs of the citizens. Responsive judiciary or a compassionate judiciary is not based on charity. By being compassionate, we do not dole out charity. By the time a litigant reaches the court, he is already a harassed lot. Then in court, he has to tackle his lawyer. Then occasionally he had to face the bad behavior from the bench also. So, therefore, and after all, what are we? We are only trying to address the grievance of the litigants who come before us. They don't come here for charity, barring an occasional litigant who would like to fish in troubled waters. Most litigants in the country, they come when they have no other alternative, then approach the court. A litigant has a right to know within how much time his case will be decided. The system must be in a position to respond to this. A litigation in whichever forum and at whatever stage has to be decided within a reasonable period. The answer to the cry of the distressed litigant need not be with mathematical precision, but the system must be in a position to decide the cases, be it at the original stage or at the appellate stage, within a reasonable time frame. Again, this decision need not always be through adjudication. Various settlement options are also available and needs to be activated on a regular basis. Taxpayers do not need charity. Taxpayers do not need compassion. All that the taxpayers need is that their claims and disputes should be decided in a fair and balanced manner without any fear or coercion. Power to levy tax, we all know, is one of the sovereign functions of the state. And in the Indian context, Article 265 of the Constitution is the flag post. No tax shall be levied or collected except by authority of law. Therefore, what Article 265 requires is that, number one, there must be a law. Number two, the law must authorize the tax, and that authorization must be specific, express. And thirdly, the tax must be levied and collected according to the law. For a citizen, whether he likes it or not, he has to pay the tax, either directly, for example, as a tax on income, or indirectly on the purchase of goods and services. It is said that there are only two things which are certain in life. One is death and the other is payment of tax. These are the only two things which are certain in life. Taxation is an important source of revenue for a nation. It is the price that we pay for our civilization. Recent data of the Central Board of Direct Taxes suggests that the share of direct taxes in gross domestic product, GDP, has risen considerably. But simultaneously, we have also witnessed a significant rise in tax litigation. As per an article titled "Litigation as a Measure of Well-Being," new evidence suggests that higher litigation rates need not necessarily be linked to an overtly litigious society or a drain on the economy. On the contrary, it can be a natural consequence of economic development and improved human well-being. It is equally true that increased litigation, particularly tax litigation, has resulted not only in the blockage of considerable amount of finances, state finances, but has also clogged our court system. In 2021, the Minister of State for Finance informed the Rajya Sabha that as of July 29, 2021, Commissioner of Income Tax Appeals across the country had 4,78,606 pending appeals. Income Tax Appellate Tribunals had 62,130 pending appeals as on 1/7/2021. High courts were handling 26,456 income tax cases as of 31/3/2021, and 2,894 such appeals were pending before the Supreme Court. Financial Express, in its edition of April 22, 2024, has reported that as many as 5,44,205 appeals were pending before the CIT appeals as of June 31, 2024. These are recent figures. 63,246 appeals were pending before the Income Tax Appellate Tribunals, High Courts and the Supreme Court. Of course, we must acknowledge the success story of the Income Tax Appellate Tribunals. When we make an audit of the success or otherwise of tribunalization in India, the one tribunal which everyone agrees is a success story is the Income Tax Appellate Tribunal. Therefore, SSCs filing appeals and contesting revenue demands before the highest fact-finding body is indicative of the robustness and vibrancy of the Income Tax Appellate Tribunals. There can be no denial of the fact that the state is the highest litigant in the country, and taxation is no exception. One of the reasons for high filing of appeals by the revenue before the tribunals or before the high courts and also before the Supreme Court, I feel, is the tendency to play safe. Revenue officials tend to leave it to the court to take a decision on the stand of the revenue one way or the other, rather than taking it upon themselves so as to avoid departmental or vigilance action. Central Board of Direct Taxes has come up with various circulars from time to time, fixing monetary limits and enhancing the limits for filing of appeals by the revenue before the Income Tax Appellate Tribunals, the High Courts and the Supreme Court. This certainly has gone a long way in reducing pendency. However, according to me, additional steps are also required to be taken to filter out appeals before being filed by the revenue in the tribunals or before the High Courts or even before the Supreme Court, so that claims which may not stand legal scrutiny are not filed before the tribunals or the courts by the revenue. Professor Rolim, a leading Brazilian tax lawyer, he has written a book called Proportionality and Fair Taxation. In that book, he has articulated the need for a fair tax system. He says that a fair tax base is traditionally described as a matter of horizontal equity, though we all know that equity has no place in taxation. But the learned author says that the fair tax base is traditionally, he has described it as a matter of horizontal equity, while specification of tax rates is characterized as a question of vertical equity. Professor Rolim says that these two types of equity, the interplay between these two types, that is horizontal equity and vertical equity, are based on the ability to pay principal. Each of the sources, such as income, consumption and wealth, taken individually as well as conjointly, should form a fair tax base that should not be arbitrary, excessive or confiscatory. We have come a long way from McDonald's. Every taxpayer can plan his tax. Tax planning is legitimate and is clearly distinguishable from tax evasion. An assessee is entitled to claim deduction, rebates, refund, or even tax exemption where these are permitted by law. So far indirect taxation is concerned, we have traversed through various sales tax laws, VAT, and after the 101st Constitution Amendment, we have the GST regime now. It's not possible to go into the nitty-gritties of the GST enactments. But there is one area of concern which I want to flag off, and I spoke about this in the Hyderabad conference also. And that is the tendency of GST officials to detain persons on the allegation that he is evading payment of GST, particularly through the medium of input tax credit. Now, this detention, this arrest, traceable to section 69 of the CGST Act, is before quantification of the demand. Subsection 1 of section 69 says that if the commissioner has reason to believe that a person has committed an offense specified under 132, then he may authorize an officer of central tax to arrest such a person. We all know what is reason to believe. I don't need to highlight on this. Starting from Calcutta discount onwards, we have traversed the entire gamut what is reason to believe. Nonetheless, we found that particularly 21 immediately, 19, 20, 21, 22, a lot of arrests were made across the country. And the high courts were not granting bail. It was very, very disturbing. I was in Bombay at that point of time and was heading the tax bench. One matter came before us. He was arrested on the ground of evading payment of GST, and the arrest was made even before finalization or quantification of the amount of GST. He filed a writ, Daulat Samir Mal Mehta versus Union of India. That's the reported case. He filed a writ 226. In the response, revenue said that about 9 crores he has evaded. Maybe for whatever reason, maybe after arrest, he paid about 4 crores. Still the revenue was insisting that he should be continued in incarceration. So, in Daulat Samir Mal Mehta, the Bombay High Court held that the recording of reasons to believe by the commissioner that a person has committed the offense is not enough. The commissioner must also record the necessity to arrest that person even after he had responded to the summons, even after he had made sizable payment of the alleged evasion of duty. In that case, according to the revenue, the evasion was to the tune of 9 crores. He had paid about 4 crores. There was no reason to continue him in detention. 107 of the Act provides that if you pay the admitted tax and 10% of the disputed tax automatically in appeal, all further proceedings will stay. If that be so, when he had paid more than 30%, what is the need to keep him in custody? So we had granted him bail in 226 in that particular case. But since no other high courts were granting bail, to play it safe, we said that immediately on release he will pay some more amount, and thereafter within 1 month he will pay some more amount. The GST officials, they had filed SLP. Luckily for him, the Supreme Court not only dismissed the SLP, but also set aside those conditions which we had imposed for deposit of further amounts upon his release. Now, this is indeed a drastic power. Arrest of a SSC on the ground of that he is evading tax before quantification is indeed a very, very drastic power and must be exercised very, very sparingly. In fact, while I was in Hyderabad, one matter came up. Telangana High Court, a division bench here before us, it came up, Agarwal Foundries Private Limited case. In that case, investigation was going on. The petitioner came and said that how long it can go on. So we said that petitioners being taxable persons under the GST were required to cooperate with the investigation. While GST authorities are empowered to investigate alleged GST evasion, such investigation cannot be for an indefinite period. At one point of time, it has to come to an end. Whereafter, an appropriate order may be passed by the adjudicating authority if the materials on record justify passing of such order. It was in that context the bench observed that the demand was still to be adjudicated upon. If the demand was adjudicated upon, then the petitioner would have the right to appeal under Section 107 of the CGST Act and under Section 107(6) thereof. If the petitioners deposit the admitted tax and 10% of the disputed tax, the appeal would automatically be admitted for adjudication and there would be stay under subsection 7. And this is a right provided by the statute. Well, I think the departmental authorities are also required to be sensitized that CGST is basically a revenue legislation. Let us not make it into a penal legislation. The trust is on collection of revenue. The power to arrest is only incidental. It cannot take center stage. Well, the new amendments have come in. 148A we have seen, 144C we have seen, dispute resolution panels have come in. It appears that the government is also trying to strike a balance between the tax demand and the requirement of the tax-paying citizens to have some kind of a level playing field. So therefore, but all these are now in various stages of implementation. Supreme Court has exercised power under Article 142. In that case, there are views. I will not say anything. Being a sitting judge of the Supreme Court, I will not express my views. But certainly there are views more than one on this aspect, whether 142 can at all could have been exercised in a matter such as this. Well, 2019, the central government introduced and notified the Sabka Vishwas Legacy Dispute Resolution Scheme. The finance minister, in her budget speech, she said that though GST had just completed 2 years by then, there were huge pending litigations from the pre-GST regime. More than 3.75 lakh crores were blocked because of litigation in service tax and in excise duty. She highlighted the need to unload this baggage and to allow business to move on. She therefore proposed the aforesaid Legacy Dispute Resolution Scheme for quick closure of such litigation. And she urged the trade and business to avail the said opportunity and to be free from legacy litigation. Again, while I was in the Bombay High Court, a lot of matters came before our bench. What we noticed, and the grievance of the petitioners who came, that their applications or declarations for dispute resolution were being rejected by the revenue on various grounds. We got a feeling that some more training, some more sensitization of the officials were required before this legacy dispute resolution scheme should have been placed into operation. The officials continued to look at the declarants through the prism of tax evaders. Obviously, there are disputes, therefore they have come forward for settlement of the dispute. And there was again some kind of apprehension which we noticed, that what would happen if we disclose this and our application is rejected, and then we are back to square one. Not only back to square one, we are back to more coercive measures by the departmental authorities. Now, in one of the judgments, that is Thought Blurb versus Union of India, we highlighted that need. We said that the department should be more focused on settlement of these disputes, so that more emphasis could be placed on implementation of GST, which was need of the hour. There are a lot of teething problems in GST. Small traders, small scale traders and businessmen are finding it very, very difficult to cope up with the GST regime. And it's all good to say that we are heralding a new era of taxation. It's good to say that, but we also need to look at the practical difficulties being faced by the small, particularly small traders and businessmen across the country, which is, I think, more acute in the state of Gujarat. I feel so. What happened, as per the Comptroller and Auditor General's report, for this Sabka Vikas scheme, government had received only 1,89,648 applications. Out of the huge tax disputes, government received only 1,89,648 applications, out of which 29,000 odd were rejected, and the remaining 1,60,000 applications were accepted. Now, through this scheme, government realized 9,492 crores, plus adjusted pre-deposits amounting to about 18,000 crores. Now, compare this figure with the figure of which was declared by the finance minister, that blocked in litigation, 3,75,000 crores. Compare this figure with 9,492 crores realized through this dispute resolution. So therefore, we need to rework on this. Now that we are going to have again the Sabka Vishwas legacy scheme, the number 2.0, starting from October, we need to once again realize, sensitize the officials, that, and inculcate in them that it is in their own interest, it is in the interest of the department, it is in the interest of the revenue, that settlements are made. The SSC has come forward, encourage them to come forward and ensure that there is a settlement of the tax dispute. Likewise, we had in the income tax department, we had the Vivad Se Vishwas scheme, which was again I would say not an outright success, but again a qualified success. But we need to have more of this in the days and years to come. Friends, we have, as I said, number of speakers. We have got very good topics to be debated in the technical sessions. I would not take much of your time, and I don't want to prolong my speech. We have very eminent speakers here. Once again, I must thank Mr. Jani and all the members of the organizing team for inviting me to this national convention. My best wishes to the All India Federation of Tax Practitioners. I am sure the Federation will scale newer heights under the leadership of Mr. Jani. Mr. Jain has already provided the roadmap. Jani will take the Federation to newer heights in the coming months and years. Thank you very much, and God bless.
Thank you, sir. Your words of wisdom were truly inspiring and encouraging for all the professionals sitting and present over here. One announcement that the conference is live on YouTube, and the link has already been forwarded to all of you in the group. So it can be watched from YouTube also. As a token of our love and affection, we are going to offer a memento to our dignitaries. I would request Shri Ashok Bhai Jinjuwadia to please offer a memento to Honorable Justice Ujjwal Bhuyan sir. Would request Santosh ji to please also be ready. I would request Mr. Santosh Gupta to please offer a memento to Honorable Justice Soumitra Saikia ji. Please be quick. I would request Shri R.D. Kakra ji to offer a memento to Honorable Justice Pranav Trivedi ji. I would request Mr. N.P. Jain sir to offer a memento to Honorable Justice B.D. Karia. I would request Mr. C.J. Maniar to please offer a memento to Mr. Narayan Jain sir. I would request Mr. Arvind Mishra ji to offer memento to Shri R.D. Kakra. I would request Mr. Nitin Gautam to come forward and offer a memento to Mr. Vinayak Patkar ji. I would request Mr. Jitendra Mishra to offer a memento to Mr. Shashank. Okay. Ji Venkatramani ji. Jitendra Mishra ji to offer a memento to Mr. Venkatramani ji. I would request Justice Shri B.D. Karia sir to please offer a memento to Ashok Bhai Jinjuwadia. Ashok Bhai. I would request Justice Shri Saikia ji to please offer a memento to my colleague Jigar Patel. I myself would be taking a privilege. I would request Shri Trivedi sir to please offer a memento to me, sir. We all know that we have such a beautiful venue. The venue owner, that is the MD of the venue, Mr. Vipul Kotecha and Yatin Bhai Kotecha is also present over here. I would request them to please come forward. I would request Justice Shri Ujjwal Bhuyan sir to please offer a memento to them. एक ही. We have a small surprise planned by Taxation Advisor Association, Junagadh. I would request the office bearers to please come forward fast and felicitate the President. They have a surprise planned for Samir Bhai. Please come fast, please. All the members of the association, please come forward. Please be quick. Thank you all. We respect the feelings of all the members of the association. Due to the time constraint, we'll be starting. We will be giving the vote of thanks. I would request Shri R.D. Kakra ji to please offer a vote of thanks.
Friends, in this session, we receive the blessings and the wisdom of words from the galaxy of judges and witness a touching moments, memorable moments of oath ceremony of our President-elect. We are very thrilled today with the kind presence of galaxy of judges. As we are getting late, so I'm so short my thanks in 2 words for the judges and उत्सव मूर्ति आज की मिस्टर भूया साहब, आपके आने की खबर से सारा जूनागढ़ महके, आपके आने की खबर से सारा जूनागढ़ चहके और अधिवेशन में शिरकत से सारा हाल महके. धन्यवाद. जय हिंद.
Thank you, Kakra ji. Thank you. We will be, as a respect of our nation, we will please stand up for a national anthem. जनगण मन अधिनायक जय हे भारत भाग्य विधाता.
पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल वंग विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंग. तव शुभ नामे जागे तव शुभ आशीष मागे. गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे। भारत माता की।
We will be starting the next session. We have a special session by Shri Arvind Datar and Justice Anil R. Dave. I request all the participants to please be seated as we are late by time, so we'll be starting the next session immediately by change in the dais. Participants who have not done their registration yet are requested to please go outside and complete their registration process first.
आधार सेंटर से कैसी कमाई हो रही है? अरे बढ़िया चल रहा है, अभी 2 लड़के और लगा दिए। मैं तो कह रहा हूँ तुम भी खोल लो। मैं करना क्या होगा? कोई YouTube वीडियो है क्या? अरे YouTube पे टाइम वेस्ट करना बंद करो, सीखो ऐप डाउनलोड करो। सीखो ऐप? हाँ, दिन भर रील्स देखते हो ना, उसकी जगह सीखो ऐप डाउनलोड कर लो। वहाँ भी वीडियोज ही आते हैं, लेकिन सिर्फ वैसे ही इससे कुछ सीखा जा सकता। भाई मैंने अपना आधार सेंटर वहीं से सीख के शुरू किया था, अब देखो कितना बढ़िया चल रहा है। सुनो, पहले सीखो ऐप को समझो। तो वैसे तो YouTube और रील जैसे वीडियो ही है, पर जैसे तुमको YouTube पे देखना हो कि आधार सेंटर कैसे खोले, फिर YouTube पे जाओगे, सर्च करोगे, 3-4 वीडियो मिल भी जाएंगे, पर पता नहीं कौन सा वीडियो सही होगा। सीखो ऐप पे तुम सर्च करो आधार सेंटर कैसे खोले, सबसे ऊपर ही वीडियो आ जाएगा। वहाँ ऐसा नहीं होता कि 15 लोग एक ही टॉपिक पर वीडियो बनाए जा रहे हैं। YouTube पे तो कोई भी कुछ भी वीडियो बना लेता है, कोई रोक टोक थोड़ी है। लेकिन सीखो पे पूरी एक टीम बैठती है जो ये चेक करती है कि जो वीडियो बना रहा है वो एक्सपर्ट है कि नहीं, और जो वीडियो में बोला है वो सही बोला है कि नहीं, तब जाके वो वीडियो सीखो ऐप पे आता है। मतलब सीखो ऐप पे अगर वीडियो है तो उसमें जानकारी एकदम सॉलिड ही होगी। भाई ये रील और यूट्यूब पे टाइम वेस्ट करना बंद करो। आधार सेंटर भले ही मत खोलना, पर अगर रोज कुछ नया सीखना चाहते हो तो सीखो ऐप डाउनलोड कर लो। इंस्टॉल नाउ पे क्लिक करो और अभी सीखो ऐप डाउनलोड करो। क्या आप भी स्टॉक मार्केट में इन्वेस्ट करना चाहते हैं पर कंफ्यूज है कि कौन सा ऐप चूज करें? डोंट वरी, डाउनलोड ग्रो। ये है इंडिया का नंबर 1 स्टॉक ब्रोकर। इस पर आप कस्टम प्राइस अलर्ट सेट कर सकते हैं, सारे प्रॉफिट एक्शन देख सकते हैं और सब कंपनी फाइनेंशियल्स एक ही जगह चेक कर सकते हैं। नहीं, यहाँ आपको मिलेगा फ्री डीमैट अकाउंट, 0 एनुअल मेंटेनेंस फी और करोड़ों इन्वेस्टर्स का भरोसा। अब देर किस बात की, डाउनलोड ग्रो एंड स्टार्ट इन्वेस्टिंग। Investment in securities market are subject to market risk. Read all the related documents carefully before investing.
Datar sir. I would request Mr. Bhavya Bhai Popat to offer bouquet to Shri Anil R. Dave. Bhavya Bhai. I would now request Shri Arvind Datar sir for his address. Datar sir, I would request you for the address, please.
Good afternoon, everybody. Since we are late, I'll cut short the introductory formalities just to thank Justice Ujjal Bhuyan for taking the trouble of coming here and staying back to listen to us. I must thank Justice Anil Dave for inviting me here to Junagadh, and I'm really overwhelmed with the hospitality of Mr. Samir Jani and the entire team here. I have a long association with the All India Federation of Taxpayers. I think in the late 80s, I spoke at Jamshedpur as a young junior when my excise book had just been published. And I've also spoken at other seminars at Hyderabad and other places. This is really a special occasion for me. I got to meet so many people after so many years. And one important thing was, while we were flying down from Chennai to Bombay to Rajkot, my wife suddenly noticed on the Google that there is Datar Hills in Junagadh. You know, I used to always, as a child, used to pass by roads and I used to say, can there be a Datar lane or a Datar road or something like that? But now I've got Datar Hills. So I can't wait to tell my granddaughters this. I'm also thankful to Mr. Samir Jani for calling me as Amitabh Bachchan. This is really, really But it's nice to be in the presence of so many dons of the legal profession. Yes. Now, today, in a sense, is significant because we are just 17 days away from the end of the year, end of the month, end of the year, and end of perhaps the last year of the first quarter of the 21st century. 2025, we begin the journey for the next quarter. If you see the economic data, there are some very healthy, positive signs. We have a direct tax collection of 23.5 lakh crores. We have an indirect tax collection of 14.95 crores. Despite slowdown in Europe, the US, China also, we are still having a rate of 5.5 to 6% GDP, which is good. It can be better, but it is good. So these are all positive signs as we enter the new year. But I thought that it is always better to take a 30,000-foot view and have an overall perspective of where we are, where we were, and where we could possibly be. And I'll just share a few data points before I come to my talk on the current controversial issues. In 2000, the Fortune 500 global listing, I always follow that very carefully. In the Fortune 500 listing of 2000, that is just at the beginning of this century, China had 19 companies in the Fortune 500. India had 7. In 2023, China has 135 companies in the first 500. India continues to have 7. Our GDP has grown. It was 0.5 trillion. It has now become 2.33 trillion. China has gone to 14 trillion. Per capita income, they have gone up by 13.5 times. They have gone up by 6 times. So all this is time for contemplation. All this is time for reflection. Where are we? Why aren't we progressed so much? What is the main problem? And that brings me to this session, which is involving tax practitioners. And after finishing almost 45 years in the legal profession, and most of my life has been in tax, I've had the opportunity of interacting with domestic large companies, small companies, multinationals. And I can say honestly that the single largest deterrent for our economic growth is our tax laws and our tax administration. And I say this with responsibility. Why is the investment climate, why is the soil of India not fertile for more and more investments? I have personally witnessed people who have come here, put up a plant, got put off, and then shifted to Vietnam, shifted to Bangladesh in textiles, shifted to other countries. So this really calls for a great introspection. Just give one example, because time is short, so I've cut short my presentation a bit. I was dealing with one of the largest automobile manufacturers in the US. They've got a matter in Europe. They've got some matters in the Supreme Court. And while having the conference, they have got multiple litigations, customs, income tax, transfer pricing, so on and so forth. So I was speaking to the CFO who had come down from Europe, and he told me something very disturbing. He said, you know, Mr. Datar, India has 1.9% of our global sales, but we have 94% of our global litigation is in India. Two weeks ago, an outstanding civil servant, Mr. Sanjay Malhotra, who is now our RBI governor, he was a revenue secretary. And he made a very important statement which all of us must take to heart. He told the tax officers, please don't kill the golden goose. Please don't make exaggerated demands and kill the golden goose. And this is the point I wanted to highlight. And I have borne witness to this. In the early 2000s, The new telecom policy came. The new telecom policy shifted in 99, and the new telecom policy came. The then disinvestment minister, Mr. Arun Shourie, was able to persuade a large European manufacturer not to go to China, but to come to Madras. They put up a plant in a SEZ, and over the years, they exported 27,000 crores of mobile phones, chargers and accessories. One fine day in February, a Assistant Commissioner of Sales Tax asked them some particulars. He said, give me the list of all your exports. So they said, sir, as per our computer, we got 1,18,000 bills of lading over the last 6 years. We can't give everything, we'll give a sample. He said SSC is not cooperating and raised a demand of 25,600 crores by treating all the export sales for the last 6 years as interstate sales. He then said all these sales have been made without C-form and therefore I'm levying 12% tax. Eventually the company closed down. We went to the writ court, a long litigation, but ultimately the company closed down. The golden goose was killed. And let me tell you, ladies and gentlemen, if you take the data, it is very, very unlikely that many of the companies from that country or that area have invested in India. This is the problem which I mentioned. Now, coming to the current controversial issues, since time is short, I've just divided this into two parts. One is the direct taxes and one is the indirect taxes. Now, as far as current controversial tax issues are concerned, I'm going to say what are actually the controversies. I'm just taking 2-3 points from direct taxes, 2-3 points from indirect taxes, and then I'll move on because there are no more speakers after me. There is an announcement that there's going to be a direct taxes code 2025. For the life of me, I do not know what is this logic in having new laws. In 2007-2008, the then Finance Minister, Mr. Pranab Mukherjee, said that they want to have a complete relook at the tax system. They formed a committee and they decided to frame the Direct Taxes Code bill. It got delayed by 2 years, and finally, the Direct Taxes Code bill 2010 was introduced in Parliament. And please see the relevant ITR. The statement of objects and reasons of that bill is very interesting. Very interesting. The bill says the Income Tax Act has now completed more than almost 60 years. It has become very complex. Even chartered accountants and administrators are finding it difficult to understand it. Therefore, we must simplify the law. And they've introduced the Direct Taxes Bill. Now, at that time, we just had the opportunity of revising Kanga and Palkhiwala's next edition, and I had gone through the bill. And I found that in the name of simplification, the old Income Tax Act had about 350 sections and 14 schedules, whereas the new law had 315 sections, 22 schedules. The definition section had 297 definitions. So my thing is, Companies Act 56 became Companies Act 2013. You had various reforms. You had recently the Evidence Act, the Criminal Procedure Code, IPC all replaced. But my only request is, and through the forum also, once the bill is going to be, this new draft is going to come and give discussions. If you're not going to change the basic structure of the Income Tax Act, if you're not going to change salary, capital gains, house property, there is no point in simply reorganizing the sections. You're not going to solve the problem at all. So depending on what the bill comes, this federation can also put their suggestions, and I would rather feel that let the old act continue, live with it. The problem is not with the act, the problem with its administration. The second point, and I'll tell you one thing, my senior was a leading tax practitioner. Actually, I'm just giving an interesting example. There's a wonderful Hamden lecture by a great Australian judge, Michael Kirby. He said if a foreigner comes to England, who was actually from 1875, he comes to England, he will find everything has changed. The roads are different, the taxis are different, the automation. The only thing which has not changed are the English courts. You still have the same wigs and the same atmosphere and so on. So this question of tax simplification has continued ever since I joined the bar in the early 80s. And my senior once told me, he says, look, you cannot have a simplified tax law. A simple tax law is an oxymoron. You cannot have it. Because even if the law is simple, lawyers and chartered accountants will make it complicated in 2 to 3 years. So don't expect a simple tax law. The only exception I'll tell you as a simple tax law is what is called the flat tax system, which is adopted in 17 countries. Where what they say is, whatever is your income, gross income, you pay 11% flat. So there is no deduction, no discussion, nothing. So if you have a flat tax system, then you can have simplified law. But if you have a complex system, then you will have always a complicated tax law. And my senior gave the example of Newtonian law of physics. He said, what is simple will have large number of leakages. If you want to have a system which does not have leakages, then you will necessarily have complex system which will take care of all possible areas of evasion. So I think we should put an end to this direct tax code 2025, but it will come, and I hope that we are able to do something about it. The second point I want to make in direct taxes is we should seriously relook at this faceless assessment and faceless appeals. Justice Bhuyan mentioned about 5 lakh appeals pending in the Commissioner appeals. I have made this, our committee has made a suggestion that if the income of the assessee is more than 1 crore, then don't have faceless assessment, give it a chance of opening. Today what is happening is, if you take the income tax ITR 6th form, it has got more than 70, 80 entries. Now how do you explain to an officer complex situations through faceless? And I have really pleaded that if you want to have faceless assessment for small assessees, please do so. But please, please do not have faceless appeals. It's a quasi-judicial function. Just imagine if you're in any court and you're just arguing and you can't see the judge, you can't at all put your thing. So the second point I wanted to mention was the faceless appeal should be abolished, and let us have faceless assessment for small assessees. The third controversy I would like to suggest, see, ultimately any tax is going to lead to dispute. It is an eternal tussle between, as Lord Green put it, it is a tussle between the taxpayer and the revenue. And in many cases, ultimately, it is a tug of war. If the assessee wins, there is a change in the law. If the assessee loses, there is other problems. But disputes are going to be there wherever there is a tax system. The most important point in a tax system is how efficient is your adjudication mechanism. Now, ever since I have joined the bar, more than 4 decades, I have not seen a single reassessment notice dropped in my entire life. Once a notice is issued, it will take its course. You only get relief in the CIT appeals or in the tribunal. And I'll give an example. I've been doing a lot of indirect taxes. In my entire life, only one excise case was dropped where the refund was 48,000 rupees. I was a raw junior and we got a refund of 48,000 rupees. The name of the party was Sabina Cleaning Powder. I still remember the name of the SSC. It was one unique case. Even that money we did not get. Then there was a public grievance committee set up. I went and appeared to the commissioner and we got that 48,000 rupees refund. So now the point is we require good appellate mechanism. And I've been fighting this battle for tribunals. The most deleterious thing which has happened is appointing members for 4 years at a time. We have pleaded to the Supreme Court that at least for large tax tribunals, the GST tribunal or the excise tribunal or the income tax tribunal, you recruit young people at the age of 40, 45 and let them take it as a career option and go until 62. There are a large number of lawyers who would like to exercise, who would like to take a career in the judicial path. They may not become high court judges, but being a tribunal member is also exercising judicial functions. So I have been pleading, the committee has been pleading, that let us go back to the old system and let us have income tax tribunals with the retirement age is 62 years. I can tell you from experience, one of my happiest moments in my young days was appearing before the income tax tribunal. We had people like T.N.C. Ragarajan, Justice Ranganathan was there. So many eminent people were there in the tribunal. It was literally like appearing before a high court or a Supreme Court, the judicial approach, and I'm looking forward to those glorious days again. The other point I'd like to flag to this audience is, if you want foreign direct investment, it is most important to have a proper authority for advance ruling. An independent authority for advance ruling is the need of the hour. This has been repeatedly told to me by various clients, foreign clients, who say that, look, we can deal with anything. You tell me my tax is 40%, I will live with it. You tell me that my approval will take 6 months, I will deal with it. But I want certainty. I don't want to be in the realm of uncertainty. So if I'm going to invest into India, I should know that, look, this is the tax I'm going to pay, and I'll live with it. I'll make my plans accordingly. And we had a wonderful system which was put in 1992, the Advanced Authority ruling. You had Justice Ranganathan, then you had Justice Syed Shah Qadri, you had other eminent judges who were there. And it was such a wonderful mechanism. For some reason, it has been abolished. It is now a board of advanced ruling consisting of 2 commissioners. Now, how do you expect 2 commissioners, with all due respect, to give a ruling against their own department when they are serving officers? So one important controversy which we have to sort out is to have an independent board, independent authority of advanced ruling. You see, the point is, the whole trouble, as I see as a tax lawyer, looking beyond the day-to-day practice, is what is the philosophy of our tax system? What is the underlying philosophy of our tax system? The underlying philosophy, unfortunately, is revenue maximization rather than growth maximization. Tax is always a byproduct. It cannot be an end in itself. Today, what is happening is you have to keep on focusing on revenue targets regardless of the collateral damage you give. I'll come to this more in GST. The other difficulty, look at how the system works and how unfortunate consequences take place. There was a whole controversy of subsidies. You want to come to Gujarat, invest in a backward area, you will get tax holiday, you will get stamp duty exemptions, you will get provident fund exemptions. Why? Because to invest in that area, your costs are going to be more. You will have to be compensated. That's why you see in all northeast states, other states, there were a large number of tax incentives were given for setting up industries. The matter went to Supreme Court. Is subsidy taxable or not? Supreme Court, in a very elaborate judgment, said, if the subsidy is capital in nature, for putting up a factory, for substantial expansion, it is capital. But if it is for promoting your profits for a running company, then it is revenue and taxable. So they made a very clear distinction, and the first distinction was made in 1922 in a case regarding a Scotland dockyard. But this was the thing when Supreme Court finally settled it. Now what do? You simply amend the law and say all subsidies are taxable. Not only that, what is worse, it's the matter pending in the Supreme Court, what is worse is that you now say a company in Maharashtra goes to a backward region. It gets 50% stamp duty waiver for setting up the unit on the stamp duty. Now the waiver of stamp duty is deemed to be your income and taxed. So look at the absurdity. I have not spent the money on stamp duty. I have got some 50% provident fund waiver, but what I have not spent is deemed to be my income and I pay 39% tax. And we demonstrate to the court, the Supreme Court has finally admitted the matter, we demonstrated that I have got total of say 200 crores of subsidies for putting up a large plant in a backward area, but out of every rupee I earn of the subsidy, 39 paise is taken away by tax. Now look at if you study deeply, who gives the subsidy? The state government. It is the state revenue which is state taxpayers' money which is going for the tax purposes, and the central government takes away 39 paise in the rupee, which is completely unfair. I mean, are you promoting economic growth? Or are you promoting tax collection? That is the point I'm making. Now I come to GST. This is now the big elephant in the room. And believe me, unless there is some curbing, some curtailment of what is going on, we are going to lead to very, very serious problems. Only yesterday, what is happening, I was told at the ground level, is just the focus on collecting more and more as we approach towards March is leading to completely absurd demands. And let's give one example and I'll move on. It's just a live case. It is coming up next week for admission. There is a bank. It's a small bank. It's not a nationalized bank. Now, they charge interest. Now, interest, there is no GST. When a bank earns interest, they give a loan on it, there's no GST. They give some gold loans, and for a person who defaults, there is a penal interest. So the officer took the view, the show cause in the notice, that interest is not liable to GST, but penal interest will be liable to GST. So the bank said, sorry, penal interest is part of the game. It's part of the contract. If you don't pay within so and so time, I'll charge you higher interest. Now look at the best thing what has happened. What the GST has done is, they have taken the total interest income of the bank. The bank has got loans, advances, etc., vehicle loans. Total interest income is taken from the balance sheet by the Tamil Nadu officer, and it is taxed at 18%. The total income. Then that the story doesn't picture baki hai. Then he then goes to the expenditure side, takes the entire expenditure and levies 18% tax on the entire expenditure on reverse charge basis. This is the demand of 2,400 crores on a bank whose annual profit is 349 crores. We've got cases, just a friend told me that I'm a job worker. I do job work. My total turnover is 11 crores on job work. But what they do is, on some dispute, they say, you've taken a job work and they tax me on the entire job. Like if I'm going to do some welding for a truck, you can charge me on welding charges, you can't charge me on the cost of the truck. So these are the things which are happening as far as GST is concerned. So this is what Mrs. Sanjeev Malhotra warned, because we made a representation that this is happening. Mr. Malhotra said, don't kill the golden goose. Unfortunately, he's gone to the Reserve Bank. I think officers must take heed of it and not try to make these absurd demands. But two more controversial issues on GST. Justice Bhuyan was part of 2 9-judge benches which went into the issue of mining and on liquor. So yesterday I was talking to some people and there seems to be some controversy on that. I'll just touch upon it and I'll move on. Take liquor. Now in synthetics and chemicals, the decision was that if it's industrial alcohol, then states have no power to deal with industrial alcohol. It's only a central subject. The whole issue is, what is the meaning of intoxicating liquor? Does intoxicating liquor means liquor which you can drink as such? Or does it may have got a much wider connotation which includes all kinds of extra neutral alcohol? Now just to give you a picture of this, you take, see, basically liquor will be made from either molasses or from corn, typically. Let's take sugar, for example, molasses. A sugar factory makes molasses, makes sugar. As a byproduct, they have molasses. Molasses can be made into alcohol. Now, rectified spirit is basically removing the impurities and making rectified spirit, which is also called extra neutral alcohol. The highly purified form is extra neutral alcohol. 95% alcohol is ENA. Now today, in certain states, you can take extra neutral alcohol, dilute it and have it as a drink, no problems. In fact, the country liquor which is sold is nothing but diluted extra neutral alcohol. You bring it down to 30%, 35%, and then you can sell it. The main issue now is with all the industries, can GST be levied on this item, on this issue, or will it be subject to state laws? Now my view is this, which I have put forth. Just visualize a factory, right? This is the factory gate. The product leaves the factory at this point, and that's the taxing point. If you're making extra neutral alcohol, which is capable of being converted into liquor, vodka, whiskey, rum, etc., you can make it. It will go to a distillery, which will then convert it into the appropriate alcohol. If that alcohol is going to be sent for industrial purposes, it can't leave the factory unless it is denatured by means of adding denaturant spirits, denaturant chemicals. And there is a rule, if you want it to go for paints, you have to add this denaturant. If you want to do for this, add this denaturants. This denatured alcohol can also be consumed, but it is highly harmful to health. If it contains methyl alcohol, you'll go blind and you'll die. But otherwise, this denatured spirit, we can technically call it, is unfit for human consumption. It should not be consumed. Now the very simple point is, just there are two things, black and white. If the liquor is going for human consumption, it will be subject to state laws. If it is going for industrial purposes, it is subject to GST, subject to central levies. That's a simple point, and I hope the GST Council clarifies it at the moment. The question is whether extra neutral alcohol can still be subject to state central law as a problem. As far as mines and minerals is concerned, which Mr. Gulati is going to deal with at length, the whole issue is a very important ruling, and I think the Supreme Court bench, where Justice Bhuyan was a party, has emphasized the need for the states to have more autonomy to levy taxes. This judgment has emphasized the importance of fiscal federalism. They said when the state power of taxation is there, it should as far as possible not be interfered with. So if it's entry 49 tax on land and buildings, not subject to any state control, give full freedom to the states. Tax on mineral rights, subject to parliament, yes, but they can tax it. So after the judgment, now one thing that is clarified is royalty is not tax. Royalty is consideration. That is the view taken by the 9-judge bench overruling India Cements. What is the consequence for GST? That's going to be a big issue now. If royalty is consideration and it is not a tax, then can it be subject to tax on GST? If the original argument was, if royalty is a tax, you can't levy GST on this because you can't tax on tax. But royalty is not a tax, it is consideration. Can you levy GST on that? In my view, the answer is no, because if it is consideration, then levying a tax on royalty is a taxing mineral rights, and that is fully a state subject. So as long as royalty is for mining amounts to consideration, the entire taxation can only be in terms of the state laws, and GST will not have a place. The whole issue, courts will have to decide what is the scope of the non-obstante clause in Article 246A, notwithstanding anything contained. Will that prevail over legislative entries or not? I'm not getting into technicalities, but my view is GST, the only purpose of putting non-obstante clause in Article 246A is to enable concurrent power of taxation. Till GST, taxes could be either by the center or by the state, but not by both. But 246A does not permit GST to be levied on all those items which are mentioned in entry 46 to 53 of the state list. These still continue to be the state subject. So on mining minerals, this is the controversy I wanted to highlight. And the last point which I wanted to mention on GST is, which is again a huge problem with foreign clients, foreign investors, is secondment. I don't know how many of you know this burning problem which is affecting large number of, almost every company which has got investment in India. Now take, for example, Maruti, hypothetically. It is, I think 52% is owned by Suzuki, and they will send employees to India to work here. Take Hyundai, which is based in Chennai. At any given point of time, there are more than 120 Korean engineers, professionals working in India, in Madras. Now, somebody took the view that these employees are coming here, they are rendering service. Therefore, the parent companies engage in manpower supply services. So these people are aghast. They said, if I am Boeing, if I am Hyundai, I am not a manpower supplier. I am a large multinational. You can't treat me as a manpower supplier. So the secondment employee was there. So we have said that, look, if he is employed in India on a 5-year term, 3-year term, he pays taxes to the Indian government. He is employed by the Indian company. He only retains his lien with the foreign company for social security purposes. For technically, he's still a Hyundai employee in Korea, but he's also working here. Now, despite multiple representations, the government still insists that these people must be taxed at 18% on the ground that it amounts to manpower consultancy services. These are small issues which irritate the investors and put them off completely. How much tax are you going to collect out of this item? So, in the short time that I've had, I've highlighted the various issues. Now, I come to the role of the All India Federation of Taxpayers. I want to make some suggestions. I am currently the part of the Tamil Nadu Advisory Council on GST and Fiscal Federalism. We have a team of lawyers, we have chartered accountants, we have software representatives, MSME representatives, large representatives. We have been repeatedly asking the people, please give us suggestions which we can put to the GST Council. Now, what we want to clarify is that one point we're working on is rate rationalization. And I'll just give a small example, just as a kind of an aside, how complicated the case is. Take a simple chocolate cake. If the chocolate cake is sold by as a cake, it is liable to 18% because it is supply of goods. If it is sold in a restaurant where the rooms are less than 7,500, the rate is 5%. In the same hotel, if there is a banquet hall, the chocolate cake is subject to 18%. If the hotel has got rooms charging more than 7,500, the same product is 18%. So one restaurant owner in Tamil Nadu said that if he is selling 14 items on his vegetarian menu, they are subject to 4 different types of taxes. So we have been repeatedly requesting people, please give us examples for rate rationalization we can put. Now I come to the role of the All India Federation of Tax Practitioners, and I would request Mr. Samir Jani and other people to take it as part of your Golden Jubilee program. I would request you to have a committee, say a reform committee or a tax, reform committee is a simple word, both for direct taxes and indirect taxes. You have a membership of 11,000. All of you are interacting daily with tax problems of your clients. You know what are the pain points, what are the areas where the law can be reformed. And I would suggest that if you can have a quarterly meeting or a half-yearly meeting, get inputs from all the people from different regions and make a compilation and give it to the ministry concerned or the department concerned that these are the areas where amendment can be done. And from my experience in Tamil Nadu, they say we just don't want complaints. We don't want to say system is bad, things are bad. They want concrete suggestions. And I may, all fairness to the government, many suggestions are also genuinely taken into account. So I would suggest that whatever problems the clients face, if you can, because the client can articulate it, you will be the best persons to put forth the problems. And from what feedback we have got so far from the ministry and also this, is that they want actual examples. If you feel this rule is bad, what should be the drafted, amended rule which you would like? Don't simply say this rule is bad, unworkable, it's arbitrary, Article 14, that's not necessary. You say if Section 17.5 is not correct, what should be the actual 17.5? So this will be a great role all of you can play. Having seminars is good, having discussions is good, but ultimately what are the action points? What are the concrete way forward that we take? And unless we do that, then these symposia, etc. have no meaning. So I would suggest to Mr. Jani, as part of your team, please form these committees and focus on areas which are going to do. And believe me, they do act. We recommended that don't have a 10-year reopening for various reasons. That has been accepted, it has become 5 years. We suggested that don't have multiple charitable trusts, 1023 for education, 215 for normal, that also has been accepted. So there is definitely hope and there is good response from the government if you make concrete suggestions. There is no point simply complaining and criticizing. Let us be the movers and shakers of the change that we want, and your federation can play the best role in this particular regard. And I'll finally conclude. I'll just finally conclude by saying that unless we change our tax system, nothing will change. I am now finishing 45 years at the bar. The same problem continues. You take Kanga and Palkewala. What Mr. Palkewala was lamenting in 1970, I am singing the same song today. So unless we completely transform ourselves, we will not get into the big league of the industry. We can have so many lectures and we can beat ourselves happy that this is very good and that's very good. But the ground reality, things are not good. I don't know if you know that the number of entities in India which have more than 5 employees is just 5 lakhs. Only 5 lakh entities have more than 5 people employed. That is the harsh reality. The biggest problem in the country today is unemployment and manufacture, and I'll conclude with that. In 2014, the manufacturing percentage of GDP was 16%. In China, it is 29%. So we said we should have a healthy benchmark that at least 25% of our GDP should come from manufacturing. It was 16.2% in 2014. In 2024, it has gone down to 13.9%. It has slid down. In 2014, they said they'll create 125 million jobs. In 5 years, the reverse has happened. It has not happened. COVID is there, but otherwise also. So what I'm saying is, at the heart of the problem, the core issue to be addressed if India has to prosper is to have a completely new tax policy. As they say, unless there is death, there is no rebirth. We should now realize that if after 24 years, only 7 companies of India are in the Fortune 500, there is something seriously, seriously wrong with our system. We have to improve. And I'll just simply end by saying that we must, as tax professionals, I'm not saying because I'm speaking at a seminar, but I genuinely believe that once you alter the tax system, once you focus on growth maximization, India will be a far, far greater and more prosperous country. And one more thing, what I find is we are creatures of habit. Recently, Mr. Joshi was mentioning, in fact, I must just mention that I'm happy to meet him after 20 years. When I wrote the book Courtroom Genius, we had to interview people who worked with Mr. Palkhiwala. And I was sitting with Mr. Behram Palkhiwala, Palkhiwala's and Nani Palkhiwala's younger brother, and he gave me a list of people who had worked with Palkhiwala. And Mr. Joshi's name was there. He said, in say Milo, he used to brief Mr. Palkhiwala in sales tax matters. And I had interviewed him, so I don't know if you remember that. I still got your tape recorded interview. I interviewed him, and his name is also in the book. So it was a pleasant surprise to see him also here on his 91st birthday. So I wish you all the very best. So I would suggest, as I mentioned, start as reform committee, become the harbingers of change, and I'm sure that with this determination and the leadership of the entire All India Federation, we will grow to greater heights. I wish you all Merry Christmas and a Happy New Year, and let us hope that after 25, we really have lots of Achhe Din. Thank you.
Thank you so much, sir. We hope the legislature will soon come up with the reforms which you have pinpointed very well. And now I would request Shri Anil R. Dave, sir, for his comments.
My dear brother judges, friends of my legal fraternity, ladies and gentlemen, I think as a judge of the Supreme Court, I was very happy because if my colleague just says something very nicely in a judgment, I had to simply say, I agree, or I respectfully agree. Matter ends. I had not to do anything further. So had I been a judge sitting with my friend, Mr. Arvind Datar, after his lecture, if I had to say something, I said, I respectfully agree, that's all, and I have to go and sit. But Samir Bhai told me that if you do like this, you will not get the lunch. So there is always a price tag. Say, I have to say something. But honestly speaking, after such a legal luminary says something, and then I have to make some comment or say something thereafter, it becomes really difficult. It is a difficult task. I really feel that our tax system is really not very good. Possibly they should be asked to read Chanakya. Chanakya had said that tax collector should be like a honeybee who takes nectar from the flower without affecting the flower at all. Flower is not adversely affected when honeybee takes the nectar. Honeybee collects plenty of honey, but no flower is damaged. Now, when my friend Arvind Bhai Datar said that the company was closed because of that one notice issued by Assistant Sales Tax Commissioner, that is really shocking. You see, our country can never progress. If I am a foreign person and if I have to do some business in India, I would 100% not come here. You see, tax system should be very simple. I really agree with him. There should be a flat system, and if you want to encourage somebody, don't ask him to pay tax. Say you are in this industry, don't pay tax for 10 years, no further conditions. Say, very often I used to say that we are not doing any small thing also, zip. We are importing from China. We say make in India, we have been clamoring about that. Why not to say that those who manufacture zip, they will not pay tax for 10 years. That's all, no further condition. Now, if you do such a thing, if you simplify, then it's a good thing, but we never like to simplify. And very often I say, when my chartered accountant friends say that laws should be simple, taxation should be simple, I say, don't say that. You see, we are having from motorcycle to Maruti and Maruti City Honda and then Jaguar. That is only because of our wonderful tax system. That every day taxes are being changed. Judges don't understand. We lawyers teach them. I mean, as a judge, I can say that way. I have learned from the lawyers, from the chartered accountants. So I said, of course, it is a very sarcastic manner of saying this, but it is really not good thing. Making tax was so complicated. You see, basically, we say that there is a presumption that everybody is supposed to know law. You can't say that a citizen doesn't know law. Now, if you complicate law in such a manner that even a High Court judge cannot understand, that Supreme Court judge has to say that the High Court judge was wrong. Now, what is this? Is it the way in which you draft the law? It should be really very simple. As I told you that once again, they should learn Chanakya right from day one. But unfortunately, they are not doing things. I remember one incident when I was a judge. Government of Gujarat wanted to give some benefit to those who generate energy with help of wind. Windmills were to be established. It was said that you establish windmill and for 5 years you will get some tax benefit. Unfortunately, what happened, somewhere in 2000 or so, there was a horrible cyclone. Those windmills were totally destroyed, absolutely destroyed. Government said, you pay the tax benefit back. You have not used tax, I mean, you are not generating now. You are not generating power because the condition precedent was 5 years use. Now, it is really nonsense. Yes, you should think about this. The government should have thought, the officers should have thought that the intention was that you don't take benefit and stop the work. You take benefit and don't do the work. Don't generate electricity. That is not the thing here. It's a vis major. The Almighty wanted to do something and that has happened. And when you put the SSC to such a difficulty, when poor chap is in difficulties, his all windmills are totally perished. And you see, give me back the concession which I have given. It is really very harsh. I made some suggestions to the council who was appearing for the sales tax department. I think it was pertaining to some sales tax. I don't know what happened subsequently because it was not decided by me. Ultimately, the bench was changed. I don't know what happened, but I think this is one incident. So why do all these things? If you want to take tax, take tax. And with regard to this faceless assessment, I really agree with him. It becomes very difficult. Even I tell you, after this corona, we have started video conferencing. Appeals on video conferencing are also not very effective. Very often I feel that the lawyers are not very comfortable, the judge is not very comfortable when you don't sit against face to face. It becomes very difficult. And when in appeal, first appeal, where all facts have to be examined and you don't see the person, you don't hear him, then what is the use of even having Supreme Court? You just file the paper, file the petition and reply and let the Supreme Court judge decide. Why should you do this? High Court will do that thing. Civil Court will do that. You put evidence and put everything before the judge. Judge would decide without hearing anybody. Then what is the use of lawyers then? If not lawyer, at least advocates, because lawyers are advocates are concerned with the advocacy. Then you don't require any advocate then. But that is not proper. I don't know whether they would ever consider such a suggestion, but I think they should consider such suggestions. I would like to say that my brother Buhan, don't look at it, I am going to say something about what you said. You said, brother, thank God you didn't say from Supreme Court, otherwise I would not have dared to say this thing. He said, tax and death, these are two certainties. If you look at our Hindu mythology, there are 7 immortal persons. Hanuman, Vedvyas, Vibhishan, Ashwathama, Kripacharya and somebody else. So they did not die, but they must have paid tax. So death may not be certainty in a very, very exceptional case, but tax is a certainty. You can't avoid tax. So this is the position. But anyway, I'm very happy that such associations are doing a very good job. And as my friend Mr. Datar said, that all the problems which you are facing, they should be informed to the government authorities through such bodies of expert tax practitioners. And at the same time, you should make some suggestion also. You should give some concrete suggestion that instead of this A, do B. Then it is useful, because otherwise they will never accept this, because they should have some idea as to what should be done. And if such things are done, then I am very sure that such conferences would be of great help to all SSs, all citizens, and to the country for the purpose of progress. I am really thankful to the entire team of Samir Bhai, Mr. Venkatramani and Mr. Jain, everybody who has organized this fine program. And I wish all the best to all. And I am very sure that in the new tenure of this Samir Bhai, something much better would be done, though very good things are being done by this association. Thank you very much. Jai Hind.
Thank you, sir. It's always a pleasure listening to you, whether on stage or off the stage. Now, I would request Mr. Anil Mathur from Jaipur to offer a memento to Shri Arvind Datar, sir. Mr. Arvind Mathur, please. Memento. I would request Mr. O.P. Shukla from Varanasi to please offer a memento to Shri Anil R. Dave.
I would have a small intervention. Mrs. Ruchi Rathod, she's the young girl, she got the award for the best article. She's living Junagadh. So I will request Honorable Dave sir to please give the award to Ruchi Rathod. Sorry for the intervention. Ruchi, please. She's a young lawyer handling direct and indirect taxes in Bombay High Court. Thank you, everybody. Thank you.
Thank you, everyone. So now we are ending up this session. So the next session will start immediately. Thank you so much, sir. Thank you for your valuable insights. Thank you. Session is starting immediately. We have the faculty Shri Saurabh Soparkar ji over here, so we will be starting the session immediately. Please request the participants, please be present over here.
Just a small announcement. A couple of you were inquiring about the souvenir booklet. It is a e-souvenir booklet, so that will be sent to you or already sent to you as a PDF link. So just for the benefit of all the delegates present here. May I please request Senior Advocate Shri Saurabh Soparkar to please join us on the stage. I would also like to request Mr. Lakshman Kashyap, Ashish Bhai Shah, Harsh Jani, Aditya Gupta and Atul Bhai Padia. If all of you could please join us on the stage, we would like to start with the technical session by Senior Advocate Shri Saurabh Soparkar. Can I ask Shri Vinaykant Mishra ji to please quickly come up on the stage for welcoming Senior Advocate Saurabh Bhai with a bouquet. Sorry? Okay, Abhishek Sharma ji from Jaipur. Abhishek ji, if you can please. For the delegates over here, in this technical session, after the address of Senior Advocate Saurabh Bhai, we would be taking up a few questions. However, in the interest of the time, the request is that while he is giving his technical session, if you have any questions, please have that sent over to us here on the stage, and we would be doing the needful for asking him the questions after his address. So the subject for this technical session is block assessment scheme, new and old. So Saurabh Bhai, if I can just set the context, we are having a full circle around. In the 95, the block assessment scheme came. It lasted till about 2003. Then we shifted to the regime of sections 153A to 153C for a good long number of years. Then the reintegration happened along with the reassessment provisions. And almost after 21 years, we are now back to the block assessment scheme, probably in the similar shape and form with modifications as would be highlighted by Saurabh Bhai. One question which I would just like to put as a poser is that under the block assessment scheme, if there is a search conducted, I have the option to pay taxes at 60% as per the provisions. And, you can enlighten us, but to the betterment of our knowledge, as of now, the surcharge and cess, there is only a provision to levy the same, but probably not levied. So if I can say like 60% tax is what I would pay if I come forward and do it after the search. The enigma arises is that under the provisions of section 68 and 69, in case of unexplained investment, under 115 BBE with the taxes and the penalty interest, it almost goes up to 84%. So it's like probably saying that the taxpayer who has undisclosed income is actually wishing that please come to my premises and conduct the search rather than, me getting caught with some unexplained investment. So, sir, that would be one of the posers that I would like to put forth, and over to you for the technical session. Thank you so much.
At the outset, I must thank the organizing committee for inviting me, and I must wish the organizing team in general, Samir Bhai in particular, for a very, very successful year to come. I am conscious of the query put in by my friend Jigar Patel. I'll come back to that as and when I deal with the issues in greater detail. But let me begin with the beginning. He said that after 21 years, if I take 95, almost 30 years, we are bringing back the block scheme. Answer is yes and no. Whereas this block, I will say new block, wears the clothes of the old block, so much so that even section numbers are repeated. 158 BFA under the old scheme was penalty. Over here also it is 158 BFA. Why should they have BFA? They could have said BG, but no, they want to have the same sections. Therefore, the clothes are the same, but body has undergone a change. And body has undergone a change because revenue has now realized the problems with both the block systems. Block system, old block from 1st July 95 till 31st of May 2003. Second 153A, 153C regime from 1st June 2003 up to 31st March 21. So the problems of both are sought to be addressed in this hybrid system, creating far more complications for the SSC. And unless one examines the scheme carefully, one would not really find the problems. And in as much as the new scheme has come into operation only in relation to searches after 1st September 24, people have not been required to file returns under the new block as of now, and therefore the problems are not realized. Let me therefore give you a slight historical background of what were the problems and how is it that it is being addressed under the new scheme. Under the old block, when it was introduced, there was lack of clarity as to whether the block assessment is going to be over and above regular assessment, or the regular assessments will be subsumed into the block assessment. The chapter said it is in relation to assessment of undisclosed income. But the way in which the sections were drafted, it was possible to take a view that once there is a search, all regular assessments will be terminated and it will be only block assessment at 60%. Punjab and Haryana High Court, Madras High Court had taken a view that once block assessment starts, all other assessments will terminate. Gujarat High Court had taken a view, taking a contrary view in NR paper, that no, block assessment is only for the undisclosed income at 60%. Legislature stepped in, and in the year 1998, retrospectively, law was amended from 1st July 95 by inserting explanation under section 158B, saying block assessment is over and above regular assessment. What is added in regular income will not be added in block. What is added in block would not be added in regular assessment. Therefore, we had two parallel assessments. Problem that the revenue faced, and that is the reason why they stopped this system, was where a particular income would be assessed was always a matter of grave debate. Section 68, addition. Whether the addition is being made under section 68 on account of information found at the time of search, that the entry is bogus, it will go in block. But if information is not there at the time of block, it is otherwise available to the revenue or assessing officer finds out, it will go in regular. So whenever revenue would try to put in an addition in regular, SSC would say put it in block. Whenever revenue would try to put it in block, SSC would say you put it in regular. In the event, revenue lost at both ends. Therefore, revenue was not very clear as to how to deal with this problem. So they scrapped the system. They have new system 153A, 153C. 153A, 153C, all of us are aware, there is only one assessment. In case of pending assessments, all pending assessments would abate and the assessment would be framed by the assessing officer on the total income, including income which is undisclosed income. In relation to assessments which have not abated, closed and concluded assessment, you would be able to assess undisclosed income provided there is disclosure, there is detection of undisclosed income at the time of search. Now again, this gave a serious problem. In relation to abated assessment, there was no problem. Everything was to be taxed as a global income. But in relation to assessments which have already closed and concluded, and you are now seeking to levy tax under section 153A or 153C by saying this is income which has come to the notice of the revenue on account of money, bullion, jewelry, valuable article or thing, or books of account, documents or entries of income or expenditure at the time of search, there was always a controversy. Delhi High Court in Kabul Chawla took the view, followed by Gujarat High Court in Souvenir construction, that where assessments are already closed and concluded, you cannot make any addition to section 153A in relation to item which is not found at the time of search. Therefore, revenue was unable to make use of 153A, 153C except in case of A, pending assessment, and B, where actual material is found for the past years. Matter was carried to Supreme Court. Abhisar Builders confirmed the view. Ultimately, it did give power of section 148, but otherwise the view was confirmed. So eventually, revenue was not able, according to revenue, to get revenue or income in relation to past years. In order to solve this problem, because unless we look at the historical background, the problems, serious issues and prejudice to the SSC under the new scheme would not be realized by us. Therefore, in order to solve this, what the department believed to be the problem, now we have a new block. One fundamental difference between the old block and the new block is, under the old block, it was assessment of undisclosed income, whereas under the new block, it is assessment of the total income. So what is now happening, I am just indicating at the beginning. Under the old block, only undisclosed income was to be taxed at 60%. Under the new block, the total income would be taxed at the rate of 60%, subject to some exceptions to which I will come to. In other words, the moment an SS is searched, his assessment for the year in which search has taken place and the last 6 years would be subjected to block assessment. Now look at again the psyche of the government. Why 6 years? Now you are entitled to reopen assessment only for a period of 5 years. You could have kept block also for 5 years. But no, because old block says 6 years, new block says 6 years. Otherwise, there is no reason as to why they would keep 6 years. Nonetheless, they have kept the 6 years. So the block period remains the same. The difference is in the definition of undisclosed income. Two things are significant. One, which is taken care of in the intervening period under the old block, money, bullion, jewelry, valuable article or thing, or books of, or income on account of books of account or documents, etc., or entries. The element of unaccounted or bogus expenditure was not there under the old block, but it was introduced under 153, 153C, so that is introduced. That's one change. But second, and which is a very, very dangerous amendment, which is not really highlighted, under the old block, what was treated as undisclosed income was a claim either of income or expenditure which was found to be bogus. Under the new block, in the definition of total income to be taxed at 60%, what would be taxed would be what an income or expenditure which is found to be incorrect. When I go to the assessment part, I'll highlight this issue. I just wanted to flag this issue. This small amendment of shifting from bogus expenditure to incorrect expenditure is itself going to create a havoc. Let's now go to section 158BA. Under the old scheme, as I said, assessment was going to be of undisclosed income. Now we are going to have assessment of total income. So what now it provides is, one, all pending assessments will come to an end. Like our old block or old section 153A, all pending assessments will come to an end. The assessment of search year, including and up to the date of search, for the purpose of this discussion, let us assume that search has taken place on 1st October 24, because I'll be discussing theoretically some issue. So let's take 1st October 24. So income for assessment year 25-26 up to October 24 will be under the block. And from 1st November 24 to 30th of March 25 will be regular. So for the 6 months, it will be 60%. For the balance 6 months, it will be at the regular rate. It's not as absurd as I said. There is something to be stated when it's computation of total income, but otherwise it is 60%. Then there is a provision that transfer pricing assessments will be terminated, etc. I will not really go there for want of time. Now comes the major issue, and this is something as I wanted to discuss. How do you compute the income of the block period? And it is here you will find the issue which I have flagged. And there are 2-3 more issues. You add 5 items. Block income is sum total of 5 income minus 3. Let's go to 5 items. 1, what you disclose in your block return. So for suppose there is a search and I file a block return disclosing income of rupees 5 crore, that's item number 1. Item number 2, total income assessed in relation to those years where assessments have taken place. Where assessments are already closed and concluded, whatever is assessed is also part of your total income. Therefore, if the search has taken place, let's say on 1st October 24, assessment at 25-26 and earlier 6 assessment years. So assessment at 2019-20, 2021, 21-22, 22-23, 24-25, 6 years will be there. So let us assume for assessment years 19-20 and 20-21, there is a return of income of rupees 2 crore each. And it is assessed at rupees 2 crore, right? Return was filed at rupees 1.5 crore, assessment was framed at rupees 2 crore. Then the second component of undisclosed of total income is rupees 2 crore for each years. Problem number 1, what happens if my appeals are pending for those years? Problem number 2, would it be that the revenue will now not take the matter in revision? Problem number 3, would it be that now there will be no 148 for those years? Third problem is simple, probably they will not do 148 because everything is now part of the block. Appeal, I am not sure how they will capture, probably they will offset it, we'll come to that little later. Third, the third component, where I have filed return of income, but assessment is not framed as yet, then on the basis of my returned income. So let's say assessment year 22-23 and 23-24, I have filed returns of income of rupees 1.5 crore each. They were accepted under 143.1, fine. So that will also be added to your total income. Then next would be where for the current year, your income up to the date of search on the basis of your books of account, records and documents. Therefore, whatever is quote unquote likely to be disclosed income, let's say rupees 1 crore, that will be added. Now obviously all this cannot be taxed at 60%. There will be some adjustment. What we have missed out or what legislature have missed out is one major year, namely the year in which return of income is not due. Please see, if the search takes place on 1st October 24, for all those assesses where the returns of income are due on 31st October 24, returns for assessment at 24-25 may not have been filed. Now, in relation to the search year, there's a deeming fiction, whatever is disclosed by you or whatever is to be found in your books of account, that would not be taxed at 60%. But for this missing year, there is no provision. Now, assessing officer is required to assess income of the block period, meaning that by 6 years plus the broken year. Out of 6 years, the 6th year is the year where return of income was not due, therefore you have not filed. Now assessing officer, if he starts assessing you for the 6th year, even if he finds there was no possibility of undisclosed income, he accepts what you filed as your regular return of income, the rate of tax applicable will be 60%. That's problem number 1. Problem number 2. Now he is going to reassess your income for all 6 years. He will again assess the income. Now there are 2 possibilities. He will find some undisclosed income on account of some entries, some bogus expenditure, some loose sheets. Income may not be disclosed. Rate of 60% is applied. I can understand. But let us say in assessment year 1920, 2021, you had claimed certain expenditure, which after detailed scrutiny was found to be genuine, and it was accepted. In the meantime, law is amended. In the meantime, High Court has taken a contrary view, or Supreme Court has taken a contrary view. So now that assessing officer has a power to touch your assessment again, he will disallow the expenditure. This is not a bogus expenditure. This is not a bogus claim. This is not a bogus allowance. This is not a claim of bogus exemption. But by virtue of a deeming fiction, if you recall, I started at the beginning, anything that you had claimed, which is found to be not allowable, because it's not a correct claim, would now attract tax at 60%. So, let's say there is an assessment made 4 years back or 5 years back, or assessment of 5-year-old, 143.3 after detailed scrutiny. It cannot be even reopened today. It cannot be reopened because it will be a change of view. It will be no failure on your part to disclose truly and fully all material facts, so on and so forth. You will have multiple arguments. Here case gets automatically reopened. And not only it gets automatically reopened, now revenue officer has a handle to examine all your assessments again. And if he finds any claim of expenditure, allowance or deduction, he believes they are not to be allowed now, he will disallow and tax you at 60%. And therefore, the scope of undisclosed income is now wide enough to cover not only undisclosed income, income which is now being assessed artificially as undisclosed income, which was never undisclosed. It was in the knowledge of the revenue. So now we have got 6 years and a quarter income taken together. But obviously this is not to be taxed at 60%. Therefore what they do is, out of these 5 items, returned income, income assessed, income not assessed but already offered for tax and for the broken period, and income ultimately assessed, of 3 items will be eliminated. And on the balance, tax will be taken at 60%. So which are the 2 items? Returned income, returned by you as undisclosed income, and income assessed. Otherwise, you will get credit for income disclosed in the assessed, completed assessed income, or wherever you have filed return of income, or for the broken period. So if you file return of income of, let's say, rupees 2 crore as undisclosed income, and assessing officer ultimately finds your undisclosed income is not rupees 2 crore but rupees 4 crore, so 2 crore plus 2 crore, 4 crore will remain. Intervening 3 items will be taken out. The whole complex mechanism of including and taking out is for the purpose of enabling revenue to again process closed and concluded assessment. So Abhisar Builder, which said closed and concluded assessments cannot be touched unless there is information available to you that there is undisclosed income, which is information is found at the time of search, would not be applicable. And old block, which said undisclosed income alone can be taxed, again would not be available. so that there is no controversy as to what is undisclosed versus what is disclosed. Now everything is to be taxed. Now there are two more problems. One, within the block period, set off of loss is not to be allowed. So what will happen would be, let's say in year 1, you have a loss of rupees 3 crore. In the next year, you had a profit of rupees 4 crore, you set off the loss, you are paid tax on rupees 1 crore, your income was 4 crore. Now that within the block period, set off of loss is not to be allowed, that 3 crore loss will go away. And now you will be required to pay tax on rupees 4 crore minus 1 crore, meaning thereby 3 crore at 60%. One more problem, opening loss would not be allowed. Therefore, suppose in this case, in right up to assessment 89, 90, you had a loss of rupees 10 crore, which you were carrying forward and setting it off, now it will be kept aside. Block income to be assessed on its own, that 10 crore loss would jump 6 years or 7 years and would be allowed to you after the block period. Which would mean that an SSE was not required to pay tax, and still SSE has to pay tax, and that too at the rate of 60%. 158 BD, old scheme practically continues, so I am not going into greater detail. 158B, the time frame. Now, the assessing officer will, so before that, 158BC, return of income to be filed. Return of income has to be filed within a period of 60 days from the receipt of the notice to file return of income. Number 1, no extension. Number 2, no power of filing revised return. So within 60 days, you shall file return of income. And I would, for a reason which I'll go little later, immediately point out, you are well advised to file return of income, because if you do not file return of income, the consequences are serious. When we go to penalty, we will see that. So you have to file return of income. Once you file return of income, there is no 143(1). The assessment will be only by jurisdictional officer, no faceless assessment, no DRP. The assessment will be made, and against that you will have a right to prefer appeal to the appellate officer. If there is a demand, section 132B, appropriate recovery would be made by making use of the seized funds. Section 158B requires that within 12 months from the end of the month in which the last authorization is issued, notice will be issued, and once notice is issued, assessment will be framed. However, now there is one more additional 6 months, up to 6 months time is given to the revenue. Time taken by the search party to hand over books of account, documents and seize record to the assessing officer will be excluded. So search takes place, ultimately books of account, document, etc. will travel to the assessing officer. That time would be excluded. Time will begin to run only from the date on which the jurisdictional assessing officer gets the document. Only problem would be that SSE will never know how much time actually is taken. So SSE must be vigilant, should be vigilant, get information under Right to Information Act so that it knows as to when documents reach, so that you can really take care of the limitation period. Now comes the issue of interest. There is no 234A, 234B, 234C interest. If you do not file return of income, even within 60 days, because belated return is not accepted, there will be obligation to pay interest at 18% per annum for the period commencing from the end of the month in which notice was issued till the month in which the assessment order is passed. But the second sub 158 BFA2 subsection 2 is interesting, and that is the penalty, which requires some discussion. Penalty is at 50%. So rate of tax is 60%, penalty 50%, you will be liable to pay tax and penalty at 90%. However, if you satisfy 4 conditions, there will be no penalty. 1, you have filed return pursuant to the notice. So here comes the importance of your obligation to file return. So 1, you have filed your return. Second, where in the return you have disclosed what you believe is your undisclosed income. You have paid taxes. Whatever taxes are payable, you have paid taxes, or, now this is a concession, or given on the basis of assets seized, given enough security. Because what might happen might be, SSC might be able to say, I did not pay taxes because I did not have money, everything was seized by you, so you have to give security. And fourth, after assessment is framed, you do not file appeal challenging what you have disclosed. Now this is very important. I might make a disclosure of income while filing block return of rupees 2 crore. Ultimately, assessment may be framed at rupees 10 crore. They do not say that don't file appeal at all. What revenue says, don't file appeal challenging your disclosure of rupees 2 crore, you may challenge rupees 8 crore. Now, if you satisfy these 4 conditions, you get immunity from penalty. But this is important. You get immunity from penalty not only under section 158 BFA 2, you also get immunity from levy of penalty under section 271D, 269 SS breach, 271DA, ST breach, and 271E, 269T breach. So cash loan given, cash loan returned, that is okay. They also give you immunity under section 271 AAD, the new section which was introduced couple of years back for the purpose of levying penalty, where it is found the books of accounts of the SSC contain bogus entries, non-genuine entries, etc. Now, at the time of search, when books of accounts are found, it is more than likely that some of the expenses may not be found to be genuine, some of the entries may not be found to be genuine. Section 271 AAD penalty would otherwise be automatic. If you satisfy these 4 conditions, then you get immunity not only from penalty in relation to the disclosed, undisclosed income now disclosed, you also get immunity from these 4 penalties. So there is one interesting issue that I am putting across for your consideration. I am searched. I filed return of undisclosed income only of rupees 1 lakh. Pay tax of rupees 60,000. They may assess me at rupees 20 crore. I may challenge 19 crore, 99 lakh. But I have satisfied all the 4 conditions. Please see the 4 penalties. 271AD, 271D, 271DA and 271E are not income specific. They are transaction specific or event specific. Acceptance of loan, acceptance of some other money, repayment of loan, or bogus entries in the books. Would it be possible for the SSA to say that moment I file return of income in time, moment I pay taxes, and moment in spite of further additions I do not challenge what I have disclosed, these 4 penalties are out? Language of the section as it stands today would give right of to an SSC to argue this. I do not know whether this is an intended benefit or unintended benefit, but today an SSC may be able to claim that if I file returns of income, etc., don't levy penalty. It is for this reason filing of return of income is extremely important. Albeit if you file return of income and there are additions over and above your returned income, then for the differential amount, penalty under section 158 BFA 2 of 30% will be levied. I am not saying no to it, but these penalties are to be taken out. Assessment would be framed by an officer not below the rank of deputy commissioner. The appeal would lie to commissioner appeal and then to tribunal. And insofar as penalty is concerned, if SSA has disputed the quantum addition at the tribunal level, So long as tribunal does not adjudicate, the penalty will not be levied. In other words, the SSA would be protected from the penalty proceeding at least till tribunal proceedings get concluded. This is broadly the block system. I did not want to go into greater detail because time does not really permit us to do that. I'll answer the questions if we have 2, 3. Let me deal with answer of Jigar. Is it that this is something more beneficial? I'm not saying it is more or less, but the problem is this. Let us assume in a given case it may turn out to be more beneficial. But as we say in Gujarati, for those who are not in Gujarati, I'll translate. Doshi mareની ચિંતા નથી, જમ પેદો પડી જાય છે. See, you don't really worry about an old woman dying, but then Yamraj has seen your home and it will come again. So, section 68, 9 editions are item specific. You may have to pay tax at a higher rate, but then ultimately it is only in relation to those items or those editions. Whereas over here, if you pray for the search in order to pay little lesser rate of tax, you end up paying tax at a far higher rate in relation to far more wide of range of income, including what is not your income, not allowable expenditure. Therefore, yes, there is an anomaly. I am not disputing it. But that anomaly, I don't think anybody would love to have advantage of that anomaly. Coming to the second issue of surcharge, see, this issue was going back and forth, back and forth. Ultimately, they amended the law and said that surcharge would be levied. Over here also what they say is rate of tax would be as applicable under section 113. 113 is subject to surcharge. So one way of looking at the matter would be, while incorporating the rate, even surcharge is incorporated. Better view may be that it is not, but I don't really believe that we have much reason to be happy. The moment this is heard by someone in Delhi, they'll bring in the law. Because no benefit which is unintended ever goes unnoticed by the revenue. Even the benefit of this penalty, I would not be surprised in the next budget, they again make some changes and say, only to the extent what you have disclosed, you will get the benefit, nothing more than that. With this, let me thank you all for a very patient hearing. As the time was short, I had to make good this presentation also very briefly. If there are some questions, I'll certainly take them up. Thank you very much.
Thank you, sir. Sir, one more question was, as you said that including the this undisclosed income, now in the new scheme it has included the income which has been disclosed earlier also. So, sir, whenever an issue has been settled in favor of an assessee till the level of CIT appeal, by the time a search has been conducted and again the assessing officer wants to reopen the same issue, then whether he can do such thing or and what would be, in case he does, what would be the penalty or for?
As I said, this is one area of some concern, because what the scheme says, you make sum total of 5 items and take out 3. One of the items to be added is assessed income, and the same item is to be taken out. In other words, what you now add over and above assessed income, even for the closed assessment, is sought to be included. I don't believe it is intention of the legislature that what was subject matter of addition earlier, which got deleted, which is subject matter of further contest, should now be taxed at 60%. So then what may have to be done logically is, you add the gross at the top and take out the gross at the bottom, or you add net at the top and take out net at the bottom. You can't add net at the top, because ultimately if the addition is sustained, you have to make addition. But then if it was an addition which was an ongoing addition, subject matter of appeal, etc., my view would be that you will have to take out even from the bottom the income which is already added, because for that in any case I would be suffering, or I would have suffered penalty under section 271(1)(c). Even those proceedings may be going on. But this is one area where unless there is some clarity, SSCs are likely to be into unwarranted litigation.
Thank you so much, Shri Saurabh Bhai. Quickly, if we have any one or two questions from somebody in the audience, we can take that. Yes, please.
Yeah, I got. Yeah.
It gets frozen and it jumps. Please, please.
Assessment will not be abated. Where concluded assessment is there, then that is closed. Now no incriminating material is found. No information before the assessing officer, nothing there. Then whether the assessing officer in the block assessment say that the expenditure claimed by you was incorrect or bogus. Because 114E of the Evidence Act, like Coordinator of India Supreme Court is saying, that is presumed that under 114E Evidence Act, everything has been done in a proper manner. So whether assessing officer can claim so that expenditure claimed by you is bogus, that is.
If you go by the language of law, the language permits and in fact obliges him to tax the total income, including undisclosed income for the block period. And therefore, if you go by the language of law, he would have right to quote unquote reopen or have a relook at concluded assessments, notwithstanding no incriminating material is found. I would wish board comes up with this clarification that don't touch this. But I believe they will not do it because that is precisely the reason why the 153A, 153C, according to revenue, failed. According to revenue, if you look at the problem that they were raising, that's a judgment of Gujarat High Court of Souvenir or Kabul Chawla at Supreme Court Abhisar. Unless you find incriminating material, closed assessments cannot be reopened. Revenue always said, but then no, whether or not we get incriminating material, we would have right to relook. So that is the right that they wanted to advance, which courts say you do not have. Now that they have lost the Supreme Court, they want to reinstate that right. They want to have control to look into all 6 or 6.5 assessment years, of which first 2, 3, 4 may be closed assessment year. And therefore, whereas they should not be doing it, it will put SSA to grave inconvenience. Because if there is nothing which is found, why should they look into it? But they would not give up the power, and therefore, I don't think we will be able to challenge such an action on the ground that this is beyond their power. Unless some court takes a practical and little more appropriate view to say that this cannot be permitted. Yes, sir. Now, if you are looking at the penultimate paragraph of Abhisar, where, see, revenue wanted somehow or other to grab this power. Supreme Court probably found Kabul Chawla and Soumya governed the situation. In this close gathering, I can say that the judge who authored Abhisar had also authored similar judgment sitting in Gujarat. So he had probably found that there is no way he could have taken a different view. But a window was opened for the benefit of revenue. That if you can't go under 153A, because it's a closed assessment, you can go under section 148. Because 153A is only in relation to the incriminating material found at the time of search. Post-search, if any information is found, then it will be an information available to revenue. And therefore, time still permits, maybe you can go under section 148. Therefore, in block assessment, under 153A, 153C, only incriminating material, nothing more than that. But if incriminating material gives you a clue, let's say a piece of paper is found making some noting, but the noting leads to a diary, and diary leads to accounts, and account leads to computation of, then everything will get included. But unless I look at the tribunal order, I will not be able to comment. No, that's okay. I'm saying unless I look at that, I will not be able to answer your angle. But broadly, this is what the Supreme Court has said.
Sir, one more question, sir. Last. Actually, when SSC has passed, subsequently, the SSC premises is surveyed by the survey party from investigation department in income tax. But she is also passed. Husband passed, then husband name, the department has issued a notice, search warrant. Then the husband and wife both are passed away. The children are also passed away. But the department is insisting their granddaughter and grandchildren, 153 and 153C. In some of block assessments from 11 to 16, the CIT appeals given a clear direction. There is no addition in those cases because the SSC passed away, SSC wife passed away. There is no children, 2 children are already passed away. There is no family members of the SSC as well as the family members. And 16-17 assessment year, there is a pending with the CIT appeals. Can we claim that the earlier order of the 11 to 16 or 15, sorry?
See, unless again I look at the facts, I will not be able to give advice. It appears to be a very unfortunate family. Everybody is dying. But let me answer this. See, merely because an SSC has died, obligation of his estate to cooperate in assessment, and if ultimately any additions are made to pay taxes is not obliterated. Estate has to pay the taxes. Now, if SSC has died, his wife has died, immediate heirs have died, grand heirs probably have no information. Maybe they will be able to say we have no information. But if they have received some estate from the deceased, they would be liable. If they have not received any estate from the deceased, whatever may be the assessment, there is nothing that they can recover.
Nothing has received.
Then they can tell the department, which is, if it is Allahabad, they can go to them, go to Ganga and take the deep. Nothing can happen.
Thank you, sir. Thank you.
What can happen?
Thank you.
If I have received nothing from the estate, there will be demand of few 100 crore. How am I concerned?
Thank you, sir. Thank you very much.
Thank you so much, Shri Saurabh Bhai Soparkar. I would like to offer my vote of thanks, but before that, I would like to invite Shri Devendra Bhai Jain to please come and give a memento to our esteemed speaker, Senior Advocate Saurabh Bhai. Devendra Bhai Jain. I can request somebody from AIFTP. Yes, please, sir. I just wanted to say one thing. So earlier we had 2 panelists, Shri Padamchand Khimcha and Senior Advocate Shri Saurabh Bhai. Due to some reasons, he could not join in. Saurabh Bhai is always so spontaneous. He just told me, Jigar, just let me know what topic I have to cover as part of my discussion. And you can see, the threadbare analysis that he does on any subject that you give him. I think we were all enlightened by the, his address on the block assessment and giving us some wonderful insights on the things that we need to take care of and how the revenue has addressed them. So thank you once again, Shri Saurabh Bhai Soparkar, and thank you everyone for joining in for the session. We will now be heading over for lunch, and post-lunch, sharp at 3 p.m. we will be starting with the next session, which will be given by Advocate Uchit Sheth. Thank you.
the session.
Good afternoon, everyone. Samir Bhai, President-elect AIFTP, all the other organizing team members, and all the delegates present here. The topic which is allotted to me would essentially have to be broken up into parts. First is refund, second is issues in section 16(4), third is issues under section 128A, and fourth, issues in section 73. The first part of the session is regarding issues in refund. Now, in the inaugural session, much was said by Justice Bhuyan and thereafter by other speakers on that famous line by Benjamin Franklin, the founding father of USA, that nothing is certain except death and taxes. Now, in the context of refund, if we extend this a bit further, getting refund from the government treasury would be like snatching life from the jaws of death. So that can be, and that is what we have practically seen also, that the moment taxes are paid, to get a refund from the government is slightly difficult unless and until it is through the automatic process as for exports on payment of IGST. Otherwise, if we need to get a refund order from the officers concerned, then it is always a challenge. So now in this context, let us discuss some of the issues which are prevalent currently, as well as some issues which have always been there but which require certain refreshment. So I will start with something fundamental to the concept of refund. Prior to the judgment of Supreme Court in the case of Mafatlal, what was argued before various courts was that any form of erroneous payment of tax needs to be refunded by the government. Suppose in my assessment a liability was made. I paid that tax. I did not challenge that assessment in appeal. Some other SSE went in appeal or went by filing a writ petition before the court. Eventually on the issue it was held that tax is not payable. Other SSEs would also line up and say that this is tax which is wrongly paid, which is erroneously paid, and therefore kindly also grant us refund. There were multiple judgments of Honorable Apex Court taking contradictory views. Some courts, some decisions took a view that yes, if it is an erroneous payment, it is violating Article 265 of the Constitution, so refund has to be granted to the SSE, irrespective of procedure, time limit, etc. Mafatlal, the Constitution bench of the Supreme Court, clarified this issue beyond any doubt. Mafatlal said that under the Excise Act, refund is to be claimed under section 11B of the excise law. Supreme Court said that when Article 265 says that no tax shall be retained without authority of law, section 11B is also law. So in order to claim refund, unless and until you fulfill the stipulations of the provision under which the refund is to be claimed, refund cannot be granted. So although the tax may have been erroneously levied, it may have been held by the Supreme Court that no, this transaction is not taxable. Even then, if you accepted your assessment or adjudication and you had paid the tax, the time limits had expired, then you are not entitled to refund. So this is one of the very fundamental principles which we need to keep in mind, that if at all there is doubt that whether this tax is payable or not, suppose conservatively the SSE has decided to pay up the tax, some other SSEs are litigating on the matter, and we want to keep our rights of refund alive, then we have to first follow the procedure under 54. So we need to file the applications within time. If the applications are rejected, we need to file appeals in time. If that is done, and eventually if some other SSE succeeds on merits, then we will be eligible for the benefit of that judgment, not otherwise. So that is something which is fundamental to the entire jurisprudence of refund. Some exceptions have been carved out. One of the exceptions was carved out by the Supreme Court in Mafatlal itself. If suppose the virus of the provision itself is under challenge, if suppose the statutory provision or a notification was under challenge, and that law itself is struck down as unconstitutional, then Supreme Court said that in such a scenario, the refund of such tax does not come within the purview of the statutory framework. Because in such circumstances, the statutory authority cannot grant a refund on the ground that the act has been declared to be unconstitutional. So Supreme Court said in such a scenario, you can file a refund either by way of a suit or by way of a writ petition before the High Court. So one of the few exceptions to the general principle that Section 54 needs to be followed for the purpose of claiming refund under GST is in a case where a provision is held to be unconstitutional. A recent example is in the context of IGST paid on ocean freight, where Supreme Court in Mohit Minerals held that it is the levy itself is banned. In such a case, even if we have missed filing refund application within the stipulated time period, we can approach the High Court by way of a writ petition and say that the tax, the very notification is struck down, so kindly grant me the refund. One more exception where people have tried to plead and some courts have agreed to it is in a case where it is as such not a payment of tax, but it is mere deposit. Suppose I have not admitted to that liability. The authorities came and through the form DRC3, they made me deposit that tax. In such scenario, many SSEs are taking a claim that this is not payment of tax, this is deposit of tax, and therefore the rigors of Section 54 will not apply. So those can be some cases where we can try to wriggle out of Section 54, but as a general principle, we need to follow the timelines and the procedure of Section 54 for claiming any refund. Next fundamental principle to any refund claim is the principle of unjust enrichment. This is not flowing from any provision. Even if suppose a provision is not there, still authority can deny refund to an SSE on the ground that the burden of tax has been passed on by him to someone else. So you have not borne the burden of tax, therefore you cannot be unjustly enriched at the cost of the state exchequer. Now in this context, again some jurisprudence has developed. Suppose I have passed on the burden to someone else. That person, the buyer, if he believes that the tax is wrongly charged and paid, whether the refund can be granted to the buyer and not to the seller. Now here, recently some of the decisions of Gujarat High Court hold that if a buyer has borne the tax and that tax is illegal, then refund can be granted straight away to the buyer. So even though the SSE per se is the seller, it is the seller's liability to pay the tax, but because the tax burden has been shifted to the buyer, and if the buyer makes a refund claim, then that refund claim can be entertained. Another judgment which is very recent is a case, it is a case of an electricity company where again Admittedly, the tax had been passed on by way of increase in the electricity tariff. The tax was held to be illegal. The electricity company filed a refund claim with an undertaking that please give us refund, we will pass on that refund to our consumers by way of reduction in tariff. Authority said nothing doing, since you have passed on, principle of unjust enrichment applies, you cannot get refund. The electricity company filed a writ petition before the High Court. Gujarat High Court recently has held that ultimately this is a principle of equity. Because if suppose on unjust enrichment the refund is barred, then amount goes to the consumer welfare fund. So High Court says that if instead of the general fund, if it goes to a particular class of consumers who have actually borne the burden of tax, then that is a more equitable and justifiable solution to the problem, and therefore the electricity company is allowed to take refund and pass it on to the consumers. Now we come to certain, so these two are the basic, I would say general principles that would govern any refund claim generally in any taxing statute. Now we come to certain issues on the basis of interpretation of section 54. Now what is commonly believed by us tax professionals is that ordinarily refund claims are more or less under section 54(3), which is regarding inverted duty structure, or in the case of export. So the ordinary belief is that in those two circumstances, refund can be granted or claimed, in no other circumstance. We need to be aware that the first section, section 54 subsection 1, says that refund is to be granted of any excess payment of tax. Now this can have number of examples. This is one of the live examples which happened. The SSE was a trader in cotton. He had purchased cotton from farmers and sold to registered traders. In 1 month, instead of showing the amount of tax on the reverse charge, because on purchase from farmers, GST would be applicable on reverse charge. So instead of showing that reverse charge liability, he paid the entire output tax through the electronic cash ledger. So the mistake which he made was that ordinarily if suppose 100 rupees of output tax liability was there, 80 rupees reverse charge on purchases, 20 differential through cash ledger, total 100 he should have paid. Instead of showing that bifurcation, the complete 100 rupees he paid through the cash ledger. After 2 months, he realized this error. Now, under GST, as we all know, there is no mechanism for revision of the return. The rectification can be done only in the month in which the error is detected. So, after 2 months, when he realized this error, he needed to show that reverse charge liability again in that month. So, what happened was that after 2 months, he had to show reverse charge liability for 2 months and output tax for only 1 month. So in total, the amount of tax which he was required to pay, he paid almost double that amount of tax. Because he paid the tax subsequently, he could not adjust that input tax credit against the output tax liability. So there was duplication of tax liability. He corrected this error in returns and then filed a refund application. Authority said that there is no excess payment in such a case, we cannot grant you refund. Writ petition was filed before the High Court. High Court took a view that ultimately you need to see what is the actual amount of tax he should have paid in those 2 months and what is the actual amount of tax which he has paid. For this, we forget all these jargons of cash ledger, credit ledger, etc. Simple arithmetic, what is the amount of tax he should have paid, what is the amount of tax he has paid. If it is excess payment, you grant him refund. The department relied on the Supreme Court decision of Bharti Airtel. Bharti Airtel was a case where Bharti Airtel approached the High Court, Delhi High Court, for permitting rectification of the very same return in the very same period, thereby allowing it to shift the payment from electronic cash ledger to electronic credit ledger. Delhi High Court allowed the plea. Supreme Court said nothing doing. Section 39 is very clear. There is a clear procedure prescribed for rectification. So we cannot permit the SSE to rectify its returns in any other manner for the purpose of swapping this mode of payment. However, the Gujarat High Court, while noting this submission, took a view that Bharti Airtel was not a case pertaining to as such refund in that sense. The company wanted to rectify the very same return. Here is a case where it is not a case of rectification of return. Rectification of return is permitted. However, as a result of the rectification, if tax is found to be paid in excess, then that needs to be refunded. So this is something which we need to keep in mind, that refund is not only in cases of inverted duty structure or exports. There can be multiple examples where there can be issues of refund, and section 54 subsection 1 is very wide. It says that any excess payment of tax needs to be refunded. So if excess payment of tax is found, then that needs to be refunded under section 54 subsection 1. Next we come to section 54 subsection 3. One of the clauses is relating to inverted duty structure. Now again, this provision has been debated, deliberated since the GST has come into force, because there are multiple industries, multiple products where there is inverted duty structure. The first litigation, one of the very first litigations on this provision was whether refund of input services is also admissible under section 54 subsection 3. Because the relevant clause read that refund would be allowed only if the unutilized input tax credit is on account of rate of tax on inputs exceeding output supplies. Gujarat High Court took a view that despite such a provision, the moment there is inverted duty structure, what needs to be refunded is the entire amount of unutilized input tax credit, and therefore even credit pertaining to input services needs to be refunded. Department went in appeal before the Supreme Court. Supreme Court, in the case of VKC Footsteps, took a view that we can't go by any assumptions, presumptions, equity, etc. The section is very clear. Section says that only if rate of tax on inputs exceeds output supplies, only then can refund be granted, and therefore no refund can be granted for input services. However, one of the other arguments in this case was that in any case the formula is defective for granting this refund, because it presumes that the entire output tax comes out of first the input tax and then input services. So suppose 50 rupees of input tax is pertaining to inputs, 50 rupees pertaining to input services, and I pay 80 rupees of output tax, then it is presumed that first 50 of inputs is utilized, then balance 30 of input services is utilized, so 20 rupees remaining is pertaining to input services. Supreme Court said that this is an anomaly. However, we will not rectify this, and therefore Supreme Court directed the GST Council to look into this matter. The GST Council in its 47th Council meeting recommended amendment of the formula. It noticed that yes, there is a discrepancy in the formula and therefore it needs to be amended. The amendment was made by notification dated 5th of July 2022. Admittedly, the notification was given a prospective effect. It was not mentioned in the notification that the notification will apply retrospectively. Circular was issued saying that the new formula will apply only if the refund application is filed after the date of notification. This circular came to be challenged, which has been recently struck down by the High Court by holding that the amendment in the formula was only curative in nature. It was in the nature of rectification of the formula pursuant to the directions of the Supreme Court and the GS. So even though the notification said that the amendment will apply only from the date of notification, by way of mode of interpretation, Supreme Court held, the High Court held that it is only curative in nature and therefore it will also apply to past periods. So law as on now, at least in the state of Gujarat, is that if any refund has been granted even as per the old formula, and I am entitled to differential refund as a result of the new formula, then I can claim that differential refund, subject of course to that time limit of section 54 subsection 1. Because as I said, even High Court noticed that in this case, the refund, second refund application was within that 2-year time limit. So subject to time limit being available, the new formula will apply retrospectively. Another offshoot of this litigation that is still ongoing, it is more prominent in the fertilizer industry. While in VKC, the government took a stand that equity has no role to play in taxation. Ultimately, you have to go by the formula for refund which is prescribed. And that view was affirmed by the Supreme Court. The department in many cases is now taking a contrary stand and saying that, look, forget the formula. On a general computation, we feel that this refund is not as a result of inverted duty structure, but due to some other reason, and therefore we will not grant you the refund. So in the case of fertilizers, the government gives subsidies. The subsidies are reduced from my transaction value, and therefore my output tax goes down. So the authorities are taking a view that because the refund is arising mainly because of subsidies and your output tax going down because of that, even if you fall under the inverted structure and even if as per the formula there is refund due, still we will not grant you the refund. This issue is now before the Gujarat High Court as well as Karnataka High Court. It has been placed before the council also, but there is no resolution. In my view, the government cannot change its stand depending on what is beneficial to it. Once it has taken a stand that formula is a formula, once you are under inverted structure, then refund has to be calculated by the formula, whether it causes loss to the government or loss to the SSE, then that needs to be applied across the trade, across all situations. So the moment inverted duty structure, the condition is satisfied, then you forget everything else and you apply the formula and refund has to be granted. There cannot be approbate and reprobate by the government. Now, in line with this same issue of the retrospective application of the formula, one more litigation which has been faced by a number of SSEs is in a case where refund application is filed, refund is granted by the authority, thereafter it is noticed that further refund is due to me. Question is whether a second refund application is permissible or not. The view of the authorities has been that once refund application is filed, then we will not permit the second refund application for the same period. However, there is no legal embargo, there is no statutory provision which says that there cannot be multiple refund applications for the same period. So, if it is found that further refund is available for the same period, and if the time limit of 2 years has not expired, then there is nothing in law preventing the SSE from filing a second refund application. That has been now made clear by a number of decisions of the High Court. So again, according to me here, there cannot be any scope for doubt unless they bring a provision which says that for one period we will only allow a single refund application. Till that point of time, they cannot object to multiple refund applications for the same period. Next is issues on export refund. First, in this category now already stands settled. There was an issue when the GST regime was initially introduced. A number of exporters did not know that if I claim higher duty drawback, then I am not entitled to export refund of IGST. Many exporters claimed both the benefits, then notices came to be issued for withdrawal of the IGST refund. Petitions were filed. Ultimately, the High Court took a view that if the exporter is ready to give back the differential amount of drawback, then IGST refund has to be granted. Supreme Court affirmed this view of High Court in the case of Amit Cotton Industries. Now, the ongoing litigation, so according to me, this part of the issue is already resolved. Ultimately, what needs to be seen is that effectively whether I have taken higher duty drawback or not. If effectively higher duty drawback is not taken in a way that differential drawback has already been given back, then refund of the entire IGST paid on exports needs to be given back to me. What is ongoing is the controversy concerning Rule 9610. Now, Rule 9610 is a rule, or was a rule I should say now, because now it stands deleted. Rule 9610 was a rule which said that if an exporter is importing goods under the notifications as mentioned therein, then he will not be allowed to make exports on payment of tax. Now again, due to ignorance or due to trade practice, a number of exporters had exported on payment of tax, even though they were importing against advance authorizations, etc. Notices came to be issued on the count of breach of Rule 9610. Therefore, the virus of Rule 9610 came to be challenged. Well, petitions are still pending before the Gujarat High Court. Kerala High Court recently, in the case of Sands Laboratories, has struck down this rule on the ground that it is contrary to Section 16 of the IGST Act. It is held that once Section 16 of the IGST Act says that refund is to be granted of IGST paid on exports if that option is opted for by the exporter, then by a rule, this option cannot be negated. It has been held that when section uses the phrase that refund is to be granted subject to conditions and restrictions, the conditions and restrictions cannot negate the very refund. This is till date only the view of Kerala High Court. It is likely that it may be either challenged before the Supreme Court or Council may take up the issue again for review. For now, prospectively, this rule has been deleted. So for the prior period, the issue still remains in other states. Kerala now, because of the jurisdictional High Court decision, may be safe for now. For other states, the issue still remains that if there is a breach of Rule 9610, then whether the refund can be granted or not. In the Gujarat High Court, when these petitions were argued, one of the other contentions which we had taken was that forget Rule 9610 or its breach. Because there were a number of cases where even if we had opted for the second option of exporting against LUT, still the amount of refund was more or less the same. Or it was slightly on the lower side, but it would not mean that the entire refund amount would have to be given back. So another contention which we took was that even if there is a breach of Rule 9610, at the most what the department can take back is the excess amount which has been refunded as a result of this option. It cannot be that I am not even given the option of refund under the LUT scheme. But as I said, these are now still issues in the open. We do not know ultimately what stand is taken. This is regarding interest on refund, but I think we can skip that. We'll move now to the next topic because I intend to at least have a glance over all the 4 parts of the session. Next part of the session, the second part, is regarding Section 16(5) of the CGST Act, which has been recently introduced. Now in this context, first we need to have a look at Section 16(4). This provision has caused a lot of heartburn for the reason that even though the input tax credit is otherwise admissible in law to an SSE, the SSE, just because he fails to claim the credit within the stipulated period, loses the benefit of that credit. Now, this is actually something which is different from the VAT laws, at least in some states are concerned. It is a provision which is more in line with what was there under the central excise regime. Under the VAT laws, in fact, the principle was that you can claim credit not only at till the stage of assessment. If suppose you are in appeal and you find that there is a new claim of credit, still the appellate authorities, the tribunals were allowing those claims of input tax credit. So this strict rigor of time limit insofar as input tax credit was not something with which everyone was familiar with. So initially there were a lot of SSEs who either filed belated returns because of which they breached 16.4, or they filed returns but they did not claim a particular credit in those returns, because of which they failed to get the benefit of the credit. Again, here the authority will have no discretion to grant the credit or not, because the provision itself debars claim of credit beyond the particular time limit. Therefore, virus of the provision was challenged in multiple high courts on the ground that one, this is a new regime which has been introduced. Two, this is the provision of input tax credit is essential to the entire GST regime, because without input tax credit there will be cascading effect which will be contrary to the very object of the GST, and therefore kindly hold that this strict imposition of time limit for claiming of input tax credit is something which is arbitrary, and therefore kindly allow the SSEs to claim the input tax credit. Now, already we were facing substantial resistance from courts on this issue. One of the reasons was judgment of Supreme Court in the case of ALD Automotive, which although in the context of Tamil Nadu VAT Act had taken a view that input tax credit is something which is granted by the legislature, and therefore it is open for the legislature to prescribe a time limit. We cannot hold the legislature guilty of arbitrariness only for prescribing a time limit for claiming of credit. So this was something which was already against us. Now, the issue became more critical because of the decision in the case of safari retreats. Now, ordinarily safari retreats is viewed in the context of section 17.5 C and D and whether the contractors etc. are entitled to credit, or whether on building construction input tax rate is admissible or not. But if you look at the decision, there are some 3 to 4 paragraphs where in a very cursory manner the Supreme Court has upheld the validity of section 16.4 of the GST Act. So now there is a difficulty. The moment the provision is upheld by the Supreme Court, rightly, wrongly, whether issue is considered or not, it will not be open for at least any of the high courts to look into the validity of 16.4 again. So unless and until Supreme Court, some other bench, larger bench decides to intervene, etc., for now the doors are closed insofar as section 16.4 is concerned, and therefore if we have not claimed the input tax credit within the stipulated time limit, we lose the benefit of the credit. If we want to claim, we need to be ready to battle up to the Supreme Court, and that too with very, very uncertain results. Just offshoots of this 16.4. One, whether this time limit is applicable to tax paid on reverse charge basis. Now here, according to me, some sort of an escapade is possible from the decisions of the Supreme Court as well as the provision. Take a case where I have not at all paid the reverse charge tax. Suppose it is a transaction of 17-18. It comes to my notice that this reverse charge tax pertaining to 17-18 is not paid, and so in 22-23 I pay that reverse charge tax. Question is whether this time limit of 16.4 will apply, and therefore the input tax can be barred or not. According to me, although the department will take a stand that even in case of reverse charge, you have to look at the year pertaining to which the reverse charge is paid. According to me, because input tax credit can be claimed only when the tax is actually paid on reverse charge basis, we can take a plea before the authorities and before the court that if I have not paid the tax, then the question of claiming credit does not arise. If the question of claiming credit does not arise, then there cannot be a question of applying time limit for claiming credit. Because time limit for claiming credit will presuppose that I have a right to claim the credit. Now, if I don't have the right to claim the credit, then whether my credit can be barred on the ground of limitation, that would be one of the issues. Another issue which has already in fact arisen is, suppose I have not claimed the input tax credit because I have claimed exemption on my output tax liability. I believe that my sales are exempt from tax and therefore I have claimed exemption and I have not claimed the input tax credit. Suppose the matter is taken up in adjudication and the adjudicating authority says that no, this exemption is not available and therefore you are liable to pay output tax. Again, in such a scenario, the best case would be, and many SSEs are doing it, that we have claimed and reversed. If that is there, then we have no problem of 16.4. If suppose in our returns, we claim the credit and reverse under 17.2, then time limit question does not arise. But suppose I have not claimed at all because my entire supplies are exempt supplies. In such a scenario, again according to me, a plea would be possible that because I had claimed these supplies to be exempt supplies, at that point of time input tax credit was not available at all. If input tax credit was not available at all, then where is the question of applying time limit? And therefore, if you charge output tax on my outward supplies, then I need to be given the benefit of input tax credit. All this with the basic principle in mind that the time limit for under 16.4 is with the object that the SSEs are not lethargic in claiming the credit. It is not with the object to punish an SSE even though at the time when he made the transaction, he could not have filed the input tax credit. So if in this context the entire provision is interpreted, then according to me, in such situations we can take a stand that limitation for credit should not apply. But otherwise, as a general principle, 16.4 needs to be now strictly adhered to, otherwise there will be a difficulty. So now next, moving to the topic, keeping in mind the difficulties which were faced by the SSEs because of 16.4, the legislature intervened upon recommendations of the council, and now by the Finance Act 2024, 16.5 is introduced, where for the years 17-18, 18-19, 19-20 and 20-21, if I have missed taking the input tax credit within the time stipulated under section 16.4, but I have filed the return before the 30th day of November 2021, then the breach of 16.4 will be negated. Now, while the legislature thought to give relief, this is a slightly half-hearted, half-baked relief. It could have, like in Tran 1 cases, it could have said that we are giving a one-time option, we are opening the portal, kindly claim all your credits which are outstanding till date, now we will not grant you any further time. But this is slightly half-hearted and half-baked, but that is what it is. So as of today, for the first 3 or 4 years, if I have filed the returns before 30th of November 2021, then the authority cannot deny the input tax credit on the ground of time limit under 16.4. 16.6 has also been introduced along with 16.5, where this is in the context of cancellation of registration. Again, this was a practical difficulty being faced, that if my registration is cancelled, how do I claim the credit? So in such a scenario, again, it is now under law it is provided that if the registration is cancelled and if now it is restored, then in such a case, the time limit for claiming of credit will be extended, and therefore if I claim the credit within the extended period, then I will be entitled to input tax credit. Now, a circular has also been issued on 8th of October 2024 for explaining these provisions or the mode of operation of these provisions. What has been explained is that if suppose this issue of section 16.4 is pending either in assessment or in appeal, then the assessing authority or the appellate authority will give effect to 16.5. So we don't need to do anything else. If suppose a show cause notice is given on the ground of breach of 16.4 and still it is pending for adjudication, if we reply and if we rely on 16.5, the authority has to give benefit of 16.5 and drop the proceedings. Similarly for the appellate authorities. However, in a case where suppose the order has been accepted by us and we have not filed appeal, or if it is an appeal order and we are still waiting for constitution of the tribunal and therefore nothing has been done, in such a case, what has been provided is that within 6 months from the date of the notification, we have to file an application for giving effect to this section 16.5, and then the concerned authority will do the needful in the matter. So again, we cannot miss the bus of this 6-month period. We need to file application. We cannot be time barred in a time barred issue. So we need to be careful about this limitation insofar as the application under 16.5 is concerned. The moment we file this application, according to me, there should not be a problem provided we fulfill the criteria. Again, as I said, it is slightly half-baked or half-hearted in the sense that again section 150 is introduced in the Finance Act, in Finance Act 2024, which says that no refund will be granted as a result of the new provisions. So suppose in a given case, as a result of section 16.4, I have already paid the tax. In such a case, I will not be entitled to the benefit of these new provisions. So this is something which could have been avoided. An SSE who thought it fit not to litigate but to pay up should not be penalized and kept at a worse position than an SSE who has not paid up. That is something which should have been kept in mind, but again what has been provided is that no refund can be granted. Now here, according to me, one issue which may arise is in the context of pre-deposits. Suppose an adjudication order is passed and I have filed an appeal and made a pre-deposit, and on the basis of 16.5, if I succeed in appeal and the order is set aside, question would be whether I will be entitled to refund of pre-deposit or not. Here, according to me, that first principle should apply. It is a pre-deposit, not a payment of tax. It was only a pre-deposit for entertaining of the appeal, and therefore the moment the order is set aside, I should be entitled to refund, and this section 150 should not apply to me. But this can lead to litigation. The authorities are likely to rely on this section 150 and said that you forget about the pre-deposit, we will not grant you any refund. Next, moving to the third part of the session, this is regarding section 128 capital A. Again, a benevolent provision which is introduced by the recent Finance Act. Considering the new nature of the GST regime, the legislature thought it fit to incorporate a sort of an amnesty scheme in the act itself. It applies only to demands under section 73, not under 74. Again, as I said, half-hearted period is 1st July 17 to 31st March 20, not for the period beyond it. Importantly, again, this is something which we need to bear in mind. The first proviso to 128 capital A says that in a case where there is a demand or a show cause notice under section 74, and if the authority or the appellate authority converts it into section 73, then also this benefit will be available. Also, insofar as the timelines are concerned, while if the demand is originally under 73, then I will have to make the payment of tax by 31st of March 2025. If the demand is under 74 and converted into 73, then I will have to make the payment within 6 months from the date of passing of such an order. So, this is something, because there has been a general impression that for 74 cases, it is a problem, we'll have to approach the High Court because it is a time-bound scheme, etc. But the legislature has been careful. For 74 cases converted into 73, the time limit also gets automatically extended. So if I succeed in converting from 74 to 73, then I will be given 6 months further time for paying up that tax. If the tax is paid, then interest and penalty will be waived again no refund to be granted. Now here also, again, this scheme is not applicable to cases of erroneous refund. So this 9610 etc., the benefit will not be granted because those are cases of erroneous refund. Here also a circular has been issued by the board where some important clarifications are given. One, if I have already deposited the tax, the circular expressly says that that tax will be adjusted against your payment to be made under the scheme. So if I have already paid the tax either through DRC3 or against an order, all those amounts which are paid will be considered under the scheme. So I will only have to pay the differential amount. However, a specific clarification is given that if suppose at the time of search I paid some tax with interest and penalty. So the amount was paid under the heads of tax, interest and penalty. Then under the scheme I can only get benefit or credit of the amount paid under the head of tax. So whatever interest penalty, whatever has been paid under interest and penalty, that credit I cannot get against the payment to be made under section 128 capital A. All the appeals writ petitions need to be withdrawn before the notified date, which is 31st of March 2025, and the application is to be made with 3 months thereafter. Again, I may clarify, this is only where the basic demand is under 73. This will not apply to cases where 74 is converted into 73. One more benefit which is given is that if that case also involves 16(5) issue, so if suppose it is a demand under 73, where one of the issues is time, the demand because of time barring of credit under 16(4), and if I am entitled to benefit of 16(5), then that is to be deducted while deciding the amount which is to be paid under 128 capital A. So as such, it is a combined scheme where 16(5) and 128 capital A are to be seen together, to be clubbed together, and in such a scenario, in fact, it is specifically clarified that even the procedure for 16(5) need not be done. So it is to be treated as if it is a 128 capital A issue, and only the amount which remains after deducting the amount for 16(5) should be paid. Now, one very serious issue in this provision is in the context of bunching of show cause notices. Now, we will again split this into two parts. One, we forget the scheme, generally whether bunching of show cause notices under GST is permissible or not. Now, VAT lawyers are very accustomed, or even the SGST department is very accustomed to framing year-wise adjudications. Even after GST, this has continued. However, under excise, under service tax, and therefore as a necessary consequence under central GST, the authorities have been issuing notices for multiple periods together. So the show cause notice will be from 1st of July 2017 till 31st of March 2022. Question is whether that is permissible or not. According to me, strictly there is no embargo against issuing such joint notices. They cannot extend the time period by issuing joint notices. It cannot be that the last year is within limitation and therefore they issue notices for the entire period by taking benefit of it. Limitation will apply year-wise, but as a matter of procedure, there is no embargo against clubbing of notices. Be it as it may, Madras High Court in the case of Titan Company has taken a view that bunching of notices is not permissible. Year-wise notices are required to be issued. According to me, insofar as general assessment adjudication is concerned, this is slightly academic, it does not make any difference. But insofar as 128 capital A is concerned, it will make a difference because it is expressly clarified that the 128A benefit is available only for the period from 1st of July 2017 till 31st of March 2020. However, if it is a consolidated notice from 1st of July 17 to say 31st of March 2023, and if I want to take benefit of the scheme, then I need to pay the entire tax for the entire period. And still, I will get waiver only for the first 3 years. This, according to me, is a serious issue. Merely because the authority has bunched together the notices, that cannot mean that I need to pay a higher amount for the purpose of availing benefit of 128A and still not get waiver for the subsequent periods. So this is a case where, according to me, if this is a scenario, then we will have to approach the High Court to look into the matter, because merely because the authority has bunched the notices, I cannot be made to pay more amount under the scheme. Last session I will quickly wind up because of shortage of time. The last part of the session is regarding section 73. While although we may feel it is procedural in nature, it also has certain nuances. It is a section regarding determination of any short payment, non-payment of tax or erroneous refund. First thing we need to understand is that section 73 subsection 1 is not a charging provision. Therefore, there cannot be a charge of tax on the basis of section 73. This is important in the context of interest, because although under section 73 subsection 1, it is said that any non-payment, short payment of tax or erroneous refund needs to be paid along with interest and penalty. As such, under section 50, there is no specific provision providing for charge of interest in cases of erroneous refund. So an issue which will arise is that merely whether based on section 73, dehors section 50, whether interest can be levied on cases of erroneous refund. Again, there are multiple judgments of the apex court taking a view that interest is a substantive provision. There cannot be any purposive interpretation of an interest provision. If the provision is there, interest can be imposed. If it is not there, it cannot be imposed. Similarly, section 73 says that erroneous refund can be recovered by the authority. Question is, if suppose there is a refund sanction order passed under section 54, which is not reviewed, not appealed against, not taken into revision, in such a scenario, whether straight away the refund can be recovered under section 73 or not. Multiple petitions are pending before high courts. In this context, in the reverse scenario, if suppose I had paid the tax pursuant to an assessment order and I had not challenged it and I filed a refund application, Supreme Court in the context of Customs Act, Priya Blue Industries took a view that straight away refund application cannot be filed without first filing an appeal against the assessment order. Applying these principles, Honorable Tripura High Court Justice Qureshi from Gujarat took a view that same principle will also apply in the converse, and therefore if there is a refund sanction order and if it is not appealed against, then that cannot be straight away recovered under the provisions of 11A and therefore 73 of the GST Act. So this is one dispute which is likely to be there, that if refund sanction orders are accepted by the department, then without filing of appeal or taking them into revision, straight away whether 73 notice can be issued or not. This is again another corner provision of GST which many of us may for the timing not even have dealt with. 7511 says that if any appellate forum has given decision prejudicial to the revenue in any matter, an appeal against such decision is pending, such time period is to be excluded while computing limitation. So an SSE in Kerala who is fighting a litigation on rate of tax on some product, ultimately, after 15 years, the Supreme Court takes a view that no, this product is taxable at 18%. I in Gujarat have been paying tax at 5%. Suppose, so whether on the basis of this provision, for 15 years together, 73 notice can be issued and tax can be demanded or not. So this is something which, yes, so in fact this issue was also there under the VAT Act. The Gujarat High Court took a view that this cannot be, I mean, such a provision and such application cannot be there. In fact, there they tried to apply this and recover the demands for multiple years. Gujarat High Court said this is something which is arbitrary. This cannot be the implication of such a provision, and therefore that provision was ultimately struck down by the High Court, confirmed by the Supreme Court recently in the case of Tirumala Constructions. Tirumala Constructions does not go on this aspect. However, if you look at the Gujarat High Court judgment in the case of Reliance Industries, this aspect has been dealt with, and it has been held that there needs to be some end to any sort of litigation. A businessman needs to be sure of his tax liability. 3 to 5 years, that can be a reasonable period for which the assessments can be reopened or demands can be raised, but nothing beyond that, anything beyond that would be arbitrary. And so this is again a decision which is of some consequence. Right. But according to me, they will rely on 7511 to say that no, it stands extended. So this litigation, right? But correct. But so if that is how it is interpreted, nothing like it. If it is not so interpreted, then we have a judgment in our support, taking a view that there cannot be an unreasonable extension of any time limit. Last, I will just end by this one more issue on 73, is regarding 73 subsection 5, where suppose we have made the payment of tax with interest by DRC 3 under 73 subsection 5. Authority says that no, this is a case of evasion, so you have to pay 15% penalty. Now here, according to me, if we on our own have paid under 73 subsection 5, then authority cannot say so. He has to accept this payment under 73.5. Suppose the authority has already issued DRC 1A, where he has said that you pay tax, interest and 15% penalty, and then I will close the proceedings. Then according to me, it will be difficult for us to say that no, we will only pay the tax and interest because according to us it is a matter of 73. This is a sort of, again, a settlement scheme. If we are not happy with that 15% penalty, then we will have to go for further adjudication and establish that no, it is not a case of 74, it is a case of 73. So if authority has already issued DRC 1A, then either we pay 15% and close it, or we litigate further and establish that it is a case of 73. If, however, we have already deposited under 73.5 and then authority comes up and says, no, this is 74 case, you pay 15% penalty, then we would have some case. But again, this will be slightly difficult because courts are also likely to say that ultimately this is sort of a benefit of waiver given to you. If you are very confident that this is a case of 73, then you fight it out in litigation, then you don't go for settlement. So that is an issue which is practically faced, and this is how it will have to be interpreted. Thank you very much. Although these are all, as I said, slightly, these are not substantive provisions in that sense. According to me, these provisions also have enough nitty-gritties for us to keep those issues in our mind while we file our returns or litigate in adjudication or appeal. Thank you.
Thank you, Ujit Bhai. Despite of so many favorable decisions, I think the refund process would be frustrating for a taxpayer. I agree to that. I would request Raju Bhai Udani to offer a memento to Ujit Bhai. Raju Bhai. Thank you, Ujit Bhai. We would like to recognize the presence of Shri Dinesh Mohan Sinha sir. He is a judicial member, ITAT Rajkot bench. I would request Shri NP Jain sir to please offer a bouquet to Dinesh Mohan sir. I would request NP Jain sir to please offer a bouquet to Dinesh Mohan Sinha sir. Thank you everyone. Now we are starting with the presidential session. Just few minutes after the stage is set. I would request Mr. NP Jain, Mr. Pankaj Ghia, Mr. DK Gandhi, Dr. Ashok Saraf, Mr. PC Joshi, Mr. Dr. K. Shivram ji, Prem Lata Bansal ji, Nikita Badeka ji, Mr. M. Srinivas Rao, and Mr. Shamir Jani to please come on the stage.
एक पेन ले लो मेरा. मेरे को फोन पे ले चाहिए मेरा सब फोन में. Good afternoon, everybody. Before we start a very important session of orientation by the past president, I'm assigned a very important duty of announcing the awardees for the year 2024. And I would request whoever are there, including all of their zone persons, please come forward and take your awards. Ready? The first is AIFTP Best Conference Award, sponsored by Raka Public Charitable Trust. It goes to Central Zone for the Ujjain Conference. Navlakha ji and the entire team, please come on the dais. Come, all team, please come up. आ जाइए. Thank you, please. The next is AIFTP Best Seminar Award. This is also sponsored by Raka Public Charitable Trust. This goes to Vadodara West Zone. Please come, the entire team. Bhaskar Bhai and team. All the West Zone team, please come forward. May I request PC Joshi sir to give the award? We will use the facility of the past president present here. Thank you. The next is the Best Zone Chairman Award. This goes to Ramanju Srinivas Rao. Ramraju Srinivas Rao of South Zone. Please come. This is an individual award, but it is a team which makes it best chairman. May I request Shivaram sir to please. Can we have best zone chairman, please? You are there, but photograph can be taken later on, please. Let the function be over, please. All right, please. Please, sir, everybody. Please help us in finishing this in a record time. Please, sir, please, whoever is there. Next is an important individual award for the maximum participation. This goes to Pradosh Patnaik, Eastern Zone. Pradosh ji, come fast. May I request Premlata madam to please do the honors. अच्छा, last year भी उनको मिला है. My God, don't do hat trick. Next. उसके आगे भी मिला है. This is a hat trick. Yeah, big clap for him. The next is the best vice chairman award. It goes to Mahendra Gargia, Jaipur Central Zone. Is he available? Please, sir, please come. Gargia ji. Gandhi sir, please do the awards. Please give the awards. Nahi zarur. Come on. The next is outstanding contribution. Sorry, sir. Outstanding contribution to the development of text, Rajendra Arora ji. As I understand, he is not here. Rajendra Arora ji is not there. Then best upcoming speaker, Shefali Girdarlal. She's. Are Rajendra Arora, Mr. Arvind ji is taking on his behalf, please. Rajendra Arora's award. Okay, it's already taken over by somebody. Then best upcoming speaker, Shefali Girdarwal. She's also not there. All AIFTP Best Zone Award. This is going to South Zone. Come on fast, entire team. Be careful. Arey sir, come on. This is the second award. I think one more award to the South Zone, Membership Development Award, V. Saidulu. He's there. So please give an award to him also, sir, after that is done. No, yes, and time for you to come and go again. Saidulu, please, please. Saiduluji. Sir, please. All the past presidents, anyone can give, not an issue, please. Now, maximum participation in the conference that goes to Gurgaon Conference North Zone. I understand they have taken the award already. It is already taken over by the zone people. They had to leave early. Best Souvenir Award goes to Kolhapur National Tax Conference. Mr. Patkar is not there. West Zone, anybody can come forward and take it, please. The secretary of the zone is there. He will take it, please, on behalf of Kolhapur National Tax Conference. Next also is not available. I'll just announce. Best article in journal goes to Aditya Ajgaonkar. He is not there. We will give it to him. Ruchi is already given award earlier. Man of the Year award goes to VP Gupta. Please clap for him. The award has already gone to him. Award for the chartered accountant having more than 50 years of practice goes to Indu Chatra. He is also not there. Then the next is the award for the tax practitioner having more than 50 years, Kishore Vanjara. Kishore Bhai was there. I think he has gone for, this was some problem. Kishore Bhai is there, we will give him in the evening. The next is the advocate for having more than 50, SM Surana, he is also not there. So that finishes the award by the Federation. There are some personal awards by the President. He wants to give to some of the persons who have assisted him throughout. One is to Pankaj Ghia, IPP, sir.
Best article in journal is left. Best article.
Aditya Ajgaonkar.
This one.
He's there? Aditya is there? No, he's not there. So I said we'll give it. Sir, you may please, Pankaj Ghia, sir. One is to 50 years practice. Okay, there was one more. Okay, RRC goes to Leh. Yes, please, sir. He has come all the way from there. I am very sorry, sir. North Zone, please come. North Zone, please come. Extremely sorry. Shivram, sir, please do the honors. Oh, be careful. Thank you.
End of the session, actually, we wanted to release the invitation, madam.
You have to ask him. You ask him. Ask him.
That was already conveyed.
You tell him. He will tell the time. Presidential Award for International Study Tour, Malaysia. Where is the chairman of the Malaysia tour?
Myself, ma'am.
Oh, sir, please.
Myself, S.K. Rungta, Chairman of International Study Tour Committee. I request all the committee members to come forward on the stage to receive the award, without whom it is not possible. Anjana Singh, Lakshman Kashyap, Pradosh, any other person who please come forward.
May I request Rao, sir, please do the honors. I have heard it was one of the best international tour. अरे कोई नहीं है सर. Be careful. Jain sir, now I'm announcing your awards. Jain sir, आपके announce कर रही हूँ. You will be giving that, right? So first it is Pankaj Gia, IPP. These are personal awards by the President. Jain sir. The next is to Samir Jani sir. Samir ji, please. Next is Vinayak Patkar. I think he is not there. We'll give it in the evening. Nanjuna Prasad ji hai, I believe. Nanjuna Prasad ji, please come forward. South Zone Vice President. Clap, please clap. Arvind Kumar ji, next आपका turn है. Arvind Kumar Misra ji, please come. राजेश मेहता जी. Second prize to Pradosh Patnaik. R.D. काकरा जी. R.D. काकरा जी. काकरा जी रोपवे पे गए. ठीक है. अनिल माथुर जी. वो भी नहीं है. गिरीश राठी. गिरीश राठी. They have all gone for sightseeing. Bhaskar ji, please come. Ji Bhaskar, it's Bhaskar and not Bhaskar. Please come. Acha, one and the same? Okay. Clap, please. Anjana Singh. Anjana, please come forward. संदीप अग्रवाल जी. शशांक मिठाई वाला is not there. Okay. Now, Dr. Ramaraju Srinivasa Rao, South Zone Chairman, please come forward. Yes, yes, बरसात है South Zone को, बराबर है. Sandeep Goyal ji, North Zone, I think he's gone. Sandeep Rungta ji can take it on his behalf. Who is it? North Zone, Sandeep Goyal. Okay, sure. Vijay Kumar Navlakha ji, next. Navlakha ji, please come. विवेकानंद मोहंती जी नहीं है, ठीक है. नेक्स्ट एस.के. रुंगटा जी, सर यू आर ऑलरेडी देयर ऑन द डायस. Mr. Dheeraj Shah, is he there? Dheeraj Shah not there. Arun Bhayati is also not there, West Zone. Then Samastan Dolma. Dolma is not there. Ramakant Surelia. Ramakant Surelia. Then M. Srivanas Rao, President 2021. Srinivas Rao, आपको भी दे रहे हैं maximum participation. I think that ends my job. Now handing over to the President, sir. We fully appreciate that. Thank you very much, sir.
Thank you. Before the past presidents give their remarks, I would request certain persons to please come forward and offer a bouquet to past presidents. I would request Mr. Ghanshyam Rajiria from Ranchi to offer a bouquet to Mr. P.C. Joshi, sir. Mr. Chirag Parekh, is he here? Okay, sir. So, over to you, sir. Okay. Then, in that case, we will offer a memento for your remembrance. I would request Mr. Chirag Parekh. He is here. Is he here? Chirag bhai? Nobody. So, can anyone voluntarily please offer a memento to Joshi, sir? Yeah, please. I would request Mr. Arvind Mishra ji, yeah, please offer a memento to Dr. K. Shivram.
May I interrupt for a minute? एक important award रह गया. Please complete that. शिवराम सर को दे दीजिए, फिर एक important award रह गया. I'm sorry. I'm extremely sorry. I missed it. Shivram sir, please. Now, when we are giving award to each and everyone in the committee, we should not forget the person who headed that committee, and we would like to offer a memento to our own President 2024, Shri Narayan Jain ji. May I request P.C. Joshi sir to please hand over the award to Narayan Jain ji. Please give him a big applause, please.
I would request Mr. Ajay Kumar Shukla and Mr. Chakra Ramanna to jointly offer a memento to Srimati Premlata Bansal ji. Next, I would request Mr. Rajesh Mishra from Prayagraj and CA Rajiv Doshi from Rajkot to jointly offer a memento to Ms. Nikita Badega ji. I would request Mr. Anand Pandey and CA Bharat Oza from Jamnagar to jointly offer a memento to Mr. M. Srinivas Rao. I would request Mr. Yogesh Srivastav from Varanasi and Dilip Yashward from Lucknow to offer a memento to Mr. D.K. Gandhi. Next, I would request Mr. Ratachand Verma from Varanasi and Akshat Vyas from Jamnagar to offer a memento to Mr. Pankaj Gia. Mr. Akshat Vyas, is he here? I would request Mr. Abhishek Sharma to please offer a memento to Pankaj Gia, sir. Last, I would request Mr. M.L. Gupta from Jaipur and Mr. Varis Isani, he is not here. Mr. M.L. Gupta to offer a memento to Mr. Narayan Jain. Is not here? Please, thank you. Thank you. Now, I would request Shri P.C. Joshi for his remarks, sir.
No, it's all right. Good evening, everybody. I hope you had a good lunch. Yeah. Well, the year has passed off. Now only a few days remains for 2024. And we look forward to Mr. Samir Jani for 2025. And 2026 to Mr. Kidhar gaya? Gayab? Oh, Mr. Venkat Ramani. You see, I have requested him that the golden year of the Federation would start from 11th November 2025 and it will end on 11th November 2026. So therefore, I have requested him that while forming a committee, celebration committee, he should be the chairman so that from 11th November 2025 itself, we should start preparation of the celebration and plan out the program right from now only, so that how do we do best for 2020, Golden Jubilee year of 2025-26. If I look back as far as the working of the Federation is concerned, let me tell you, I am very happy with the development that has taken place last 50 years. But at the same time, there is some minus points also which I would like to speak about. And one is messages being sent on multiple groups, same message being sent on at least 5 to 6 groups we receive the message every day. And therefore sometimes, the important message may be lost sight of. So, Mr. Samir Jani, please look into this matter. These groups, WhatsApp groups, should be limited to the purpose for which it is created. Suppose it is created for an NTC at one place, then the moment that NTC is over, that group should be stopped. Even today I am getting NTC 2023, that is still alive. I don't know why it is being continued. So that should be immediately removed. Because same message is being received, same message is being repeated again and again. Second thing is, zonal working is not up to the mark. Let me tell you, South Zone has received it very good working this time, but other zones are still lagging behind. I think most of the people, most of the chairmen, most of the NEC members also are not aware about the constitutional provisions. They do not know as to by which time and by which period the notice has to be issued for a meeting. You just can't call a meeting that now we will call a meeting day after tomorrow. You can't call a meeting. That is not a meeting in law. So that periodical time has to be maintained while calling the meeting. I am just speaking general, not for any specific person, not for any specific zone, but these are all general observations which I would like the new committees to follow, because that guidelines for zonal working and duties and responsibilities of NEC members, office bearers are all well stated in the Constitution. If you don't have the Constitution, please call for the Constitution copy and please follow it. That's my general remark. Thank you very much. Mr. Shivram will go for the constitutional provisions. जो बोलना हो बोलो भाई.
I'm not going to say anything on the constitutional provision.
हाँ वो लिख के ले आया है तब.
Friend, thank you very much for the opportunity. In fact, we are honored that DM Sinha, he is our own member. I become the ITAT member. We had no occasion earlier to celebrate or wish him all the best on behalf of the Federation.
Shivram, as far as DM Sinha is concerned, I would also recall it was this Mr. Sinha as our member has helped us in getting the journal recognized by postal concession. Thank you very much, Mr. Sinha.
So that's the reason I requested our Samir Jani to call him. He had done a lot of work for us. I used to telephone him every day. Arey Sinha sahab udhar jaake dekhiye kya ho gaya karke. Then he used to go there, post office, and get it done. So we still remember, But now, of course, we are a little distance, He is a member now. We are this side. That's why we had. No, thank you very much. But of course, Mr. Joshi Sahab, whatever he said, I fully endorse some of his views what Joshi Sahab expressed. In fact, let me congratulate, that our Mr. Samir Jani, your President-elect, how this session is concerned. Not that, that is not the orientation. Let me clear. I am not going to give any orientation to any of the members.
No, but Mr. Shivram, I would suggest that there should be a special meeting for new NEC members, especially NEC members who do require such orientation.
Okay, sir, but that is, I think, that you have to give to the Mr. Ramani and they will. I think they will go ahead with that. But I am not going to speak on the orientation course is concerned. But let me share with you few thought for all the members over here, not restricted to only our National Executive Committee member. That is my idea is concerned. Friends, first of all, that we the members of the AIFTP are blessed with having the 11,200 members. What I call it is nothing but the national integration of the tax professionals. Because we are having from the 29 states and 4 union territories. And then we are also honored to have Mr. P.C. Joshi ji, who is the founder secretary of the AIFTP. That is a great, that he has seen the journey of the AIFTP for 48 years. So therefore that we are also blessed with that. Now I must congratulate Samir Jani, as I mentioned earlier, this is a good thought what he has brought it. That we are here not going to be advised or something, we are just sharing our thought, ultimately left to the executive committee or the future generation take it forward. My first thought is that we should make an honest attempt to interact with the members across the country from small town. What I feel that now most of our programs are in the big cities only. Mr. Venkatramani in South, there are so many small towns like Udupi, all these small places. If we can go small places and we can interact, that will be, it will more interaction for your association go like that is the one request to all of you. Secondly, I used to make request to all the whoever become the president, don't repeat the speakers. What I found that with so many, every time same speaker is coming, all the seminars. Avoid, because you are having so many wealth of the speakers across the country. So therefore, as far as possible, we should avoid the repetition of speakers, unless it is absolutely necessary is concerned. Then another thing is, that our representation, what I told Mr. Jain Sahab also, and also every time I am repeating, our representation should be of the 4 parts. One is immediate action from the revenue or whatever may be. Secondly, procedural difficulties, what all of you are facing. Thirdly, the amendment in the law. And fourthly, conceptual, that is long term. So earlier, chamber of consultant, we used to do like that. Lot of deliberation and thereafter we used to send them, and we used to interact with the members, civility and everything. What we found that very positive response is coming. So this is what I expect. Then now the faceless assessment, of course, Mr. Datar has his own reservation about faceless assessment. And but what I feel that the faceless assessment an opportunity to all the professionals. This gives an opportunity to the professionals to excel in their profession. Now we will not find, at least in some of the places, contact-based profession has gone. Now it is your quality professional, what you render, representation, what you make, that made the difference in the faceless assessment. So therefore that now if you feel that, we can appear from sitting at any corner of the Chennai or any place, Supreme Court also, which never used to happen earlier. Mumbai tribunal, you want to appear, you don't come to Mumbai. You sit anywhere in the corner of we can do it. That type of, I think we should encourage our members to specialize on the use of the technology and how best we can represent on. That will go on the long way for our association is concerned. Now, one thing which I thought with the many members are here, which many may not be aware, that we conduct yearly tax mode competition for the Palkiwala Memorial Tax Court competition. There we give the research paper for the law student. And this year you'll find, 75 law colleges across the country participated. 75 law colleges means 375 participants from across the country. So all the 375, that is participation. And to see how much your federation aim has gone to the 75 law colleges. You can see imagine on each college how many students they are having. So everybody made aware of your association, everybody made aware of your educational activities. When they come to the profession, possibly that will be great asset to you. So this is what I feel that we should, this is one of the educational activities what we should continue. Now we know that as per direct taxes, we are having the AIFTP Bar Association Coordination Committee, which was found when Rankaji was the president and Mr. Dastur was our coordination committee chairman for the 2 years. Then Dinesh Vyas, all of them continue. It's doing very well. But similarly, it should have indirect taxes now. If we really want to grow in the indirect taxes, we should have coordination committee similar to have what we used to have in the direct taxes. Now, brain trust, what I found that, now recently, Mr. Joshi sir will recollect, in the brain trust, what we used to do earlier days, we used to ask the trustees, give us the answer in writing. So as soon as the seminar is over, we used to distribute. But now that is not happening at all. That once brain trust is over, everybody, you give the answer in writing, get it published in various forum, including journal or AIFTP. So not only those participated, others also will benefit of that. So this is what I thought of sharing with you. As regard Joshi Sahab suggested that the new members, that ITAT, when our member joins, Mr. Sinha Sahab must be knowing, they are given the booklet containing the conventions. So we should have similar to convention book to our members of your executive committee. As soon as whoever comes, please look into that, read, and next time you come. So this convention, ITAT, we are our members. That is not the rule or bylaws, it is by convention. So I think that way we should, Mr. Ramani is very good at drafting, can prepare a convention based on that. So let it be circulated, all the past presidents can look into that. And thereafter, if we do it, I think then that will be great what we can do for our members are concerned. Now that we are of course celebrating 2026. Now one thing is what we desire that when we celebrate your 2026, our vision should be that our Prime Minister has for the 2047. We should have the vision for 50 years, 60 years and also for 70 years. That is how we can go ahead and we can prepare for vision is concerned. Now new income tax, Mr. Datar has made that how it will be. But whatever may be that the new income tax is bound to come or they are going to present. So we have to we can play very positive role in giving very objective suggestions for that. And yesterday also I told Mr. Venkatramani, when Mikita was the president we tried to bring out the website, which we could not do it, that like similar to IT online org, you please do that. That will be, I think, the very, almost all the members will get benefited. Now that of course both of them, Mr. Samit Jani and both have agreed to work together for 2 years is concerned. Well, one thought, let me share with you. You are from Gujarat, he from Bangalore, okay? In the year 16 January 2004, when I was fortunate to have the president of the AIFTP. At that time, we released the Palkiwala Memorial stamp. At that time, our Prime Minister Atal Bihari Vajpayee came to Mumbai only for our function. Then released the stamp. At that time, Ratan Tata, Soli Sorabji, all of them together came. So our thought should be, when you complete 2026, when you go, we should have the vision to bring at least Prime Minister of India one of the program, and that will go a long way for your, that is concerned. Now, that two thought, finally, let me share with you, that I used to travel with the founder president, Sri N.C. Mehta and Joshi ji from time to time, earlier days. Now, when N.C. Mehta, I asked him, sir, what is your success? Everybody respect you so much, why is so? He replied me, Shivaram, initial stage, when I started practice, I lost all the matter report officer. Then I have to go up to tribunal, then I have to get it set aside. Then he told me that thereafterwards officer realized, so there is no point in asking him anything. So now, we will we will give the relief whatever it is, as per the law. I think possibly our junior members, we have to teach the lessons what we taught by the seniors. Don't worry, initially you have some difficulties. You don't compromise your value ethics. Once you do that, possibly, when you become the very senior, officers will obey you because you know that you are nothing going other than submission. So this is what I think, what we have been taught by all our seniors. And then lastly, let me share with you one more thing. When Justice H.S. Kapadia became the then senior judge of Bombay Court, he inaugurated our seminar, convention at Mumbai. Thereafter become Chief Justice. He told me that after seeing our code of ethics, we are having code of ethics for our members, code of ethics for our opponent, code of ethics for all that. He said, Shivaram, fine. I am very impressed by your code of ethics. Then he asked me one question, all right, I appreciate. But what about Article 51A of the Constitution of India? That is duty to the nation. He said that is missing in your code of ethics. He said that should be part of your code of ethics when you do it, and it is the one thought, Mr. Venkatramani and this, possibly whenever you do something on that, possibly Article 51A, we have to always remember that. Of course, we already remember Article 14, 21, all that, our right duties. But 51A, everybody forgotten. This is the one Justice Kapadia told me, still I remember. So therefore, thank you very much. I think I have spoken much more than what he desired. Joshi Sahab, thank you very much. Thank you.
Now I will request Premlata ji.
Good afternoon, friends. Two stalwarts have spoken so much. Nothing has been left before me, for me. But in any case, I will do my duty in a best possible manner. Friends, it's my privilege to stand before you for such a orientation program. It's a great honor to me, rather, to stand before you. Friends, you all know that this is an unique organization. Stands for ethics, education, and excellence. The role of the president in an organization is like FTP, which unless member all corners of the president is not just a mere formality. To be a president is not the formality, but he has to do much more things. How to become, it is, combined of authorities and duties. I say duty is much more than the authorities. Friends, the grooming of the president does not start with becoming of the deputy president. It starts with the time when the person becomes the member of this federation. He has to cultivate the traits as soon as he becomes the member of the federation. Friends, I have called down certain principles as what are the traits for the president, friends. Because why I am saying so? Because you all are the future, office bearers, or the zonal executive committee members, or the chairman of the zones, or the president and office bearer of the executive committee. That is why I am stating down certain principles as to what should be there. Because first of all, the president should understand the organization and the members. A president must first deeply understand the organization's mission, vision, and values. Our commitment to unifying the tax consultant across the country and fostering the professional excellence must remain our compass. The president must also recognize the diversity of the members residing in the different states, different languages, different culture, different heritage. So the president has to understand the members first of all. The second is there should be the visionary leader. He has to see the visions. If the visions are being, then the federation will go much farther. He had to setting the clear, achievable goals, innovating initiatives. Venkatramani sir, I am saying something for you, sir. Innovating initiatives that align with the members' aspiration, embracing the technology. We have gone further for the technology that we are, we have the website, we have the AIFTP Times on the website, then journal, we are, educational committee, we have, we are, most of the judgments are given on the website or this WhatsApp group and all that. So this is the, I must say that this is the use of technology. And I can't say that what AI will do for us, for our federation. That is to be think by the Venkatramani sir. Then cultivate the collaborator and the inclusivity. Why I am saying inclusivity? That we have to make the members participate in the different committees. There should be interchanging of the committee members. During the year also, if you can see that this member is doing well, then he can be, he can be activated or he can be participated or placed in a certain group, maybe direct committee, indirect tax committee or any of the committee. The person can be placed. Then enhance the communication and engagement. An active president is one who communicates effectively and consistently. Say regular newsletters or video messages to keep the members updated. Then organizing webinars that we are doing. Then strengthen networking and partnerships. How can it be done? Collaborate with other professional bodies and associations. Build strong relationship with government authorities, ensuring that AIFTP's voice is heard in policy discussions. So with government we can fix the programs. Encourage members to engage with local, national and international forums. Then one of the principles is to encourage mentorship and knowledge sharing. Then promote ethical practices. Then one of the most important thing is focus on financial sustainability. To increase membership and retain existing members. To give respect to all the elder members, past presidents, past members. At this juncture, I remember Mr. Sareen. When Dr. Shivram told regarding Article 51A. So when we held a conference at Rishikesh, then that was the outcome of thoughts of Mr. Sareen, that we can have the speech on this Article 51A, because most of the persons are aware of fundamental rights, but nobody is aware of the constitutional responsibilities and duties laid down in Article 51A. Then we had a conference on spirituality and justice. Sikri in Rishikesh have told that how to combine spirituality and the judgments. Because in the morning, Justice Bhuya have told regarding compassion in the judgments. So at that juncture, I remember Mr. Sareen very much, that he had told how spirituality can be included in the judgments. So, and then empowerment of the next generation of the leaders. That is most important. Otherwise, what will happen that after 5 or 10 years, we will not have any leader. Everybody cannot be the leader. Leadership, traits, maybe in some of the persons, but that is to be groomed So we have to empower the next generation of leaders. Then timely, we have to measure the successes and adaptation. I mean, we have to measure the successes and we can motivate the members by giving the appreciation certificate, appreciation letters time and again, Samir bhai. We can do so that members can be motivated. Then one thing I must say, that even in the last year, there are two, petitions before the court or charity commissioner. I want to request all the members that this type of litigation should not be there in the court of law. That brings the bad name to the federation. Before coming to the grievance committee of the federation, no person can be allowed to go into the court of litigation, friends. That is my personal opinion. Because that is everybody's right. I don't want to curtail anybody's right to go in the court. But that brings the bad name to the federation. Why the person should not come before the grievance committee? Grievance committee is only for that purpose only. The second thing I want to say, that even any person is made the office bearer. Can't we, what should I say? I want to say that क्या हम उसको बर्दाश्त नहीं कर सकते? मेंबरशिप तो 1 साल के लिए होती है ना, उसमें क्या ग्रज है? आपको फेडरेशन के लिए काम ही करना है, तो उसके लिए जरूरत थोड़ी कि सेक्रेटरी ही बना जाए या वाइस प्रेसिडेंट ही बना जाए या प्रेसिडेंट ही बना जाए। यदि किसी को वाइस प्रेसिडेंट बना दिया या सेक्रेटरी बना दिया तो उसमें क्या हुआ? आप काम कीजिए 1 साल, क्या पता नेक्स्ट ईयर आपकी टर्न आ जाए वाइस प्रेसिडेंट के लिए या सेक्रेटरी के लिए, पर उसके लिए कोर्ट में क्यों जाया जाए? So that is your own problem. I must say that is not the problem of the federation. That is the problem of your own mind. That you have such a big vision, but that can have after 2-3 years. So we have to have that motivation in our mind. Last, what I want to say, that being the president of an organization like AIFTP is both a privilege and a responsibility. It requires vision, collaboration, and unwavering dedication to the members and the mission. Friends, I hope these insights will inspire you, not just the current leadership, but every member to contribute towards the thriving AIFTP. Together, let us build an organization that remains a beacon of excellence, professionalism, and ethical values. Friends, this is all.
Friends, we must appreciate the homework done by Mr. Shivram and Premlata ji. For what? For the betterment of the AIFTP. So ultimately, it is all you who have to do something for AIFTP. Don't think of what AIFTP does for you. Do something for the AIFTP, for its development. You may have some friends, you may have some areas where AIFTP members may not be there. So please see that the number of members increase multifold by the time we conclude our Golden Jubilee. Now may I request Mr. Pankaj Gia to... One minute, Pankaj. Whoever is, okay. Gandhi, chalo. Oh, sorry, Nikita. I forgot the serialism. I don't have it. वो घर का है ना, घर का आदमी वो भूल जाता है
दाल बराबर. Friends, the next session speaker is already there. I will not take more than 2 minutes only. As far as the zones are concerned, our worry is tax compliance. I'm really worried about the TDS and other issues. the accounts of the zone not coming, etc. And I'm sure President will take care of everything. Now, the new team which is coming, we are seeing that people come directly to the NEC rather than working on the zone level. And my request, earnest request is start from the grassroots level. I will give you an example of Narendra Modi. He started with the grassroots level and now where he is. Unless you work at the zone level, coming to the national level, you will not know what is happening at the zone also. Please work at the zone and work, you will be noticed. Don't bother about having the post, etc. One important issue which I've been always telling, spending at the seminars. Our seminars are becoming very costly affairs. Day in and out, the burden is increasing on the organizer also. So what we can cut off? Now, as a federation, we all know the persons, if they are from the federation, they come on their own. They don't burden the association, they pay the registration also. But at the same time, if you are spending, yes, we need 5-star because we need good food, we need to stay there. All right, fair enough, you are paying for that. But then I must appreciate Mr. Jani. He says, this memento has cost him 2,900. I said, give us 200 rupees pen, that's more than enough. We don't need such big memento. Yes, for the faculties who are upcoming, they would be happy to have the memento. But for the seniors like us, even 10 rupee pen is a memento. So don't bother with the AIFTP name. I would use it gladly. Okay, yes, this is what is coming. So please save something because of our ultimate goal. I mean, this is what I have said. All the 5 zones should have their own office. How would it come if they don't save from the seminar? And you will have to start building that fund and keep that goal in mind and come up that way. Reaching to small places during the pandemic, I am a pandemic president, and with the help of our Ghia sir, we have reached to remote places. And I would request you to continue with the reaching to the remote places. If you can't go, please reach out in the virtual mode also. And of course, use of AI. This is going to be a very important subject for all of us. And we can have one full day session on use of AI by the professionals. Thank you very much.
Thank you, Nikita ji. Now, Mr. Gandhi, or you are there. Okay, okay. I cannot forget Mr. M.S. Rao, who is always giving us the ladu from Tirupati. This year it has gone. Bhai, abhi tak aaya nahi hai.
Thank you, Joshi sir, for giving me the good compliment for me. First of all, I will thank the organizers, Mr. Samir Jain and the team, giving me this opportunity for stand before you, for giving a small knowledge about the AIFTP. The AIFTP is a top body in the country, and it is a unique organization run by the eminents and seniors in the past 48 years. This is the 49th year starting. The AIFTP is having 5 zones: West Zone, Central Zone, North Zone, Eastern Zone and South Zone. These are the 5 zones. It is comprised of some of big states 2 and some of 4 to 5 states, 6 states. Like that, the seniors like P.C. Joshi and other all seniors, Sivaram and other all seniors, they have made this zonal setup. This zonal setup is to dedicate the work to the zonal chairmen and the zonal management committee for moving smooth the organization AIFTP national body, for which the zone setup has started, and the zone setup is very much useful to the AIFTP in the earlier days and coming days also. And secondly, if the national president is
having somewhere at Bombay or Junagadh or any other place, he must have not reached the zone. The zone chairman is the unit officer to having that zone issues, whatever it may be, the representations, whatever it may be, the other issues the fraternity is facing with the government, that will be addressed by the zone chairman, and as well as he has to write to the head office and committee for the taking appropriate steps before the government for the income tax as well as the GST now. And secondly, these zonal setup, the zone chairman and the zonal vice chairman and zonal secretary, zonal treasurer, zonal joint secretary, like this. This is a building of a small house of the zone. And the bigger house is the National Executive Committee. Every 2 years, we have got elections. That in elections we are getting the 50 members for the, we have decided in the our constitution, the people who have made the members, that members should be reach each 51 of the member of NEC, then they will go to the National Executive Committee. This National Executive Committee having a 50 members, and the president is having a privilege to co-opt some 10 persons and special invitees as he likes, and this is the structure of the NEC, National Executive Committee. From the initiation of AIFTP 1976, the NEC and the national setup is going on. Subsequently, the zonal setup is made. After that, 2 years, 3 years term first, then 2 years term. From 2016 onwards, it is 1 year term. Now 1 year term is going on. And this 1 year term, the national president moved from Kanyakumari to Kashmir and Rajasthan to this Gujarat. From horizontal and vertical, all the states he should have to cover. Nowadays, our AIFTP is having a members from all over the country, 29 states, more than 9 to 10 union territories, and we are having a corporate members, we are having our sister associations members, like that. Major membership is there with us. Our seniors have already told that 11,200, something like that. And the other corporate members and other members, roughly 150 or 200. But the involvement and the dedication is to be there in the organization, then only it will be success and give a good result. The member who can involve in the programs, zonal study circle meetings, as well as the zonal meetings, zonal conferences, 1 day, half day, full day, and other national conferences like these conventions, automatically the person should learn something from the seniors and as well as the procedural aspects of the zonal management committee meeting as well as the NEC meeting. First, we are loyal to the president, and then wherever the NEC member is elected, the NEC member loyal to the organization is the highest of the high body. He has to give a first preference to the organization, then personal egos and or any other individual reservations. That is the second issue. And third issue, I would like to share with you. The organization, only the person to coming and going, so many presidents are come, so many secretary generals, treasurers, and all the NEC members, so many people are come. But wherever the NEC member is a trustee to the charity commissioner. Why we are having a trustee, we would like to have a responsibility. That's why the NEC member is very, very important, and he would like to have the knowledge about the National Executive Committee, and the National Executive Committee should reach the person with a good knowledge and greater heights. Lastly, the President and the National Executive Committee is the highest body. National Executive Committee what desires, that will be designed in the advisory board as well as the collegium and as well as the implementation of the rules and regulations, everything. If constitution is going to be amended, if somebody has given a small message, 3 days, 4 days is not enough, and you should have to pass on to next year. That everybody listens that particular aspect and they have pushed out to the next 2025. That is the spirit of the past presidents and as well as the National NEC, National Executive Committee members. That spirit should be go forever, forever. Long live AIFTP. Thank you very much.
Thank you, Mr. M.S. Rao, for giving general outline up to how the Federation is working today. Now, Mr. Pankaj Gia. Oh, Gandhi. Gandhi, भूल जाता हूँ भाई. Sorry.
थैंक यू जोशी साहब. दोस्तों, जो माहौल है वो बहुत अच्छा है. मैं 2 या 3 बातें आपके सामने रखूँगा और बहुत इम्पॉर्टेंट बात ये है कि आज मॉर्निंग में जो सेशन हमने रखा था उसमें सुप्रीम कोर्ट के जज ने भी हमको बताया. उसी के रेफरेंस में सबसे पहले एक बात मैं आपके सामने रखूँगा कि जो हमारी फेडरेशन है 76 में बनी और जो उसका कॉन्स्टिट्यूशन है उसमें अमेंडमेंट भी होंगे, चेंजेस भी होंगे, लेकिन बेसिक स्ट्रक्चर में कोई चेंज नहीं होगा. आई रेस्ट यू एश्योर फ्रॉम ऑल पास्ट प्रेसिडेंट एंड ऑल कस्टोडियन ऑफ द फेडरेशन. रीज़न बीइंग कि जो बेसिक स्ट्रक्चर है वो 3 है: एजुकेशन, एथिक्स एंड एक्सीलेंस. We must never forget what is the motto of our federation. Ethics is most important as far as my personal experience is concerned, and we must maintain it. Second thing, my piece of advice to the national president incoming is that today he has taken an oath. Whenever he feels any pressure from any corner of the country, from any executive, any office bearer, he just should read that oath and he should take the decision. No fear, no favor. And most of it, you must have all the patience to hear all. जितने ग्रीवेंस हैं, ग्रीवेंस आएंगे. क्यों आ रहे हैं? बिकॉज एक्सपेक्टेशन बहुत हो गई मेंबर्स की. उनको लगता है कि यहाँ पहुँच जाना कोई बहुत बड़ी बात है. दोस्तों, मॉर्निंग में भी ये बात थी. इवन समीर भाई ने बड़े हम्बल वे में कहा कि इधर उधर में बहुत अंतर नहीं है, लेकिन एक अंतर बहुत है इम्पॉर्टेंट, वेरी वेरी, विच एवरी मेंबर शुड रिमेंबर. एक मर्यादा का अंतर है. देयर इज़ अ लिमिटेशन व्हेन यू आर टॉकिंग टू द सीनियर पर्सन, टू द पास्ट प्रेसिडेंट, टू द नेशनल प्रेसिडेंट, टू अदर ऑफिस बीरर, टू योर ब्रदर कोलीग्स. यू मस्ट नो what is your domain. You must never forget. We all are equal, but we should be respectable to each other. और सबसे बड़ी बात जो अभी एक्सपेक्टेशन लेवल बहुत हाई हो गया, that you cannot dictate the terms to the person who is on the chair. He knows his responsibility. He knows how he is going to perform. And I would request all my new members, just have patience. Federation is yours. You are for the federation. With these words, I congratulate Mr. Sameer Jani that he will be discharging his duties to the principles of the federation. I will not be saying much on those what he has to do because he is a very experienced man and all his teams are very, very competent because all members of the federation are competent and we invite all members from who are of academic excellence. One more thing, I want to make it very clear. एक बहुत expectation level की जहाँ बात आई, we must remember that our constitution invites members from Rajya Sabha also. We are having a finance minister from Rajya Sabha. We are having a foreign minister for Rajya Sabha. They have not fought the election. It does not mean that capable person should be coming to the federation only on the basis of election. It is the duty of the past president, it is the duty of the incoming national president, deputy president to just catch hold of the good persons who can come to the federation. And I must remind you, all my past president know, I remember 2002 when Bharatji came to our one convention and he was made not only member, he was directly taken into the team. So this is the way, this is the culture of the federation we have to see. I also came through not by fighting election. In 2016, I was co-opted and then I fought election. It's there. Madam Bansal, all we have come, Dr. Shivram. So it is the creation when we are inviting the people who are half academic. No doubt there is a much importance to election also, but that is not the only thing. We must remember it. And with this, thank you so very much. Thank you.
Thank you, Mr. Gandhi. I must compliment to what you said. I would say, remember HTR. Hear, think, and then respond. Never respond immediately. Not only in problems with AIFTP, but in your profession also. When a judge is asking you a query, just hear him completely. Don't start straight away. Even if the question is not over, you start reply. I have seen that in the court. So please remember HTR. Hear, think, and then respond. Over to Mr. Pankaj.
We always say that the third time is the lucky one. My name has been called third time, so I think I am the luckiest one.
No, that shows how much near you are.
Yeah. And that is what I always say. Just laugh, enjoy, and love AIFTP. If you do these three things, AIFTP would be an asset to you. AIFTP will become a family to you. AIFTP will become a senior or junior or whatever you want, that it would become to you. And youth will join AIFTP if we have a very somber atmosphere, if we have a very dull atmosphere, if we just forget how to broaden your smile or show your teeth, we will be going all the bald hairs and all the white hairs and all the gray hairs, and the youth will not be there. So friends, my motto has always been one thing: be a friend, be a family member, love everybody, enjoy every moment of AIFTP, and if you enjoy, you will give your best. That is automatic. It is likewise in the profession. If you deal with the profession as a duty, you will never rise to the top level. But if you love your profession, if you wear your profession, if you sleep with your profession, if you think about your profession, you will always achieve the great heights. And we look forward for those people in AIFTP. Love AIFTP, and everybody would love with you. Everybody would become a family with you. And that is what AIFTP is. I had gathered in the 2023, I traveled length and breadth of India. And what I got the best of the family members throughout India. Wherever I go, wherever I meet, people just come and hug me. And that is what I gained with AIFTP. You also want to gain the same thing, just enjoy and love the AIFTP. Thank you.
Thank you, Pankaj. Now, before I request the current president, Mr. Narayan Jain, we would like to hear our judicial member, Mr. B.M. Sinha. अरे बोलो यार, 2 मिनट तो बोलो.
भाइयों सबको नमस्कार. For the first time I came to the podium with that I had joined the AIFTP way back in 92 or 93. Since then I remain the active member of the federation, complied with several duties as has been casted on me, and I think that I am here only because of the federation. When I joined the federation, I learnt a lot that how the lawyers are arguing in the matter in the court. Before that I was an income tax practitioner and then advocate, but practicing only on up to the level of income tax officer or the commissioner income tax. But after coming and joining the federation and learning from here, reading the articles, reading the views of the senior lawyers, I learnt a lot, and then I started my practice in Delhi High Court. And now I am a judicial member only, and the full credit goes to the federation. Thank you very much.
3 cheers to AIFTP. Credit, Mr. Siha. Thank you very much. Now, the current president, Mr. Narayan Jain, our president for now few days. After few days, I am telling you few days. Of course.
2 weeks.
Yes, yes.
Friends, I once again express my gratitude for all the blessings and cooperation and help from all of you. These 2 minutes, sir, I want to use to introduce the new zone chairman of the 3 zones who have been elected. May I invite the zone chairman, new zone chairman of North Zone, South Zone and Central Zone, because they have elected their new zone chairman. New zone chairman. भाई आपका है? आप इलेक्ट हुए हैं वापस?
Good, welcome new chairman.
You see,
2025.
East Zone and West Zone.
Zone chairman.
East Zone and West Zone could not elect so far, but they will be electing soon. So our congratulations, sir, to all of you, and we have a lot of expectation under your leadership that AIFTP will function well and proceed further. And whatever you need from AIFTP, on behalf of our new president, Sri Samir Jani, I assure you full cooperation. Samir bhai, Samir bhai is also very dynamic. हाँ आइए आप भी आइए आइए
रमणी
अरे भैया काम तो आपको कराना है.
This is your team. You have to get the work from these 3 people.
And we hope the other zones will be electing their zone chairman for 25 soon. And sir, our good wishes to all of you. और हम होंगे कामयाब under your leadership. AIFTP will होंगे कामयाब. और एक बात खाली आपको बोलना चाहता हूँ एक लाइन में कि अब क्या है कि जो समय चला गया, अब हम लोग को सबको मिलकर चेष्टा करनी चाहिए कि सब लोग कैसे प्रेम बढ़ाएं, प्रेम से रहें. और केवल रमणी साहब ने एक लाइन मेरे को बोला था, एक लाइन बोल दीजिए, नो पॉलिटिक्स वाला. He has also assured that he will try his best with the help of Mr. Samir Jani that we all work together. No politics. Thank you. Thank you. Congratulations.
On behalf of all the past presidents, I assure all the chairmen, all the zonal chairmen, that best of the guidance and best of assistance will come from past presidents. Whenever you call for, there will be assistance. Now, the lovable President 2025, Mr. Samir Jani.
Well, I have 2 things only to say, or rather 2 sentences to be said. Each of your advice has been noted in my notepad of my mobile. I will take care of this Shiksha Patri. and honor all past presidents. My priority would be AIFTP members, no groups, no factions, simple work. And I think since Mr. Kevin Gulati, senior advocate, has been waiting for an hour or so, we are aware about that, sir, but then the limitations. So we conclude this session. And I would request Kevin Gulati, sir, to be on the dais.
Thank you very much to everybody. Thank you for giving time to past presidents.
Thank you, past presidents. Now we are immediately starting the last technical session for the day today. That is on GST, on mining industry post Supreme Court decision. I would request Mr. Chintan Joshi, Anil Agarwal, Mr. Deepak Amin and Mr. Kedar Heda to escort the faculty, Mr. Kevin Gulati, sir. I request the persons on the dais to please hurry up. Yeah. As a token of our love and affection, I would request Mr. Himanshu Waghela from Baroda. Is he present over here, Himanshu bhai? Yeah. I would request him to please offer a bouquet and a memento both to the faculty. Himanshu bhai, please offer a memento also. Thank you. Thank you so much. Over to you, sir. The dais is all yours.
So, good evening. So, when we were in school, the last lecture was always the most difficult to endure, and all of you had a very, very long session today, number of speakers. So, what I'll do is, I will quickly introduce the topic and try and finish in the next 15-20 minutes so that your misery is done with. So, as you are aware, under GST, in Schedule 2, leasing is treated as a service. Now, what is the impact of the Supreme Court judgment which has come with relation to mining, and how does it affect that entry? What we are really seeking to discuss here is what Mr. Datar pointed out in the morning today, whether that entry of leasing can remain in the GST legislation as a valid legislation. Because of what the Supreme Court has said in this judgment of 9 judges, because what they have dealt with is the powers of the state government under entry 50 of list 2, which gives the state certain exclusive powers to tax a certain subject matter of taxation. And in this case, we are concerned with leasing and royalty which is paid, whether that can be amenable to GST. Now, mining, as you are aware, has a number of services which are pure services. Those were even in the Finance Act regime, they were taxable as pure services. They continue to be taxable under GST as well. But the issue really is of royalty. When a mining lease is given and when the party who gets this lease pays royalty, whether that becomes amenable to GST, because that's a very, very major revenue outgo for any industry. So that's the topic which we are going to be discussing today. And in order to discuss that, very briefly, we will have to go back to the position just prior to 2017. What was the taxing regime then? We are dealing with constitutionality today. Now, as you are aware, prior to 2017, the power to make any laws, especially tax laws, was provided in Article 245 and 246. That gave certain exclusive powers of taxation to the union government, similarly exclusive powers of taxation to the state governments. There was also a list 3 called the concurrent list, which is unique to India, borrowed from Australia. But that list is unique because under the concurrent list, there is no power of taxation. So there is an exclusive power of taxation on certain subjects like excise, duty, customs, etc. in list 1, which is the union list. Similarly, the state had exclusive powers of taxation like sales tax, except central sales tax. Central sales tax was with the union government. Entry tax, these were exclusive powers with the state government. Now, there is something which is known as a residuary power of taxation, which is to say, if a particular taxable event is not captured by the list 1, which belongs to the union, or list 2, which belongs to the state, and a new tax is being coined, then the union could, under the residuary power entry 97 of list 1, make a law taxing that particular new law within its domain. And one example of that is the service tax legislation, which came in through the Finance Act of 1994. Now what happens is, this is the division of powers which existed prior to 2017. And 7 judges of the Supreme Court, in the case of India Cements in 1970, they were discussing the scope of entry 49, which is tax on land and building, and entry 50, which is tax on mineral rights. These are the 2 entries which they were considering, and 7 judges of the Supreme Court in 1990 gave a decision, and that decision said that royalty which is paid on mining is in the nature of a tax. And because royalty is in the nature of a tax, there can be no tax on tax, and therefore, since there can be no tax on tax, the state's power under entry 50, which is tax on mineral rights, stands denuded to that extent. So the states therefore were stopped from levying cesses which they were seeking to levy in 1990. This position continued right till the year 2004. In 2004, another constitution bench in state of West Bengal versus Keshoram, it, without disagreeing with the judgment in India Cements, said that no, insofar as entry 50 is concerned, the states have that power, it is available on the statute book. How can you ignore that state's power, and how can you not allow the states to tax? And therefore, it upheld the cesses which states were levying on these mineral rights. When this conflict of views was seen by other benches of the Supreme Court, the matter ultimately was referred to 9 judges, which is known as the Madha judgment. This judgment came a few months back, some 5-6 months back in 2024. What this judgment holds is something which is extremely important, and it has a direct bearing on the GST legislation. What this judgment holds is this, This judgment says that royalty which is paid is not a tax. Royalty is a consideration which passes as a result of a contractual arrangement between the lessor and the lessee, and therefore it is a payment for parting with the privilege which the union or the state government has, and that privilege is the right to mine at a particular place. So the very basis of India Cements holding that royalty is a tax has been undone, and now the basis is that no, royalty is consideration, is a consideration which arises out of a contract. So therefore, they further say that the width of entry 50 of list 2, which gives states the exclusive power, is very wide. They say under this entry 50 of list 2, the states have the right to tax anything which relates to rights in minerals. And what is extremely important for our purposes is, they say that under this entry, we are not saying that the state has the power to tax the minerals, but they have the power to tax the rights relating to the minerals. Now, this is extremely important. Why? Because when you say that the state has the exclusive power to tax rights relating to minerals, what is a lease? When a lease is being given by the government to another party, what is the government parting with? The government is parting with its rights in relation to the minerals. And therefore, according to the Supreme Court, 9 judges now in 2024, all these rights are within the ken of taxation of the state government. We'll come to that. We'll come to that. Because this is only the start of the problem. This is only the start of the problem. It is. We will, yes, telecommunications rights is a different aspect because there is no entry under the state list dealing with mineral rights. Entry 50 of list 2 is a specific entry relating to mineral rights. There is no similar entry with regard to telecommunications as you've put. So that is why you are taxed under the service tax regime by the union government, under the Finance Act. Now, this is something which the Supreme Court has held in 2024. But they were not concerned with the GST legislation which had already come in the year 2017. Now, in the previous constitutional regime, as we said, there were strict demarcations between the state and the center insofar as their powers of taxation were concerned. And that is why India is sometimes referred to as a quasi-federal structure, which essentially means what? Which means that even though we are a union of states, on certain subjects, the state is supreme. And on certain subjects, the center is supreme. So therefore, if there is a power of taxation with the state government, say relating to sales tax or entry tax, the union cannot interfere. The state is the supreme body insofar as the levy of that tax is concerned within its state. Now what happens? Before GST is brought in, the constitution is amended. The constitution is amended by bringing in the 101st amendment to the constitution. And what does this amendment do? It brings about a new article called Article 246A. And it starts by a non-obstant clause saying, notwithstanding anything contained in Article 245 and 246, both the center and the state shall simultaneously start levying what is known as a goods and service tax. So what we have learnt for the past 30 years in our law, we have to unlearn and relearn again. A new system of taxation was now evolved by the constitution, where the state and the center will both start taxing simultaneously. And something very interesting which will play up 5 years down the line maybe sometimes, which is that this is not a concurrent power of taxation. Under list 3, as I told you earlier, the state and the center could concurrently impose or bring about legislation other than tax legislation, which essentially meant that if the center had not passed a law, the state could deal with that subject. But if a central law came which was repugnant to state law, then the central law will prevail. But now the scheme is something very different. Now they are not talking of concurrent powers. Now they are saying simultaneous power of taxation. Therefore, you have 3 acts: the CGST, the state GST, and the IGST. Now, I mean, that's not the topic which we are discussing today, but just hypothetically speaking, tomorrow we may have a situation when a state may turn rogue. The state may stop following the GST Council recommendations and say, no, I have the supreme power under 246A, I will prepare my own law. I will not give you input tax credit for a XYZ item, because it is going out of my state and the receiving state is the state which is going to recover all the money. Why should I give you this input tax credit? But that's for another event, for another topic which we will deal with. But coming back to GST, it is this power of the which has now been bestowed on both the states and the center, that the CGST and the SGST legislations have been framed. And it is in exercise of this power that Section 7, read with Schedule 2, provides for leasing to be treated as a deemed service. That's one thing which they have done. Secondly, what they have done is they have amended section or brought in Section 2 within bracket 17 to say activities performed by the union and the state governments are to be deemed to be business. And the third thing which they have done is, by a notification they have said, services being performed by the union and the states shall be in the reverse charge regime, which is to say that the recipient will become liable to tax. Now the question which arises today is that the Supreme Court, now 9 judges have conclusively ruled all rights relating to minerals have gone to the state exclusively. But your GST entry today is saying, sorry, we are treating this right to lease as a service. Now the question immediately arises, there is an immediate clash of heads. So therefore, there is a challenge pending in the Supreme Court, challenging this insertion of 2A in Schedule 2, which treats leasing as a service. How the Supreme Court will decide, we don't know. It will happen the next 2-3 months. It was supposed to be heard some 2 months back, but Justice Chandrachud retired, so that bench could not be formed. And the second issue which I said was with regard to the leasing by the state to be treated as a business. Even that entry has been challenged. It is pending in the Andhra Pradesh High Court, where the argument which is being raised by the assessees is this, that when the center is or the state is parting with its privilege or giving out land on lease, it is essentially performing sovereign functions. And if the state or a center is performing sovereign functions, you cannot say that they are engaged in the activity of business and therefore you have no right to impose GST. That's also an interesting challenge which is pending, but probably with the next year when you all meet, we would have answers for both from the Supreme Court, one way or the other. But as of now, this is the problem which we are grappling with. Now, what the center and the states are going to argue is that Article 246A, which has been inserted, starts with the words notwithstanding anything in 245 and 246. So therefore, under 246A, we have the power to levy GST and frame legislation like this. But the question which will arise is, does the 101st Amendment to the Constitution, which brought in this Article 246A, does it have a reflection on entry 49 and 50 of list 2? Answer is no, because clause 17 of the 101st Amendment specifically said that we are dealing with entry 84 of list 1, which is manufacture. Then they said we are dealing with sale, which is entry 54 of list 2, entry tax, but they did not touch the state's power under entry 49 and entry 50 of list 2. So therefore, the center and the state will have a serious problem in dealing with their submission that 246A overrides everything, including entry 50. They cannot argue that, and they should not be able to argue that, but that's for the courts to decide. But in the meantime, according to me, and that's the last part which I want to share with you today, how does the government, without the intervention of the court, resolve this issue? Because you see, ultimately when GST was brought in, it was brought in with the idea of reducing the cascading effect on taxation. The idea was to have one tax, one nation, and there should be no cascading effect on the taxation, in the sense that your goods should not become uncompetitive because of high taxation and multiple taxations. So one way of doing it would be that the Supreme Court itself, while defining the powers of the state under entry 50, said that the union government has the power to regulate under entry 54 of list 1, and that power of regulation can also touch upon the state's power to tax mineral rights, but for that they will have to issue a legislation or pass legislation to that effect. So one way of dealing with this issue is to prevent multiple or multiple taxes on the same taxable event, is for the union to frame a law which would curtail the powers of taxation insofar as the state government is concerned. And the states will also not lose anything, because ultimately they will get their share of GST from the state, which is in any event going to be available to them once SGST is being levied. The other way is, don't levy GST, allow the states full rights under entry 50 of list 2 to proceed. Because if you levy both taxes, the levy insofar as entry 50 of list 2 is concerned, you will not be able to pass on the burden anywhere, in the sense that you will not get an input tax credit or anything of that kind. You will only get an input tax credit if you are being levied GST and it's treated as your input, and then in your final output goods you are not paid tax. So at this stage, the law is in a completely gray area. How the Supreme Court would decide, it will probably need another 5 to 6 judges to sit and decide this issue, because we are concerned with a constitutional provision, and Article 145 of the Constitution says that if you're dealing with a constitutional provision where all states are involved, then legitimately matters should be referred to 5 judges, and it is those 5 judges which will decide the issue. So that's all that I wanted to say for this talk. Insofar as I'm concerned, this topic is done. We've had a long day. I think I've promised I finished within half an hour. Any questions which you need to ask? Yes, sir, please. I'll try and answer to the best of my ability. So you can take a mic.
Speaker sir, primarily we have two difficulties. Most of these mining leases, madam, they are all subleased from A to B, B to C. Ultimately, that fifth fellow, either you can trace him or you cannot trace him. Somewhere in between, 1 or 2 of these fellows would have paid royalty, 1 or 2 of these fellows would not have paid royalty. What do we do? Keep this at the back of your mind. One. My basic question is, who is supplying service to whom in these royalty cases?
May I just answer? In fact, it's a very pertinent question. May I straight away answer that? And that is why I pointed out this entry 50 to you, because this judgment says something very important. Apropos what has just been asked by you. This judgment draws a distinction between, please have a seat, sir. So this judgment draws a distinction between a lease and a license. It says a license is something where you only give a person a right to use, and without your giving that right to use, that activity will become illegal. Versus a lease, where there is a transfer of the right to use. That's very important, I'll tell you why. So, the Supreme Court says in order to constitute a lease, it is necessary that the lessor transfers his right to use to the lessee. Now, if a lease has been entered into and the lessor, which is the government, has transferred its rights to the lessee, all its rights as per the Supreme Court go with that transfer. Now, once that transfer has taken place, where is the question of the government performing any other service or act of supply thereafter? So therefore, that's also one of the grounds which have been taken in the petition which is pending in the Supreme Court, that sir, once you have allowed your rights as the government to be divested into a lessee, there is no question of further supplying any service or any supply, and therefore this you cannot therefore create a service in the air or an act of supply in the air. That's one of the submissions which we are raising in the Supreme Court. But given that this was already there before the Supreme Court, they quietly kept, I won't say that. No, but actually in fairness, the Supreme Court was not called upon to answer this specific question in that case. No, so that case which you are referring to is still pending in the Supreme Court. They were about to, so they had actually directed that those sets of matters would be taken up immediately after this judgment. No, so the judgment of the Supreme Court in this case was frankly not called upon to answer this question. That question is still pending and it will be answered very soon, I think in the next 5 or 6 months.
Sir, can I put a question?
Sir, certainly.
With this mining Supreme Court decision, what would be the tax liability in transport vehicles involved into, and what would be the rate thereof?
Sir, insofar as I started by saying, what all does mining involve? What all does mining involve, sir? Mining involves, let's start from the beginning. Mining involves survey to start with, then you will have excavations, then you will have demolition, then you will have earth moving services, and then you will have handling of minerals and transportation. Those are pure services. They are all captured by the Service Accounting Code, Chapter 99. And whatever is the head in which you will fall, and therefore they were taxable even prior to GST as services under the Finance Act. So insofar as those services are concerned, they continue where they were, and really speaking, there is no loss caused to any SSE. In fact, they would gain, because earlier there were different, for example, you were selling something. You could not pass on the ITC related to sale to your service and from service to sale. Now, of course, there is portability in the sense that now that the taxable event is supply, so you get that benefit. The only problem is when you pay royalty, and that's a major chunk which people are paying. And you will end up paying 2 types of taxes. One which the state is levying as cess, and the other is what people are levying under GST. So that's the problem which we are facing, and that's the problem which actually needs to be addressed. The Supreme Court itself, according to me, has given the union government a way, which is to say you frame legislation in such a manner that you can stultify the powers of the state under entry 50, but it will need political, besides Karnataka, there are 3 other states who are planning the same thing. So that's the thing. It will all depend on the states. Yes, sir.
Supreme Court has allowed to levy the tax by the state government as per entry 49 and 50.
Yes.
Right, sir?
Right, sir.
But the GST has been listed at serial number in the second schedule list 2. तो what मतलब ये जो एंट्री 54 में जीएसटी के बारे में है, जिसके बारे में कोई क्लियर जजमेंट नहीं कहा गया है, तो कैन स्टेट गवर्नमेंट लेवी जीएसटी ऑन द बेसिस ऑफ दिस जजमेंट?
सर पहली बात तो ये कि लिस्ट 2 में जीएसटी का एंट्री नहीं है
सर। 54 पे है, इट इज
नहीं सर। एंट्री 54 जो ऑफ लिस्ट 2 जो है वो है टैक्स ऑन द सेल और परचेज ऑफ गुड्स।
हाँ।
उसमें वैट लगता था।
हाँ।
जीएसटी के लिए जैसे मैंने अभी आपको बताया,
जीएसटी फर्स्ट लिस्ट में
नहीं सर, ना फर्स्ट में है ना सेकंड में है। वो वही मैंने आपको शुरू किया था ना बताना सर। आप एक मिनट उसको फोन को छोड़ दीजिए, मैं आपको बताता हूँ। आप आई थिंक इंटरनेट से देख रहे हैं।
नहीं, मैं इट हैज बीन लिस्टेड। जब
आप,
मैंने टॉपिक देखा था तो मैं नोट करके लाया था कि मैं क्लैरिफाई करूंगा इसको।
मैं आपको एक मिनट अगर आप मुझे दें, मैं आपको बताता हूँ। तो जो 2017 के पहले की रेजीम थी, वहाँ पे लिस्ट 1 और लिस्ट 2 थी। उस टाइम जीएसटी नहीं था, तो वो आपको दोनों लिस्ट में नहीं मिलेगा। 2017 में जब आर्टिकल 246 एक नया आर्टिकल लाए कॉन्स्टिट्यूशन में, क्योंकि क्या है कि लिस्ट जो है वो एक फील्ड ऑफ लेजिस्लेशन है और जो आर्टिकल्स हैं वो सोर्स ऑफ पावर है। तो जो मदर बोर्ड है वो आर्टिकल 245 एंड 246 था, और उसके साथ फील्ड ऑफ लेजिस्लेशन था जो एंट्रीज में था कि सेल्स टैक्स कहाँ लगेगा, एंट्री टैक्स कहाँ लगेगा। अब जो है एक नया मदर बोर्ड क्रिएट किया गया है विच इज़ कॉल्ड 246A, और जो स्टेट और सेंटर का पावर दोनों वहाँ एनलिस्ट किया गया है। और ये कहा गया है कि सेंटर एंड स्टेट दोनों के पास साइमल्टेनियस पावर है जीएसटी लगाने का, बट सेंटर के पास सिर्फ पावर है इंटर स्टेट ट्रांजैक्शंस में जीएसटी लगाने का, तभी वो आईजीएसटी। तो इसलिए 3 लेजिस्लेशंस हो गए, सीजीएसटी एंड एसजीएसटी एंड आईजीएसटी। तो वो एंट्री 54 जो है वो सेल का है, वो अब रिडंडेंट हो गया है, एक्सेप्ट फॉर दो 6 गुड्स जो पेट्रोलियम गुड्स हैं जो अभी उसके अंदर आते हैं, अदरवाइज इट्स आउट ऑफ द सिस्टम। ये है करेक्ट पोजीशन मेरे अंडरस्टैंडिंग में।
थैंक यू।
Please don't ask me difficult questions.
I'm not that knowledgeable, no intellect. My question would be very basic.
Sure.
And it is on a practical ground that I'm facing.
Sure.
With this cloud still there, post Supreme Court, and we are waiting for the decision, there has been a persisting matter on the rate of tax to be paid under RCM, especially in supply of lease for coarse sand, balu, morang, which attracts 18% if it's a service on reverse charge and 5% on forward charge. This matter is sub judice at the Supreme Court as well, Joginder Singh versus
Correct. That's the same matter which I am referring to.
And we've been taking shelter of that in various other cases subsequently. But out of the discussion we had today, I am probably of the understanding that I should stop paying RCM at all until this cloud gets removed. Am I right, or you want to add something? Should I repeat?
No, I have followed your question, but I don't want to hazard a guess for 2 reasons. One, the matter is pending in the Supreme Court, and my answer one way or the other would not be the correct position depending on what the Supreme Court decides. Number 2, I don't want to hazard a guess on a hunch. I will have to look at that situation before I answer it one way or the other, because we are not in the business of answering specific queries relating to a case, because ultimately it's an advice which you may act on, and therefore I don't want to, on pure law I can talk about, but I don't want to talk on a case specific situation, because it's not correct to do that without reflecting on the matter a little deeply.
This is a matter at the national level across all states.
I understand.
Wherein हम 18 देना बंद कर दे या देना शुरू कर दे, वरना लिटिगेशन से 18 की डिमांड हो रही है, और सर 5% की आउटवर्ड सप्लाई है। हाँ, आई एम जस्ट एडिंग टू इट, आई एम मेकिंग इट जनरलाइज, नॉट टू ए स्पेसिफिक केस। सर हम 5% दे रहे हैं, 18 का इनपुट मिलेगा, इन्वर्टेड का कोई इशू नहीं आएगा क्योंकि सप्लाई की वैल्यू बहुत ज़्यादा है। इशू ये आएगा, हम अभी आरसीएम नहीं देते,
1 साल 2 साल बाद जब कभी ये मैटर जो सब जुडिस है डिसाइड होगा, तब तक मेरी लीज खत्म हो जाएगी। और अगर हमारे अगेंस्ट ये डिसीजन आया, सर हम 18 देके करेंगे क्या? इनपुट मिल जाएगा विद द क्लैरिफिकेटरी सर्कुलर गिवन, you pay the tax, claim RCM, pay RCM, claim ITC, pay interest for the period that you have defaulted, but what will I do with it?
See,
and then get into the glitch of refund.
See,
if I'm wrong, please.
I'm not sort of a tax consultant in that sense where I should give you case-specific advice, but I'll tell you something which I tell all my clients or all the juniors who come to me for advice on tax matters, that if you want to fight, please fight after paying your taxes and pay taxes under protest for a very simple reason. Because in my 35 years of experience in law, I have seen very, very good cases where the amount, the principal was say 5 crores, and by the time the litigation got over, interest and penalty went to 25 crores and the company went down. So I've always advised my clients that please don't bank on these stays until and unless it is absolutely necessary for you. It's better to pay your taxes under protest, make provision for it in your balance sheet and contest it. If you succeed, you succeed. Otherwise, this business of taking a stay and waiting for 5-7 years is something which is detrimental for most companies. I mean, I don't personally subscribe to it.
Sir, this pertains to the cases which have occurred in the past. आज की तारीख में हम यही राय दे रहे हैं.
Right.
आप 18 दे दो.
Right.
Avoid करो litigation. Like your state shouldn't do that problem.
Right.
And then consume it towards your outward supply. The matter gets over.
Absolutely.
But then that becomes a kind of a precedence to decide by the authority in future. आप आज दे रहे थे तो पीछे क्यों नहीं दिया? And so on.
See, the thing is, पीछे क्यों नहीं दे रहे थे? पीछे कितनी जाएंगे? कितने साल पीछे जा सकते हैं? 5, no? If it's a case of, no, they may call it anything. See, no, it's like this. There is, I mean, you have to proceed on the assumption that this is the law. If somebody tries to overreach the law, you can't do anything about it, you have to fight it out in court. But the question which he's asking me is, what do you do at this stage? So essentially what you're asking a lawyer is to take a judgment call. That judgment call, unfortunately, in our Indian setup, in our Indian judicial setup, is a very difficult call to take because it will depend on judge to judge of how he perceives things. So therefore, the call which has to be taken by each client really is not a legal call, but a commercial call. I mean, that's the way I would put it. Certainly, sir, certainly. Sir, they want a mic.
Samir Bhai's question was very actually interesting because this is what the states are currently doing. You said right from the time survey, lease, maybe a sublease, extract or mineral, call it by whatever, move. So this has goods, this has service. Imagine if this contract is only to one man. Now, only one man gets this contract, right?
Which
of
contract?
mining contract.
Mining
one man
contract.
gets
Okay,
it. One man.
okay,
So he
okay.
extracts, he moves. Now what the state is saying, while the ore can be 5, the man says this service is 18. Now here they don't want to go by the composite contract, saying the principal contract is extraction and the incidental contract is service. They don't want to go by that, which means the rate will be 5.
No, but the point is now that the taxable event is changed to supply, that distinction between a sale or a service is gone.
No, they're adding everything and saying on the whole of these things you pay 18%. This is the problem we have in Karnataka. I don't know about other states.
That will depend
Itna
on...
bada notice aa raha hai.
No, see the point is, I mean, the oldest tax.
Close this litigation.
The oldest taxing joke is that when your child is wanting an ice cream, you take a scoop out of that. That will teach him how to give 30% to the government. And now, sort of, the latest joke is that take the entire ice cream and give him the cone, because this is what the governments are doing now. Taking away all your... So the point is, how the officers are administering the law is very different from how the law is. I mean, just as a side, I'll tell you, till about 2 years back, in financial crimes, the Supreme Court and the High Courts were coming down very heavily on courts which were granting bail, to say that these are cases which are worse than murder. But in the past 1.5 years, the trend has changed to say that no, bail is the rule and jail is not. So these ups and downs in thinking, in judicial thinking, also takes place insofar as tax laws are concerned. There was a time when there were a number of judgments which came in favor of the assessees, which were in favor of an environment towards, transparency and ease of doing business. Then there came a stage where courts started saying that even legitimate tax planning was tax evasion. So these are, moments which come like blips, 5-year periods. So we don't know what the next blip will be in terms of taxation law. And the question which is being put to me is a very pertinent question, and this is something which many people are grappling with, but unfortunately, if you give advice based on your understanding of the law and a court thinks otherwise, the party goes down the drain immediately. That's the problem.
हेलो हाँ, जैसे सर ने पूछा, हमारे रीजन में भी जूनागढ़, पोरबंदर, अमरेली बिल्डिंग लाइमस्टोन की लीज है, क्वारी लीज है सब। तो इसमें रॉयल्टी के पेमेंट के ऊपर जो आरसीएम बना है जीएसटी में, सेंट्रल जीएसटी एज वेल एज स्टेट जीएसटी दोनों ने नोटिस दे रखी है। 74 में नोटिस इश्यू की है फ्रॉम 2017-18। 16 से हमारे हियरिंग शुरू हो रहे हैं। We have already replied. Personal hearing are starting from Monday. Then what should we do?
अभी मैंने साहब को वही आंसर दिया।
So that आपको 9 जज की बेंच बिठानी पड़ी है डिसाइड करने के लिए, और हमसे अपेक्षा करो।
नहीं, but on a serious note, whether section 74 is applicable or not is not an answer which is generic to everybody. That will depend on the facts of each case. अगर आपने इस चीज़ को शुरू दिन से कॉन्टेस्ट किया, फर्ज कर लीजिए, एंड डिपार्टमेंट इज़ अवेयर ऑफ द सिचुएशन कि भाई आप उनसे कॉरेस्पॉन्डेंस कर रहे हैं बैक एंड फोर्थ, और 4 साल बाद आपको नोटिस देते हैं 74 का, इट्स ऑब्वियसली नॉट अ केस ऑफ 74 बिकॉज you've engaged with the department in conversation and they are aware that this is a dispute of interpretation versus a case where you may hide facts from the department on a certain issue. So ये इसका generic response नहीं हो सकता कि 74 का केस है कि नहीं. That will depend on a case to case basis. But ये पक्का है that 74 का केस department officers at the first level may invoke. But if it's a genuine dispute on interpretation, 74 will not be invoked and it will not be sustained in a higher court. So once you start reaching the levels of the tribunal and the High Court and the Supreme Court, those issues are then dealt with there and you can expect an ultimate relief there. Because I have yet to come across a case जहाँ पे आपको adjudicating authority ने छोड़ दिया unless there are reasons otherwise. And जहाँ पे भी छोड़ दिया होता है, वहाँ पे there is a committee of commissioners which will tell them that you file an appeal against your own order. So वो एक प्रॉब्लम आता है फर्स्ट 2 लेवल्स पे, बट दैट्स अ प्रॉब्लम विच इज़ पैन इंडिया, दैट इज़ नॉट अ प्रॉब्लम विच इज़ रिस्ट्रिक्टेड टू योर पार्ट ऑफ द स्टेट, और उसका रेड्रेसल इज ओनली इफेक्टिवली ओनली एट द ट्राइब्यूनल लेवल, ट्राइब्यूनल एंड हाई कोर्ट एंड सुप्रीम कोर्ट.
Thank you, sir.
Thank you so much.
Thank you so much, sir. In spite of this being the last session, I'm sure it is the most interactive session throughout the day, sir. Thank you so much for your time. So by this we are ending up the today's technical sessions. I would just like to appraise all of you that at 7 o'clock we have a folk dance program at the MP Theatre downward. And then at 8 o'clock, we have a musical evening followed by dinner at the lawn at the backside of the venue. Thank you so much. See you all tomorrow. Thank you.
सर वो ग्रुप में डाला ना. Well, all NEC members are requested to be there in 10 minutes on the first floor, Zira Hall. NEC meeting is on the first floor. मैंने पहले बोल